Good morning, everyone, and welcome to the December 3rd County Planning Commission hearing. I am Kate Ford, the Chair of the County Planning Commission. Please stand and face the flag for the Pledge of Allegiance. Salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Villalobos, could you please continue with the information about the TV coverage, followed by the roll call?
Yes, thank you, Madam Chair, and good morning to the Commission. Planning Commission hearings are televised live on County of Santa Barbara Television, CSB TV, Channel 20 at 9 a.m. in the South Coast, Lompoc, Salinas Valley, and Orchid areas. Rebroadcast of Planning Commission hearings are on Fridays at 5 p.m. on CSB TV, Channel 20, and the hearing will be available for download in a day or two. The county's broadcast will also be, the hearing will also be broadcast on the county's website as well as the county's YouTube channel. Moving on to the roll call, Commissioner Cooney.
Here.
Commissioner Park,
Ready to go.
Commissioner Reed,
Here.
and Chair Ford.
Here.
And Commissioner Martinez will be joining us in just a few minutes.
Thank you very much. Now, Mr. Wilson, will you continue with the status report and then follow up with the projection report, please?
Thank you, Madam Chair and Commissioners. Looking at the status of our agenda today, we have one item on our consent calendar, and then on our standard agenda, we have 4 items. The first 2 is an appeal, the Peterson appeal of residences in the eastern Goleta Valley. It's my understanding the appellant and applicants are here on those items as well as staff to present on those today. And then we have item 3, which will be before lunch, will be the general zoning ordinance amendment package, and staff is ready to present on that as well. Following lunch, as indicated on the agenda, we will not begin the workshop on the rec master plan, ordinance amendments and comprehensive plan amendments until after 1:30. So no sooner than 1:30 will we begin that item. And staff's ready to present on that item as well. And then I can move to the projection report, Madam Chair.
Please.
Today will be our last official hearing for the County Planning Commission. As we had earlier canceled the December 10th hearing. And so one item on the projection report that I just want to indicate for the commission to put on their calendars, if not so already, is on December 17th. There'll be a Planning Commission holiday luncheon that will begin at 11:30 a.m. And go till 1:30 p.m. And Mr. Villalobos or Ms. Tanya Crandall will be sending that information out if you haven't already received it. You should have sent an email already. Okay. And that's on December 17th at 11:30 a.m. Looking at next year, there are no items projected for January 14th, and so that would push our next hearing to January 28th, where we do have one item, an appeal on that day. I'm talking to Division Manager Mr. Seawards. It's not likely that we will have anything on January 14th, unless there's any items from today that is continued to January 14th. So as of right now, there are no items on that one are anticipated. So we would be reconvening after January 28th, barring any continuance today.
Thank you very much. Please, Mr. Reed.
Oh, I do have a question about our meeting on February 4th, which would be the week following January 28th. I have a obligation. I have a board meeting board meetings for both of our ranches those days, and I lead one of them. So it would not be possible for me to make February 4th. So if we could look at keeping the agenda open and perhaps, I don't know what you would do in that category. It'd be more convenient to me and sensible to just cancel that meeting. But I just wanted to put that out there now so you might be aware of it.
So Madam Chair and Commissioners, thank you for that indication. We can note that Commissioner Reed will not be available that day. If there are items projected for that, and if there's anything in your district, we can either reschedule them so that you can be present. If there are no items, we can cancel it. But as of right now, we would just note that Commissioner Reed would not be available at that hearing.
Thanks very much. On to public comments. Mr. Villalobos, are there any requests for public testimony in person or even online on items that are not on today's agenda?
Madam Chair, I've received no speaker slips for this portion of the agenda, nor are there any attendees online.
Wonderful, thank you. Now we're on to the Planning Commissioner informational reports. I'd like to ask any of my colleagues who would like to announce or report on anything that is related to our work. Yes.
Yes, there is one thing. I attended a webinar from the, I'm not sure what the entity's called. It's UC Davis, and they have an agritourism group there. And this was on the new SB 518 law that was passed and signed by Governor Newsom. It relates to our ag enterprise ordinance. It's all about an exception to the state law on the requirements for a campground and for what they call low-impact camping, which is sites of 9 or less and certain other things. You don't have to observe all those things. It makes it easier in terms of the infrastructure that needs to be installed. Our ordinance, the AEO, was set up to accommodate that law, figuring it would be passed. Now that it is passed, we need to kind of trigger our provisions of our ordinance that implement it. And according to what I learned at this webinar, all that takes is a notice to the state. It doesn't take a revision of our ordinance. So I would hope that that's something our staff could take a look at, and I'm glad to talk to you all about it so we can initiate the provisions of our AEO that take advantage of it. They're important. Thanks.
Thank you. Let's move on to item number 8 now. It is time for us to consider the minutes from October 29th, 2025 and November 5th, 2025. First of all, are there any edits? Mr. Cooney.
No edits, Madam Chair. Reviewed both sets of minutes, and I'd like to move approval of both.
Do we have a second?
I'll second.
Thank you, Mr. Reed. Shall we go with the roll call, please?
Sure. Commissioner Cooney,
Aye.
Commissioner Park,
Aye?
Commissioner Reed,
Aye.
Commissioner Martinez.
I'll have to abstain since I wasn't at the November 5th meeting.
Great. Chair Ford.
Aye.
Motion passes 401.
I wonder if we have a director's report today?
Madam
Mr.
Chair,
Wilson?
yes, we do. Director Plowman will be here shortly.
Okay. Shall we wait?
We can move to the consent item, and then when Director Plowman arrives,
Thank you.
we'll
I'll
bring
do
it back
that
up.
then. Okay, we have one item on the consent agenda, the trail easement, quitclaim, government code conformity determination in Summerlin. So, Mr. Villalobos, could you please read the item into the record?
Yes, thank you, Madam Chair. The following is a hearing on the request of James Cleary, agent for Real Property Division General Services, to consider case number 25 GOV 11, application filed on October 28, 2025, for a determination that the quitclaim of a portion of an existing county trail easement conforms with the comprehensive plan of the County of Santa Barbara pursuant to California Government Code Section 65402A.
Thank you. As a reminder, consent items are projects that do not require presentations, reports, or extensive public comment. So, colleagues, do any of you want to pull this item from the consent agenda? Mr. Park?
I have a preliminary question. I had some conversations with some CRATAC representatives about this. If there's somebody here from CRATAC that wants to speak to this today, either online or in the audience, I would ask to pull it from the consent agenda. If there is not anyone here from CRATAC that wants to speak to this, I'd rather just leave it on the consent agenda. Is there anyone here from CRATAC? Anybody online, Mr. Villalobos? Okay, well then, I won't pull it. Thank you.
Thank you. And are there any public comments on this one?
Seeing no one rise, I have no speaker slips, and there's no members online.
Thank you. So it would be time now for us to call for a motion to approve item C1. Do I have a motion?
Move to approve our consent agenda?
I'll second the motion.
The motion has been made and seconded. I'd like a roll call, please.
Commissioner Cooney,
Aye.
Commissioner Park,
Aye.
Commissioner Reed,
Aye.
Commissioner Martinez,
Aye.
Chair Ford.
Aye.
Motion passes 5-0.
Thank you. And now I'd like to ask Director Plowman to please continue with your report and hearing summary.
Good morning, Madam Chair, members of the Commission. I have a brief report this morning. We haven't had a lot of items at the board of late, but we will in December. One item that I wanted to report on was that the Coastal Commission took action on the housing element rezones that were in the coastal zone. They unanimously supported it. They did make 2 modifications that I think are important to acknowledge, and that was they increased the requirement for affordability, levels of affordability on the rezone sites in the coastal zone in the Carpinteria area. And that went from what we expected was going to be about 20% up to 32%. And that was a cooperative effort between county staff, Coastal Commission staff, and the property owners. And then they also required that all of the units remain in affordability for the lifetime of the project. It's what we try to achieve anyway. We have a 90-year term that goes with our affordable units, but this just ensures that as long as that project is in existence, those units will remain in an affordable status. So that was a positive result for us. We weren't sure that was going to happen, and so I was very pleased. And we will be going back to the Board of Supervisors the first meeting in February for them to accept the modifications from the Coastal Commission and move that step forward. And that will be sort of that final action in our housing element update. We have a number of items that are going to be at the board over the next 2 board hearings in December. They only have 2. We have our fee ordinance update. So as I mentioned previously to the commission, the department has been in the process of essentially doing a significant review and overhaul of the current fee structure in the department, which means, the permit fees that get paid by people, our hourly rates, that kind of thing. And so our first hearing is on the 9th at the board, so there'll be a presentation to the board, and then on the 16th is the second reading of that ordinance. Short story is that because of the costs that have increased in the department, we haven't updated our fee ordinance since 2017 when we first went full cost recovery per the board's direction. So this is a pretty significant update. We're really simplifying the building fee structure because it was quite complicated and I think difficult for people to interpret. We are increasing some of our fees to make sure that we are full cost recovery, and we've had some areas where we have changed projects to fixed fees or reduced deposits where we've seen efficiencies and we don't need to collect as much money or charge as much money. So it's sort of a mix of things, but overall, the fees are going to be increased, mostly in the building division, where we've been falling short, and particularly in inspections. So if you're interested in that, I recommend listening to that hearing and following it. We also have the appeal of the decision by the Commission on the Mission IV project, the housing project, and that was continued to the 9th, and so that'll be heard by the board. And then we have the streamlining and housing ordinance package that the Commission took action on. That's going on the 16th. And then we are returning to the board with findings for denial for the transfer of ownership of the Exxon facilities to Sable. And that's all I have to report. I'm happy to answer any questions.
For that last item, is it on December 9th also?
16th.
Oh, sorry.
Sable is on the 16th.
Thank you. Mr. Park?
Oh, there you go. On the fees, does that include park fees? Parks?
No, this is only planning and development related fees.
Okay.
Yeah, they're not development impact fees. there are permit fees. So what we charge applicants when they come to request a permit.
Now, I had a question on your first item. What was the first item again? I forgot.
The Coastal Commission?
The what?
The Coastal Commission decision on
Yeah,
the?
oh, yes.
Yes.
How many units extra units for affordable do we get out of that change in the percentage?
I'd have to go back and look at the unit counts. But
Wasn't that project about 180 units total?
the one at Baylord is. The other ones we don't have projects on yet. They're not submitted, but Baylord, so, 30% of that is,
So it might be another 15-plus units?
yeah.
Okay, I just know we were tight on our RETA numbers for the South Coast, so we got 15 more affordables.
It's a good thing.
It's a really good thing.
Yeah.
Yeah, because if some of these others don't get built, then we're kind of back in the RETA process a lot quicker than we would want to be.
Right.
And that'll be like money in the bank. Yeah, thanks.
Thank you. And Mr. Cooney?
Sorry. My question was answered.
Great, thank you. Thank you, Director Plowman. Thank you. That moves us on to the standard agenda, and we will have 4 today. As Mr. Wilson said, I want to let you know that item number 4, the Recreation Master Plan Workshop, will begin no sooner than 1:30 p.m. So with that, Mr. Villalobos, will you please read hearing item number 1 into the record?
Yes, thank you, Madam Chair. The following is a hearing on the request of Michelle Peterson, appellant, to consider case numbers 23 APL 37, which is to consider the appeal of the director's approval of the Laurel Springs Retreat LLC new single-family residence project case number 21 LUP 197, and to determine the project is exempt from CEQA pursuant to Section 15183 of the state guidelines for implementation of the California Environmental Quality Act.
Thanks very much. First, may I ask for any ex parte reports from my colleagues on the commission? Mr. Martinez, please.
Yes, I had a Zoom conference with Attorney Amy Steinfeld, and I'm forgetting the gentleman's name, but he's sitting right next to the right of her right now. And it was a Zoom conference which we discussed the project itself. Thank you.
Thank you. Any others? Mr. Reed, please.
Yes, I had a video conference with Amy Steinfeld, attorney for the applicant, as well as Josh Copland, but that was on November 18th, prior to the time I'd actually received any of the hearing materials.
Thank you. Mr. Cooney?
Yes, thank you, Madam Chair. I had the same experience, video conferencing with attorneys for the parties to this item, Amy Steinfeld and Mark Shatillo. Mark was representing the opponents to this project, and Amy was representing the proponents.
Thank you. Mr. Park?
I attended a site visit with Josh Kaplan and Amy Steinfeld and one of my puppies on last Tuesday. And then I had a meeting with Mr. Chatillo this Monday, and miscellaneous phone calls kind of setting up those things.
Thank you very much. And I'll report that I met with Amy Steinfeld representing the applicant, and we met at the site of the 2 projects, and she explained them as they are presented here today. I also met on Zoom with Mark Chichillo, who's representing the appellant, and he shared the appellant's perspective, point of view, and concerns, all produced in the documents that we have in front of us today. Seeing none of, Mr. Cooney?
Slow reaction.
No problem. Let's continue with the staff presentation. Please introduce yourself, and I'm hopeful that 15 minutes will suffice.
Good morning, Ms. Chair and Commissioners. My name is Veronica King, here to present the Peterson appeal of the Laurel Springs Retreat LLC new single-family residence. This map highlights the project site in red. The parcel is located within the Painted Cave community in the Eastern Glida Valley Community Plan area. The lot is approximately 0.23 acres and is currently vacant. The appellant, Michelle Peterson, owns the property to the southeast, which is outlined in blue. Here's the site plan. The parcel is zoned residential ranchette, a zone that specifically allows for the development of a single-family residence. This project proposes the construction of a 3,185 square foot residence, which is shown in yellow, with a 463 square foot garage shown in orange. There's a water tank for fire protection, shown in blue. A stone wall and wood fence are outlined in purple along the property boundary. The project also includes 3,445 square feet of habitat restoration plantings, shown with green hatching, which exceeds the required 2-to-1 ratio for replacement plantings. Here are elevations of the residence. The east is the upper left, the upper right is the street view, and the lower image is the south elevation. The design uses fire-resistant materials, like metal roofing and stone, with earth tone colors and natural finishes that blend with the rural surroundings. The land use permit was approved in 2023, shortly after an appeal was filed challenging the approval, which brings us to today's presentation. There are 8 appeal issues, which I will address in the order outlined in the staff report. In the first appeal issue, the appellant claims the project description is incomplete because the wall and fence are not shown, raising concerns about impacts to oak trees and sensitive plants, and arguing the walls are out of character with the community. However, the project description is comprehensive, with all components, including the stone wall and wood fence, clearly depicted on the plans and fully evaluated in the biological analysis. Perimeter walls and fences exist throughout the community, are permitted in the zone district, and use natural wood and stone materials appropriate to the community character. For the second appeal issue, the appellant argues that the landscaping conflicts with County Fire's defensible space requirements and that the project lacks adequate stormwater management. However, County Fire has reviewed and approved the landscaping plan, confirming full compliance with all state and local defensible space and vegetation management standards. Regarding stormwater, the site is not required to prepare a Tier 1 stormwater control plan. However, the project incorporates robust drainage measures, including on-site retention ponds, permeable surfaces, and roof runoff capture for irrigation, all of which must be approved by a grading inspector at the building permit stage. For appeal issue 3, the appellant argues that the project description ignores its relationship to the Laurel Springs Ranch and claims the site has historically served as informal open space for the community. However, the parcel is privately owned, contains no public recreational or open space rights, and is not part of the ranch. Any informal use by neighbors is not relevant to the project's approval. In the next issue, the appellant claims the applicant illegally graded the site, impacted native habitat, and that the baseline surveys reflect a degraded condition. However, these claims are inaccurate. Following a 2024 complaint, the county grading inspector inspected the site and determined that no violation occurred. The soil movement consisted only of septic feasibility test pits, which are routine and not defined as grading under county code. Furthermore, environmental surveys were completed in November of 2022 prior to any soil testing and accurately documented the existing habitat and site conditions at that time. For the fifth appeal issue, the appellant claims that the use of propane is dangerous and that electrical alternatives should be installed instead. However, propane use is both legal and common in rural areas like Painted Cave, including by the appellant. The proposed underground tank has been reviewed and approved by County Fire, meeting all applicable safety standards. Additionally, there are no policies or development standards that prohibit propane use or mandate electrical alternatives. In the next appeal issue, the appellant asserts the project may cause sediment runoff and requests upfront erosion control plans, as well as a Chumash monitor during construction. However, the appellant did not substantiate claims regarding runoff. The project incorporates long-term stormwater control, and an erosion and sediment control plan is required prior to land use permit issuance. Regarding cultural resources, a Phase 1 archaeological report found no archaeological resources on or nearby the site, so Native American monitoring is not required or standard. In addition, conditions require work to stop in the unexpected event that resources are discovered. For the seventh appeal issue, the appellant argues the project is discretionary and requires further CEQA review due to biological resources, fire hazards, evacuation risks, groundwater concerns, and project size. However, the project qualifies for CEQA Section 15183 and does not require additional CEQA review. In addition, the project includes a habitat restoration plan that restores biological resources at a greater than 2-to-1 ratio. County Fire and Transportation found no access or evacuation issues. The water company confirmed adequate water supply, and the home size is consistent with other residences in Painted Cave. Lastly, the appellant asserts that the project is inconsistent with the general plan, but does not cite any specific inconsistency. As discussed in detail in the staff report, the project is consistent with the comprehensive plan, including the Eastern Galita Valley Community Plan. This project is for development of a single-family residence on a lot zoned for single-family uses. The community plan and its EIR anticipated this exact type of development. Under CEQA Section 15183, when a project fits the plan's policies and density, no additional environmental review is required. This project matches the zone's density, meets all applicable policies and development standards, and has no new or unusual impacts. Therefore, this CEQA section applies. In summary, the project is for one single-family dwelling that is consistent with the comprehensive plan, including its community plan. It complies with all development standards, including height, setbacks, density, and it has adequate services. The project does not require further environmental review under CEQA pursuant to Section 15183, and all appeal issues have been thoroughly evaluated and found to be without merit. Staff recommends that your commission deny the appeal, make the required findings to approve the project, determine the project is exempt and no further environmental review is required pursuant to CEQA Section 15183, and grant approval of the land use permit. Before I conclude my presentation, I wanted to acknowledge that we received a new 18-page letter from the appellant. There are a few points we would like to address from the letter. With regard to fire safety, we met with Fire Captain Chris Olmstead to review the letter on Monday. The applicant is proposing to implement additional fuel clearance around the propane tanks. With that, Captain Olmstead confirmed that the project is compliant with all applicable fuel management, access, and fire protection requirements. No off-site fuel clearance or road widening is required for this project. With regard to new legislation and other guidance documents identified by the appellant, we confirmed with long-range planning staff that these do not establish new policies or thresholds applicable to this project. With regard to CEQA, there are no new project-specific significant impacts. The EIR already identifies area-wide significant impacts under wildfire, emergency response, and fire protection. Fire danger is a known concern for the area, but a single-family home does not result in a new significant impact in that regard. The concerns expressed regarding biological resources appear to primarily be based on old information. We can confirm that the currently proposed habitat restoration exceeds the 2-to-1 replacement ratio for environmentally sensitive habitat. and that tree replacement criteria are met. Lastly, the appellant cites outdated square footage numbers for the home in his letter. The home is actually 3,185 square feet, not 3,971 square feet. That concludes my presentation. I'm available to answer any questions. Additionally, Mark De La Garza, the project biologist, is here to assist with technical inquiries.
Thank you very much. Are there any clarifying questions on the staff report from my colleagues, please? Mr. Reed?
Yeah, well, thank you for your, I was going to ask about the fire department and if they approved all the items, the latest the standards for plants and clearance and even the ones reflected in this letter we got at the last minute from Mr. Chitillo. So thank you for exploring that. I appreciate that. One item that comes out that was mentioned in a petition and some other things are ADUs, which I could not find in this project description. Are ADUs a part of the current project, or do they go away?
Commissioner Reed, ADUs are not proposed with this project currently.
Okay, thank you. Second, well, another question. In the report, I mean, it was stated that there, and in the response to the appeal, there was no soil stockpiling conducted. The only soil removal had been for, percolation tests or something?
Commissioner Reed, that's correct. It's routine and standard for septic feasibility test pits.
Right, yet I find in the biological report from Watershed Bio back in 2022, on page 20, there's a photo of a pretty significant, looks like soil berm, and it says it's a soil stockpile on lot 10. It looks a lot bigger than what you'd excavate for a percolation test.
Chair and Commissioner Reed, the county grading inspector did go out to the site. The county grading inspector would be the expert on grading quantities and the types of activities that would require a grading permit or a zoning permit. And he did visit the site and determined that soil that you saw in that photo associated with the test pits did not constitute a violation.
Okay.
But I do also think that part of the point of that argument was that somehow the baseline studies wouldn't have analyzed the biological conditions prior to that taking place. And the biological surveys occurred in 2022 prior to those stockpile activities occurring, their
Okay,
grading
well,
activities occurring.
Okay, well, just with respect to a stockpile, it was on my ranch. I piled up some dirt. I think it was no big deal, but it piqued my interest because the report said no stockpiles, yet there was an image of one. So thank you. Another question I had, because I know the Santa Barbara honeysuckle has come up. And I think in the plan it said, there are 12, 5 would be removed, but I also noticed in the landscape plan, they're going to plant 9 on each of the lots of the Santa Barbara honeysuckle. So wouldn't you contend that that is more than adequate in replacing the few that would be lost?
Commissioner Reed, we have policies that require rare plants like a Santa Barbara honeysuckle to be replaced at a 3-to-1 ratio. This project meets and in certain areas may exceed that. I believe if we're talking between the 2 lots, which I don't know we should be doing here, but each lot individually will meet that replacement ratio on its own. And that's all.
Okay, another question I had. One of the items I saw in Mr. Chitillo's letter submitted late on Monday, but I read them all the way to the back, was a chart, a table indicating all the lots less than a half acre and the sizes of the homes in the Painted Cave area. How many total lots are there in Painted Cave area?
Commissioner Reed, I don't know the answer to that, but I can look into it.
Okay, well, since this, my question is because this table that was submitted shows, the homes in those areas and indicates that, they're all rather modest, most of them, or many of them below 1,000 square feet, including the 2 lots adjacent to these proposed developments. I was just wondering, since your staff report says there are also homes that are up to 5,000 square feet, what percentage of that there are, in that area? And are houses of these sizes clearly atypical? Certainly they're out of character with the immediately adjacent properties, but overall, how different are those sizes?
Commissioner Reed, can you repeat the exact question so I can
Okay.
respond well?
Okay. So how many houses are there? You say houses up to 5,000 square feet. These houses are going to be, 2,800 and 3,800 square feet. If you look at the overall percentage of homes in that area, where do they fall? On the extreme, or in the middle?
Commissioner Reed, these homes fall within the range of homes in Painted Cave. Perhaps they are larger than the homes directly adjacent. However, they meet all development standards and community plan policies, comprehensive plan policies, including ordinance standards such as height and setbacks, lot coverage. So perhaps they are on the larger side, but they're well within the range of homes you'll find in Painted Cave. There's a pretty wide range, as you saw in my staff report.
Yeah, Chair and Commissioner Reed, I think in some neighborhoods like Summerlin, community plan areas like Summerlin and Montecito, there's required floor area ratio requirements. There's no required floor area ratio requirement for this neighborhood. And a pattern that we see throughout the county is that as new development comes in or as lots get redeveloped, the homes are larger. The homes in this area, those 1,000 square foot homes, are probably quite undersized compared to a modern home. And so this home falls within the range of homes within the neighborhood. And there's no standard requirement that the county has wherein we could limit the square footage that they're proposing. Our only determination is neighborhood compatibility, which involves all sorts of factors, including mass, bulk, and scale, the way the home is designed to fit the site, not just square footage. And so our review of this project, we found that within all of those factors, the home design, the materials, architectural design, that it would be compatible with the neighborhood.
Okay. And then
Commissioner
final
Reed,
question.
if I could add to it, and I might have staff verify it, because based on discussion yesterday, I do not think that table also represents all of the parcels in Painted Cave. Is that correct?
No, it does not. I can
Right,
tell you
okay.
that.
So it's a partial list of homes and their sizes. So staff has looked at a broader, the internet's saying about 100 homes. I would have to do some digging to figure out how many lots there are, but our analysis says that it is within the existing range of what is built out there.
Well, I fully understand it's only a partial
Yeah.
list, and nor would I expect Mr. Chitillo to submit a list that has data on it counter to the position he supports. So I was just trying to get an idea of how big a piece of the pie it actually represents. Final question this time. I also saw an assertion that there had been some representation made that these 2 parcels were going to be available to residents for recreational use, whatever, in perpetuity, or just an assertion to that effect. Did you find any evidence of any rights of way, anything printed, anything to really support that? I know everybody hates to see the last lot in the neighborhood go, but I was just wondering if you found anything concrete to support that position.
Commissioner Reed, no, we did not. These are privately owned parcels.
Okay, thank you.
Mr. Park.
I had a few questions. One about ADUs. We see that there's no plans for ADUs. Is there anything that prohibits ADUs in the future on these lots?
Commissioner Park, no, there is not. That's a possibility in the future. But it would have to be subject to all of our ordinance standards, just as any other ADU in the county.
Well, aren't these zones strictly for residential use, these lots?
Yes, this lot is zoned RR10, that's residential ranchette. That's for low-density residential development, so a single-family dwelling, which is the proposed project, is appropriate, and if they wanted to come in for an ADU in the future, that would be evaluated at the time.
But they wouldn't have to come in for an ADU under the county development standards, because if they came in for an ADU that's 800 feet or less, it'd be under the state development standards for, that apply to strictly residential zoning.
Our, Commissioner Park, our code, ADU code matches state requirements, so yeah, yep.
No, I'm very aware of it, but it's two types of ADUs, and one has Santa Barbara development standards, Santa Barbara County development standards. They're for larger ADUs, but where you have strictly residential zoning and you're under 800 feet, you've got the state standards, which limits what we can do.
I understand.
That was my question.
Yeah, our code has incorporated those state standards, so it's the same.
Okay.
Yeah.
Anyway, we can see ADUs in the future there, perhaps.
Yes.
I heard a comment about this architecture in these houses would be compatible with the neighborhood. And, it's something we could discuss, whether that's the case or not, factually. But I'm curious how that comes up. In a CUP case, we see finding, I think it's 2.1.5, and it's particularly addresses harmony with the neighborhood and uses the word compatible. I'm not aware of that application in this case, but staff used the word, so is there something in our ordinances or policies that requires compatibility?
Commissioner Park, yes, we have a number of policies. Two of those are in my staff report, the Land Use Element Visual Resource Policy 1 and 2, that discuss neighborhood compatibility, which is why I get into a discussion of that in my analysis in the staff report to demonstrate that it is consistent.
So even though this is an LUP case, we do have a compatibility standard to meet here.
Yes, the project is required to comply or be consistent with all of our visual resource policies contained within the comprehensive plan, as well as those specifically within the Eastern Goleta Valley Community Plan, which I also included a few of those policies in my staff report.
Okay.
Yeah, Chair, oh, sorry.
Go ahead.
Oh, Chair and Commissioner Park, I'll just read you an excerpt of one. So we don't have a approval finding that specifically relates to compatibility. We do have an approval finding that says that the project should be consistent with the comprehensive plan, including land use element policies. So this policy says that the height, scale, and design of structures shall be compatible with the character of the surrounding natural environment, except where technical requirements dictate otherwise.
Yeah, that makes sense. So that kind of imports a compatibility finding if we're
Yeah,
doing consistency. That's good to know.
It then goes on to say that it should be designed to follow natural contours of the landscape, those types of things.
On the size of this house, I've heard all sorts of different figures. It's a little confusing to me. I think that it boils down to, are people including the garage or not? And, if you shop for real estate, you're always seeing the same thing. If I say I have a 2,800 square foot house, does that include my garage or does it not include my garage? I think if I'm trying to sell it, I include it. If it's not, So when you say this one, I think you said it was 3,150 square feet. That doesn't include the garage, right?
That number does not include the garage. There is an attached 463 square foot garage.
That's what I recall. Finally, in my review of these materials, which I hope was comprehensive, I saw a graphic that showed the location of the Santa Barbara honeysuckle plants, And I didn't see that in your presentation. Do you have a slide that shows the location of those vis-a-vis the houses? If not, I'll ask Ms. Steinfeld about it, because if it wasn't from yours, it must have been from something I received from Ms. Steinfeld, and I can ask later. But if you have something right now, I'd ask you about it. If you don't, then I won't.
Commissioner Park, I don't include that in my slide. It is shown pretty clearly on the habitat restoration plan and the landscaping plan.
That's where I saw it.
Well, yeah, which I'm sure Amy Steinfeld can show you in her presentation.
At some point in this hearing, I'm going to refer to that. So if you can make a slide out of it, if she doesn't have it, I'd appreciate that. Because there's one that showed each plant, and it showed them vis-a-vis the grading and the actual building footprints.
Chair, we'll be ready to pull up, Chair and Commissioner Park will be ready to pull up that plan.
So what I'm going to do is reserve my more detailed questions for Ms. Steinfeld, and then if I have further questions for staff, I'll bring them up when we go back to staff after the public comment and the various presentations.
Okay, sounds good. Any other questions? Mr. Cooney, please.
Thank you, Madam Chair. I feel like I know the neighborhood well because so many of the issues that have been raised this morning and in the staff report are ones that have occurred in my neighborhood about the same altitude, but a few miles down the mountain trail. And it's astonishing to me, to begin with, that CEQA is somehow observed only to note that it's not required. And I don't know how many CEQA-based cases we have as a commission studied even in the last year or so. But could you indicate again what statutory requirement exists to avoid CEQA analysis?
Chair and Commissioner Cooney, so there's a provision, Section 15183 of CEQA, which says where there is a community plan for an area and where an EIR has already been prepared for that community plan, that no additional environmental review is required, provided that the proposal meets the density, so the zoning density that was anticipated in the community plan EIR build-out, and provided that it's consistent with the policies of the community plan. The way that I understand that is when you prepare an EIR for a community plan and you identify impacts and mitigation measures, those mitigation measures become the policies of the community plan. So in a way, it's saying if the project is consistent with the policies, it's applying the mitigation measures of the community plan for the Eastern Goleta Valley. And the density component comes in because the community plan analyzes the potential build-out based on the zoning that's analyzed in the community plan, which is the zoning of this parcel. So for example, if they were wanting to increase the density, it might not, in a way that it was not anticipated by the community plan, we might not be able to apply Section 15183. But in this case, the community plan analyzed build out of the community. These undeveloped lots, it assumed would be developed at the density that they're zoned. It assumed that there would be homes, there would be a home on this lot. And so Veronica prepared a very extensive, 18-page write-up analyzing the project's compliance with Section 15183. It's kind of like a mini initial study, or MND, that goes through the impacts and mitigation measures identified in the EIR for the Eastern Goleta Valley Community Plan and analyzes it against this project. So there is a fairly extensive discussion of why Section 15183 is appropriate for this project. And I think when Ms. Steinfeld comes up, she probably has more to say about CEQA as well.
I have a lot of respect for Ms. Seinfeld, and I look forward to her presentation, but I also hoping that staff is paying close attention to this anomaly, if you will, that if there is a community plan that can stand in place of CEQA analysis and is being suggested in this case to do so.
Chair and Commissioner Cooney, if I may, what 15183 is saying is there's already an existing EIR, and we're relying on that EIR. And there are multiple sections of CEQA, like when you're going to do an addendum to an EIR, where it says you shall not prepare an additional CEQA document, like a subsequent EIR or MND, where you already have a CEQA document. In this case, we do already have the CEQA document, and it's the community plan EIR. And maybe I'll give you an example. The Santa Barbara honeysuckle, for example, and rare plants. The EIR analyzed there will be impacts to rare plants, and then identified policies that says when there's impacts to rare plants, you have to replace them, and you have to replace them at this ratio. So then we look at the project and we say, there's impacts to rare plants that were anticipated by the EIR, and there's a mitigation that's asking for replacement. Are they doing that? Yes, they're doing that. So that's us showing compliance with the mitigation measures of the EIR. So it's a little bit of a fine point, but we really aren't saying there's no CEQA. We're saying there's already an EIR, and the project complies with the analysis of that EIR.
Yeah. Thank you, Nicole. That was a great answer. In addition, Commissioner Cooney, I don't think it's accurate to say it replaces the CEQA review. Section 15183 provides a streamlined review process. So we still did a CEQA analysis. It was just based off of the EIR that was already done.
I just want to add, if this hasn't already been said, the EIR created mitigation measures, and those mitigation measures, including those for mitigating any loss of a rare plant, those are directly incorporated into the community plan. So the Eastern Goleta Valley Community Plan has these policies. The policies are taken directly from the mitigation measures from the EIR.
Good job, you guys. I indicated I was surprised, and not every development in the mountains is going to fall under the Goleta community plan. So we'll have another chance in the future to compare those. But I appreciate going through it, and thank you for your patience. I think that's all.
Thank you. Mr. Martinez, do you have any questions?
None at the moment.
Thank you very much. First of all, thanks for the presentation, and also I wonder if you could just talk through this slide that you put up regarding the honeysuckle plants.
And I did have more questions about 15183.
Commissioner
Over to the slide
Ford.
first.
Sorry. We're looking at both lots here, but let's just focus on lot 11, which is the project in question currently. As you'll see, all of the green hatching area, which was also on my presentation, that's showing all of the restoration area, which is a combination of different plants. It's not actually shown on this sheet. It's shown on the landscaping plan as to what types of plants that includes. But of course, those would be, fire resistant, drought tolerant plants, native plants. On lot 11, specifically, you'll see that, ignore the oak trees for now. We're looking at the red clumps. You'll see that 5 Santa Barbara honeysuckle plants are to be retained, and then 3, kind of on the left side there, are going to be removed, meaning that 9 honeysuckle plants will be planted to replace the rare plant to meet our policies. And again, the rest of the green hatching just is extra restoration for what our biologist identified as environmentally sensitive habitat, which there are 2 separate alliances, which I include in the staff report, which include the Coast Live Oak Woodland with its understory, and honeysuckle understory as the other type of alliance.
Thank you. Mr. Park.
Yes, thanks for bringing up that slide. You know, if you observe the questions I ask in hearings about mitigation, you know I'm going to ask this question because CEQA guidelines favor, and they make it very clear, favor avoidance as opposed to mitigation. And we have various policies that are enacted by the county that follow that guideline and state that we maximize avoidance before mitigation. So I always have to ask, why are we removing some of those plants? So for example, group, and I can't quite read the number, is it number 4? It's the one that's immediately to the left of the building envelope on lot 11. And do you know why that's being removed?
Commissioner Park, are you referring to where it says 3, the red kind of blob that says 3? Okay.
That's it. You got it.
Okay, just want to be
I just
clear.
can't read it myself.
I believe those had to be removed actually due to fire requirements, fire clearance. There are separate zones, which you'll see there's zone 0, zone 1, zone 2. That falls pretty close to zone 0 where we wouldn't allow any plants.
Okay, so it's not because there's going to be some fill dirt dumped on it, or there's a house on top of it. It's to make it defensible against fire.
Commissioner Park, that is
And is
correct.
Santa Barbara honeysuckle considered combustible?
Commissioner Park, I just had a conversation about Zone 0 yesterday. They
Yeah.
don't want anything.
What's that?
No, they want no plants.
Right.
Nothing.
That's
in
the
that
current
Zone 0,
thinking on,
yeah.
yeah, I get you.
So I think any plant type to fire is considered combustible right now.
And do we have any information on the rates of success for restoration of Santa Barbara honeysuckle? I mean, we know that some things like dendromecan and Fremontodendron, you can plant all you want, it won't live. And we have other things you can't kill. Where's this fall?
Chair and Commissioner Park, I think I would probably defer to Mark De La Garza, the biologist, to answer that question as an expert. I will say that
Is he here today?
He is here, yes.
Okay, good.
I will say that the habitat restoration is going to require, I believe, an 85% survival rate at the end of 5 years. And if the plants have not survived at that point, contingency measures will need to be implemented to ensure that that rate is met. But Mr. De La Garza could probably speak to your question with more expertise.
Okay. And I did have, I originally raised my hand several minutes ago to ask about the 15183 analysis. Is now a good time for me to ask that question?
Sure.
Yeah. Okay. So I think I heard from Ms. Liu that we have less need of environmental analysis here because we have the East Goleta Valley plan. Does that mean we don't rely on the 15183 exemption, or we still do?
The Commissioner Park, the 15183 is not an exemption. It just provides for a streamlined review of projects that are consistent with the community plan.
Okay. And then didn't we have 4 exceptions to that where we do have review, like one is where it's
Correct.
peculiar
Yep.
and things like that?
Correct.
Those are still in play. That's not displaced by the fact that we have the East Goleta Valley plan here.
That is correct. In our analysis, it looks at each topic area and looks to identify if there is anything project specific or peculiar
Right.
that comes from these proposed projects.
I got it. Okay, thanks.
Yep.
Thank you, ma'am.
Thank you. Mr. Reed, please.
Just a couple more questions, not to beat the item to death, but with respect to the Santa Barbara honeysuckle. Okay, so the net loss is 7, okay? And that's due to fire safety requirements, not the choice of the applicant, but because it has to be in a clear zone, is that correct?
Commissioner Reed, if we're just talking about Lot 11 right now, the 3 that are being removed, yes, it's due to fire requirements, fire safety
Yeah, but
requirements.
If we just, if we just look at total, both lots, so 7 are getting removed. Each lot, the landscape plan shows 9 are going to be installed, so it's a net gain of 9. And irrespective of the 5-year survival rate, how excited am I? I start out as a botanist. I have 2 degrees in plant pathology. How excited am I supposed to get about a plant that I can probably go to the Botanic Garden or any number of native nurseries and buy in a gallon can? You know, that's facetious. You don't have to answer that one. Thank you.
Mr. Cooney, please.
Thank you very much, Madam Chair. I can't leave the project despite the skill and excellent advice we've received from our staff already. And I know that at least 2 attorneys are going to be adding to the discussion. But we in California, much less in the hills of Santa Barbara County, just can't look at a new project going into that area without being concerned about fire. And I heard that, and please correct me if I'm misstating this, but I heard that the Santa Barbara County Fire Department has indicated that all measures necessary are being applied, and therefore this project can go forward. Is that accurate?
Commissioner Cooney, that is accurate.
Okay, well, then I have an issue with the fire department, but not with you. So let's keep going.
Commissioner Cooney, yeah, I understand that. This is a high fire hazard area, right? And it was planned out to have these lots, and the development was envisioned. I do think we went above and beyond to coordinate with fire to make sure, given the real constraints, and they are our county experts, but we acknowledge your concern.
Thank you again to staff. With that, we will go on to the next presentation, which is by the appellant. Please, when you come to the podium, please introduce yourselves, and I'm hopeful that 15 minutes will suffice.
Coming up.
My name is Michelle Peterson. I've lived in Santa Barbara since 1976 and in Painted Cave since 2015. I filed the appeals because I and my neighbors are opposed to the approval of the 2 excessively large houses planned for lots 11 and 10. We agree that the houses are incompatible with the community, that they threaten sensitive biological resources, and that they compromise the safety of the entire community. Many of us have expressed our opposition in letters to the planner who processed the LUP applications and via our signatures on a petition to you, the Planning Commission. All told, we think the project as it stands is too much for the community. After meeting with a group of like-minded neighbors, I hired Mark Chitillo to represent our concerns, and he will now carry on our behalf.
Thank you, Ms. Peterson. Members of the commission, I'm Mark Chitillo, attorney for the appellants in this matter. Thanks for your detailed questions. I appreciate that. Quick overview of what we've presented, and we'll maybe spend a little more time in detail in this presentation, and for the next one we can truncate it somewhat. We have a team of 5. We'll only have 3 of us here, and you've heard from Ms. Peterson. The third person is Christopher Dykes, a professor at Cal Poly, wildlands fuel and ecology expert. His written opinion is included in our materials at Exhibit H. David Kistner, a county certified biologist, will not be presenting today either, but his written comments are attached as Exhibit F. But we will have the benefit of hearing from retired county fire marshal Rob Hazard. His comments, or his written comments, are Exhibit D, and you'll be hearing from him momentarily. I want to briefly just touch on the issue of timing. I heard Commissioner Reed mentioning the late submittal, and of course that, I think you're referring to the informal. It would have been nicer if we could have gotten this to you earlier. It's my hope in each of these appeal hearings to try and get the materials to the commission so that you can have the weekend to study them. So I aim for Friday, but technically these were not late. They're due according to protocol Monday at noon, and we did get those in that time. For the last 2 years after we filed this appeal in 2023, obviously conditions have changed quite a bit. Staff at that time had informed us that their reliance for CEQA was just on a ministerial, that the conclusion that this was a ministerial project, so there was no exemption that applies. It just wasn't subject to CEQA. And it wasn't until last Tuesday, the 25th, that we actually saw that it was that the county had decided to rely on 15183, which is a much more complex analysis. With my 3 experts, I had to reshuffle all of their testimony and work with them through the holiday weekend. So we worked very hard to get you this material, and I appreciate that you've, Mr. Reed and members of the commission, have had a chance to study that, because that was a considerable amount of effort. With respect to ADUs, I think it's important to recognize those are ministerial approvals after the fact. So if they convert this garage into an ADU, there's going to be no review whatsoever. That occupancy is going to be there. And obviously, occupancy is a key question for this project. With respect to the grids, we chose in Exhibit A to calculate and look at just the quarter acre or less parcels. Actually, we included the quarter acre, which this area is in this project. We also included the half acre parcels in order to provide some additional, a more robust assessment of what's the neighborhood. A 15 or 20 acre parcel down at the bottom of Painted Cave Road that has the 5,000 square foot house isn't part of the Painted Cave neighborhood at the top of the hill. And Mr. Hazard will be able to address that in just a moment. So key issues, environmental review is obviously a critical one. We believe that this project needs a full initial study. That would then provide the decorum to be able to look at the wildfire impacts, the risks that have been newly identified over the past decade since the EIR was certified, and as well as the biological issues. The project is not consistent with the general plan or other applicable authority, and we disagree with the determination that the fire department apparently has made with respect to this project. The black letter law of the development standards applies. If they want to exempt that, they have to have evidence to waive those standards. They can't just say, well, we don't think it really needs to apply here. There needs to be an alternative method that's identified to address the same risk. Those standards are not only in our development standards, but also in state law and the state regulatory environment. And then the role of environmental review, as you know, is to just avoid having these stubborn problems swept under the rug. So here's a helpful graphic, I think, that kind of shows the road on Painted Cave Road South. This is the entire Painted Cave Road. This one is subject to a county regulation that limits vehicles to 30 feet. Trucks above 30 feet or cars, automobiles with trailers over 30 feet can't use any part of this road, red or purple, under code. And similarly, the Board of Supervisors adopted a regulation that says that vehicles over 12 feet can't use the southern portion because of the existence of the boulder here, which obviously limits considerably the ability of vehicles to go underneath there. So this is a highly constrained road. So now let's talk a little bit about CEQA and the streamlining process that Mr. Seward referred to and staff is relying on. The 15183 is the administrative regulation. It's based on the statute, and the statute is 21083.3. And it requires, for this streamlining provision to apply, that the project has to be consistent with the general plan, not just the density, but all of the elements of the general plan. And it doesn't apply if you have the peculiar impact, if the impacts were not addressed as significant impacts in the EIR below, or if there's substantial new information that shows that those impacts will be more significant than in the prior environmental impact report. And those all apply in this case. Consistency with the general plan. I picked only the most significant ones because I hope that your commission will see that there needs to be an initial study for a more robust analysis of all of these issues. The development standards in the fire code require consistency with the state standards for defensible space, road width, and those are the two key issues that we are going to present testimony on today and did through our written materials. The impacts that are particular to the project are associated with both its location it is a very high wildfire hazard area, not a high which is a distinction that matters when you're dealing with the risks associated with this. The evacuation routes are obviously compromised, and the whole of Painted Cave, the grid, the 71 units and parcels that are in the grid are largely antiquated, and Professor Dykes opined that only one met current fire code standards. The parcels are all small, rare plants, shallow soils, and it's in a congested area. And of course, the project is considerably larger than the average homes on the comparable lots. 4 bedrooms and 3.5 baths. You could have 4 to 8 occupants in each house before the ADUs. Originally, that was included in the project description, but then it was subsequently removed. Those are peculiar impacts. The impacts that were not considered in the EIR include the fact that there was no treatment of the Painted Cave or mountain communities at all. We have now modern wildfire impact assessments. And a series of other issues. I'm going to keep moving in lieu of the time, and I want to make sure that Mr. Hazard has some time to speak. If there are off-site impacts or cumulative impacts, then you cannot use the 15183. Here, if somebody with this project lights a fire, it's going off-site. If somebody from this project crashes their car on the way down or can't make it and blocks the roadway, it's going to have off-site impact. So there's no question that the nature of the project's impacts are such that there are off-site impacts. And then finally, there's new information, which we're going to hear in a moment from retired Fire Marshal Rob Hazard. So I want to invite Rob to come up and talk about some of the significant impacts, the significant changes in wildfire impact analysis that have occurred in the last 10 years. Mr. Hazard.
Can you flip it back to the community map?
Yep.
The next one.
There you go.
Yeah, okay. All right, I'll try to go fast. I'm not good at going fast, so I'll do my best. Good morning, commissioners. Happy to be here. My name's Rob Hazard. I was your county fire marshal up until about 1.5 years ago when I retired from county fire after 26 years, and I had 10 years of Forest Service experience on the hot shots here locally. So a couple questions real quick that I'll answer for staff. So there are 71 parcels with homes on them in the Upper Painted Cave community. So I went in and measured the square footage of every single one of those homes. The average was 1,400 square feet. The mean was about 1,200 square feet. The 5,000 square foot home is on the Lower Painted Cave community, about a mile below the upper community on a 10-acre lot. So it's a very different setting. Painted Cave has an extreme high level of wildfire risk. Intuitively, everyone in here knows that. It's been measured and quantified by multiple efforts. The state has done their fire hazard severity zone mapping. It's in the very high fire hazard severity zone. And recently, the Santa Barbara County Fire Safe Council, I sit on the board of that group, we are conducting FlamMap fire modeling for the community and coming up with extremely high integrated flame lengths surrounding that entire region. It's surrounded by dense chaparral vegetation and steep slopes right into the upper community. Has significant fire history, names that I can toss at you that you would all remember. 1990 Paint Fire, 2009 Hasacita Fire, 2008 Gap Fire, 2016 Ray Fire, 2019 Cave Fire. And there is a nexus of wildfire ignitions that happen all along these road corridors. This is something that County Fire collects this data annually. And there are literally hundreds of ignitions that happen throughout this area on an annual basis that can lead to a fire jeopardizing this community. Staff mentioned that Captain Olmsted reviewed the project. I can guarantee you that Captain Olmsted reviewed it at the parcel scale, because none of the parcel maps show 100 foot of defensible space, which is the state minimum standard. And in a conversation with the current fire marshal, I reminded him that they amended their standard recently to include off-site defensible space on the adjoining parcels. That is apparently, according to their standard, the responsibility of those homeowners to do that extra defensible space. You can see from the project plans that they have about 50 foot of defensible space in the rear lot and less than 20 feet of defensible space on the side lots. So knowing that the adjoining parcels are going to be required to do the extra defensible space required by the state and local code, there would need to be landowner agreements in place. There would need to be some type of agreement that into perpetuity this would be maintained. Typically, how you would deal with this in a project like this would be through generating a fire protection plan, which, by the way, is required in the local Santa Barbara County Code. All development in very high fire hazard severity zones are required to have a comprehensive fire protection plan. If this was a development requiring a map to be recorded, a fire protection plan would automatically be required through the CEQA process. Because in 2019, CEQA amended itself to include wildfire analysis. That was not part of the Eastern Goleta Valley Community Plan wildfire. They did not include wildfire analysis in the CEQA document. I was in county staff at the time and assisted with county planners developing that community plan. Wildfire analysis was not included for the mountain communities. Then the last thing I want to speak to is the road. So state guidelines say that all roads that access residences shall be 20 foot wide. County code requires all roads that access residential neighborhoods be 20 foot wide. Painted Cave Road, in every dimension that you measure it, and in every length, in nowhere does it meet 20 foot standard. I physically measured the road in 50 foot segments last week, starting from the top down to the project site, and then all the way down to the Painted Cave site. It averaged 15 to 17 feet wide, and in one particularly troublesome area, the double switchbacks, which the locals here will know about, measured 9.5 feet wide. So the rear duals of a fire truck are going to be hanging off that edge. And point in fact, in that exact same location in 2019, a fire truck hit a tree responding to the cave fire. Below that point is the infamous hanging rock, which also Santa Barbara County had a fire apparatus smash into that rock back in the early 2000s. So there's numerous problems with that road that are not analyzed when you're looking only at the parcel scale. So while technically Captain Olmsted is correct that it meets access standards, that's because he's only looking at the driveway. He's only looking at the fact that there is a driveway that is within the parcel that has to meet the 12-foot minimum. So the only way that you get this higher level view is if you look beyond the parcel and beyond the specific development standards and fire code requirements specific to that parcel, and you look at the overall area. The final piece of this is conflagration potential. So this is a new thing. This is something that was not ever discussed when Eastern Goleta Valley Community Plan was being developed. But we all know now, seeing what happened in Palisades, the Eaton Fire, and in the Paradise community, that conflagration is a very real thing. It is something that affects all dense communities of structures. Painted Cave has all the elements of a potential conflagration: dense housing, very receptive structures, and wind-driven fire, the infamous sundowner winds that affect this area. So it is incumbent upon the county to at least analyze the potential for conflagration fire to impact these two new structures, or for a structure fire originating on site to impact the rest of the community in a conflagration. The only way you can do that is through a greater level of analysis, potentially looking at things like alternative methods and materials that might go into this, beyond just your typical building code 7A requirements. And just two last things I'll close with. Two things that happened to me personally in the Painted Cave community as a firefighter serving Santa Barbara County. In the early 2000s, I responded to a structure fire on the Laurel Springs Ranch. I was the engineer on the pumping apparatus. We ran out of water while we had firefighters on our interior hose lines. This speaks to remote communities that have on-site water systems are always subject to failures. And so technically, yes, the 2,500 gallons of stored water meets the county standard. But that standard was in place for the structure fire that I was on in the early 2000s. And there's nothing worse for an engineer at the panel to watch your tank go dry and watch your hose lines cavitate. And I'll go back a little bit further. In 1990, I was a young hotshot on the local crew, and 30 minutes into the Painted Cave fire, we were involved in a furious firefight along Highway 154. We ended up getting burned over. We had to shelter in our crew trucks, along with several civilian vehicles. And I watched from the inside of a vehicle as 100-foot flame lengths surrounded our vehicles. We were on the widest stretch of 154, where currently that super long construction project has been going on. I will tell you that you cannot overstate the ferocity of wildfire on our public roadways. And so to think that Painted Cave Road, that has to connect to East Comunicello, that has to connect to 154 to get all of these residents to a safe area is adequate, and that the fire department adequately addressed those issues in the review of these projects seems suspect. So my recommendation would be a greater level of review, at least to include a definitive fire protection plan.
Thank you, Rob. And Madam Chair, if I could just have a couple of minutes, and I'll try and wrap up our presentation. Thank you.
And when he's done, I have some questions of Mr. Hazard.
Sure.
Okay, great, thank you. And thank you, David, for bringing this back. So I want to just, the CEQA, the power that your commission has is based in the findings of general plan consistency and the findings of CEQA exemption. And that is where we have presented overwhelming substantial evidence that these issues were not considered in the 2015 EIR. The standards that Mr. Hazard just referred to were adopted. There's a new CEQA standard in 2018. Then there's the Attorney General's guidance on how to interpret CEQA and how to apply CEQA for wildfire impacts, which is Appendix Q, or Exhibit Q to the materials. I hope you've had a chance to study that, because that is really the single most important document in terms of your analysis of the CEQA issues associated with this project. Our Attorney General interpreted the new provisions under CEQA and the Bonta v. County Lake case and determined that there needed to be a consideration of wildfire ignition and evacuation amongst other issues. And so those were not done as part of the 2015 EIR. You don't have any evidence to support a finding that this project would be exempt, knowing what you know now, what we know now in 2025, that analysis in 2015 didn't have the benefit either of that authority or the subsequent fires where we've seen where there are significant human risks and risk to life and property. So we don't think that any of these findings apply. I want to reference one other piece of authority. I think that the findings cannot be made that the exception or the exemption applies, and the 4 exceptions of peculiar project not covered in the EIR, offsite and cumulative impacts, and no new information. Those 4 exceptions, each of them applies. And if only one applies, that then provides a pathway to doing an initial study and assessing what's the appropriate level of environmental review for this project. The fire protection plan obviously is a key piece, and compliance with the current standards, which the project does not comply, and that's a general plan requirement. So our general plan safety element says you got to meet all the applicable standards. It does not. So that's also the basis for your commission not finding that this project can be approved at this time. The additional authority is based on CEQA, that the case of Citizens for Better Environment versus the California Natural Resources Agency. And that addressed tiering. When you rely on a prior EIR, if the prior EIR makes findings of significant of overriding consideration, there are significant impacts that could not be mitigated at that community level. This case requires that there be an additional environmental document, not an additional environmental impact report that evaluates whether those significant impacts from below could be mitigated as to this individual action. So that's another, I didn't cite it in my materials, but I think it's important for your commission, since you have dug into this CEQA issue. It's an additional foundation for why there needs to be additional environmental review in order to be able to consider this project. And that environmental review then gives you the opportunity to avoid, to see through an EIR the applicant identifies their objectives, and then at that point, the environmental or impact report evaluates alternatives that can achieve most of those objectives with lesser impact. And that alternatives analysis is a critical piece that's needed for these projects. And through that, then additional mitigation measures in order to, if possible, reduce these impacts in significance. So with that, I appreciate the additional time, and we're available for any questions. And obviously, we're going to see some additional discussion on the adjacent lot. I don't know that it's fair to consider these two projects separate, because obviously they are the same. They're linked. And to take them separately piecemeals the impact, as Mr. Hazard said, which is really a regional impact. So thank you, Madam Chair and members of the Commission.
My pleasure. So, colleagues, I wonder if you have any clarifying questions for Mr. Chitillo, Mrs. Peterson, or Mr. Hazard.
Yes.
Please, Mr. Reed.
Okay. Who's up, me?
Yes, sorry.
Okay. Mr. Chitillo, I appreciate your answer on the timing of your submission, but that seems to be your MO at a lot of our hearings, but I appreciate the fact that you made an
Those are the
effort to
guidelines.
answer.
I mean, if the regulations,
Sure.
the procedures.
I
are
know
not-
it's okay to
I don't
submit
appreciate. I mean,
anytime.
it's I'm complying with the rules.
I know you're following the rules. That's fine.
I
But
guess that's my
sometimes-
MO, is to try and comply with
Yeah.
the rules. I do my
Yeah.
best.
Sometimes I just wonder if that's to confound our efforts to review it.
Under
or
no
to
circumstances
to
would I do that.
apply.
No.
Okay, fine.
If that's the belief, that's not my intention.
Yeah.
It was the Thanksgiving holiday.
But I did find it enlightening, the material in your letter.
Great.
Because this is a pretty complicated issue. Definitely, it's a bit murky, and I have to separate my own feelings as a landowner and stuff about neighboring developments, et cetera. So I appreciate that. I'd like to speak to Mr. Hazard. You know, I always remembered your name when you were fire marshal and thought you had the perfect name for that.
It was completely random.
I was going to
I get that
ask
question a lot.
I was going to ask if you had any personal experience fighting fires in this area. So I
Many.
appreciate further your answering that. And, you know, you're a fireman. Who's going to disagree with a fireman on anything they say?
Other firemen.
You bet. Well, yeah, I suppose. But I do have a question.
Sure.
Obviously, you're very clear in your position regarding this applicant, these two lots. Would that be a similar position you would take on any other development in that mountainous, very high fire-prone area?
Yeah, so many of the firefighters that I work with and many of the county planning staff would probably attest that I've always had a strong feeling about the county public access roads that go into these mountain communities. I was probably a thorn in the side of many people in the evacuation advisory committee group when they were doing the evacuations, the KLD evacuation study, because that study did not look at actual road widths. It assumed 25-mile-an-hour speed limits for these mountain roads because it assumed they were 20-foot ride roads. And I physically went up there and measured all these roads and put it back into KLD's face and said, this is a flawed study. And I've had a lot of conversations with the transportation folks about this poor state of these roads. And so this goes to the heart of the problem of wildfire safety. And this is something that has reared its head since the 2015 Eastern Goleta Valley Community Plan, EIR. If you look in that document, it has a transportation study. It was done in 2014 and only looked at the urban areas of Eastern Goleta Valley. It did not look at the mountain roads above Highway 154. If you were to ask the transportation folks here, if they were in this room, do you know the road widths of your mountain roads? They would tell you, no, we do not. We only have a centerline file, which is a line file in GIS. It does not measure widths. And they haven't physically gone out and done these measurements and determined where these roads are grossly inadequate to provide for public safety. So this is something to understand. The response time for the closest county fire engine to Painted Cave is 24 minutes on average, plus a 2-minute turnout time, the time it takes the staff to get into the fire truck. NFP standard for rural areas is 14 minutes. So to get effective firefighting force on scene, which would be 3 engines and a battalion chief and a truck company, So number one, you'll never get the truck company up there. They can't make it up the road. And to get 3 engines and a battalion chief from the South Battalion, you're looking at an over 30-minute response time. So meanwhile, the only thing that's holding that fire in check is the 2,500 gallons of stored water coming out of a sprinkler head that's been activated by a fire. If it's a wildland fire, those interior sprinklers have no purpose. They're only for interior fires. And so that road becomes a critical piece of this fire mitigation and public safety puzzle. It's super critical for the firefighters responding, and it's super important for the residents trying to get out of the community if there's an evacuation called by the county, I might add, who's probably going to be doing a mandatory evacuation. So you have a community that has a mandatory evacuation order trying to access out of a community with no good way out. Case in point, so these are factual things that happened. In the 2019 Cave Fire, that fire started east of the community on East Camino Cielo Road in the middle of the night with sundowner winds pushing it, somewhere around 40 to 50 mile an hour winds, with rates of spread that were probably somewhere to the tune of several miles per hour, pushing that fire down towards Santa Barbara and laterally to Painted Cave. The county closed the top of Painted Cave Road. That was closed. Residents tried to evacuate and they were turned around. So these things happen in evacuations. People get confused. The law enforcement officer was confused, took it that he had to close that road off and sent everybody down the opposite direction, which is a terrible evacuation route. It's winding your way down Painted Cave Road, past that rock you saw in the pictures, switchbacking through mid-slope mountain range covered in chaparral, which, by the way, the cave fire burned over that landscape several hours later. So we know that evacuation is a significant concern. And I'll just read one thing out of the, so everybody keeps talking about the Eastern Goleta Valley Community Plan. I have to read this. So this is Policy Fire 5.2, Non-Conforming Roads and Development. And this is what it says. The county will continue to evaluate non-conforming development and apply contemporary road standards consistent with the state fire safe regulations that are in Title 14 of the California Code of Regulations through the development review process. So how can you not look at a project like this in an extremely high fire hazard area? And there are other places like this, Refugio, Gibraltar Road, Mountain Drive. So we all know these locations. So yes, do they require more review than simply applying fire code and building code? Of course they do. I mean, that's just obvious. So what is that higher level of review? That I can't speak to, but I do know that as designed, as reviewed by the fire department, it's not adequate to address these issues. At the very minimum, you would ask the project to do site-specific fire modeling. This is done all the time in community developments where a fire protection plan is required. And a consultant will come in and do fire protection modeling and say, yeah, this is the flame lengths that are going to happen at the edge of this community. That informs vegetation management, because then you know how much vegetation you need to manage to reduce those flame lengths to have a survivable situation. So does anybody in this room think that those site plans create a survivable situation? You have, at maximum, 50 feet of defensible space in the back of the lot. So how is it possible that you think you could stand there with the type of fire behavior that you could expect and survive that? You would not. So you won't have defensible space for structure protection, so firefighters are at risk, and you won't have defensible space for shelter-in-place options, which there is a high degree of probability that people will shelter in place there. And point in fact, they did shelter in place during the Painted Cave Fire. Many, many residents sheltered in place. And the final little piece of that Painted Cave Fire, this is directly to me from Chief Hartwig, former county fire chief as of a month ago. He was there at Painted Cave during the cave fire, and he could not get strike teams of engines to go into the upper community to do structure protection. They would not do it. They were out-of-town strike teams. The strike team leaders went in, evaluated the neighborhood, the dense streets, the super ember-receptive structures, the complete lack of safety zones and temporary refuge areas, and the narrow public road that accesses the community. And they denied the assignment. Chief Hartwig reached out to our local engine crews, which were already in place. They were in place down at the bottom of the pass, and redirected them to go up there. And those captains were clearly not going to say no to the fire chief and had a greater degree of local knowledge and felt like, okay, we can do this, but it's going to be dicey. So this is a known thing amongst the fire service here locally. Painted Cave is one of the greatest high-risk communities that we have. And at the very minimum, a comprehensive fire protection plan would be the only way that you could address some of these issues.
Okay, thank you.
Thank you. Mr. Park, please.
Could we go back to that slide that Mr. Hatter was referring to in his testimony? First thing I'm going to ask you to do, Mr. Hazard, when that comes up, is to identify the location of the closest county fire station to the project.
Not on the map. At this scale, it would be down here somewhere. So at this scale, it would be somewhere down here on the floor. So it's located on Hollister Avenue, next to the Wake Center.
Nothing on Camino Cielo.
No, so there's a Forest Service station. It's a wildland fire station only. It's a federal resource. They're nationally committed all the time. So they don't do structure fires. They don't do EMS.
Okay, I'm going to ask you some questions of rapid fire. Downslope to the west of this community, just down its slope, a lovely young woman was incinerated to death in her home in 1990. Is that right? Correct?
Yep.
Yeah. And in 1974, was that the Romero Canyon fire? Four firefighters were incinerated to death trying to fight the fire on one of these remote mountain roads, correct?
Yep.
And in the Coyote Fire in 1964, which swept back and forth from east to west for several nights, it apparently did not incinerate Painted Cave, but it came darn close, did it not?
Yeah, so that's an infamous story. The Forest Service did a backfire off 154, sent the fire up to the community, and then the winds changed. But yeah, little known fact, created a schism for generations between the Forest Service and the locals.
Okay. And speaking of the locals, didn't they, in fact, at some time, maybe they still do, have a volunteer fire department with their own
They
engine?
had a volunteer fire company, so that's an important
Yeah.
distinction in the California code. So volunteer fire companies don't have a physical boundary, they don't have a revenue source, and they're not trained as structural firefighters. But yes, they had a volunteer fire company, and it was disbanded a few years ago through some malfeasance from the fire chief.
I only brought it up to just show that it was a community concern.
It was a huge community concern. They currently do have a large group of folks that are called the Mountain Ember Team, and they're more of, I would say, like a prevention group. They do tons and tons of prevention work and community outreach to try to mitigate some of these concerns. It's a very difficult place to do fire mitigation, just because of the age of the homes, how they're laid out. You have steep slopes coming from all sides. In wildland fire, we talk about alignment. So alignment of wind, alignment of slope, alignment of fuels. When all these things come together, we get extreme fire behavior. Painted Cave community sits at the top of alignment. So everything's coming at it from every angle. It's actually rather interesting that it hasn't burned to the ground. And we talk about it all the time in the fire department. It's the same kind of conversations we would have about Mission Canyon, about the extreme fire risk there. And so it is one of our target hazards in the county. There are other places that have similar risk, but this is one of the highest risk communities in terms of wildfire that we have.
So if I went to the other end of District 1, where this is located, and near where Mr. Cooney lives, up in the hills, the mountains, and I was building a new house, my driveway would have to have a hammerhead turnaround, and it would be at least 16 feet wide, correct?
You would have to have a 12-foot wide driveway, a large bulb turnaround, and if your project required access that qualified as a road, so you were the third parcel, the third home accessed by this driveway, you would actually have to take the existing driveway that may or may not be 12 feet wide and turn it into a 20-foot road to the public road. And so this is where the adequacy of current development standards and the adequacy of the fire code misses the mark, because the code does not require the county to bring the county roads to the same standard. This is a common problem when you deal with this endlessly in these neighborhoods where project proponents look at the fire department with so much skepticism and the hypocrisy of requiring private properties to do 20-foot wide roads, when the county roads don't meet that standard. Which drives home the point, so what are the impacts of the county infrastructure not meeting the standard? How do you know what those impacts are? They are not evaluated in the Eastern Goleta Valley Community Plan. The KLD study did not look at Painted Cave Road. So if you reviewed that study, which hasn't been released yet, but it was circulated amongst county departments, it didn't look at Painted Cave Road. For whatever reason, it missed it. So this has not been evaluated. The only document that has evaluated wildfire risk for Painted Cave is the Community Wildfire Protection Plan that was done in 2017 through a partnership between the County Fire Department and the Fire Safe Council. And that project did look at fire behavior, potential fire behavior, integrated risk. It looked at the infrastructure, and it looked at the homes. So we have data. So we know from that document that they modeled that 80% of the homes in the upper community, the community we're talking about, would have an extremely low percentage of survival, even with active structure protection. It was the lowest of all the communities in that area. So the Eastern Goleta Valley, San Marcos Pass Community Wildfire Protection Plan looked at all the mountain communities in the San Marcos Pass area and all the way down to the foothills. Painted Cave had the lowest percentage of survival estimated for structure protection. So 80% of homes would be expected to not survive a simulated fire. That's not good odds, particularly if you're stuck there, particularly if you can't get out through any type of evacuation route. And there are no designated temporary refuge areas officially up there. There are ad hoc temporary refuge areas, but again, greater analysis would be needed to determine what's their efficacy, how are they going to be maintained, how are they signed and notified to the public. And this has been debated endlessly by the fire department over the years. And so it's something that this project is an opportunity to take a look at that lack of infrastructure up there and make some mitigations that would protect the surrounding community and whoever the new residents are of these homes that may or may not know what they're getting into.
When we're looking at the size of homes, we're not just looking at the aesthetics. We're looking at how many occupants will need to evacuate. Is that correct?
Correct.
All right. Thank you, Mr. Hazard.
Yeah, you're welcome.
I just have one question for Mr. Hazard. Thank you so much for the information that comes from your experience and knowledge and also anecdotal stories. I just want to go back to one quote you said that approval by the fire department is suspect. What do you mean by suspect?
Yeah, because so recent changes to the fire code a few years ago and the current fire code that was recently adopted and will come into effect on January 1st require fire protection plans for any development in a very high fire hazard severity zone. And in the state responsibility area, it's any high fire hazard or very high fire hazard severity zone. So I would ask staff, was there a fire protection plan prepared? How come it wasn't provided? It was prepared. It has fire behavior modeling, and it looks at response time, and it looks at alternative methods and materials. It has a vegetation management plan, not just on-site, but surrounding the development. That's what a true fire protection plan does. A fire protection plan isn't just looking at the parcel, it's looking at, holistically, fire mitigation, okay? So that would be the first thing I would ask the fire department, is how come you didn't look at that? Number two, fire department changed its development standards a few years ago, and this is an important change that happened, that they're now requiring off-site property owners to complete defensible space requirements if they can't be met on the parcel. The state minimum standard is 100 feet, but based on the plans, you get about 50 foot of defensible space in the backyard of this proposed structure. A little bit less than that on the front, and on the sides you have about 20 feet of defensible space. So to get 100, you have to complete this defensible space off-site. And the county development standard, fire department development standard for defensible space, puts the onus of that on those adjoining parcel owners. So this includes 2 parcels to the north across Painted Cave Road. So there's two parcels. They don't have a structure associated with those parcels, so they're going to have to do defensible space across the street to get to that 100 foot. The parcel adjacent to the west, which is Laurel Springs, they'll have to do additional defensible space, and all future owners of that parcel. And then the residential parcels on either side, which Arguably, they already have defensible space because they've completed it for their structure. So you can see the conundrum of multiple parcels that are now going to be required, according to the current standard, to do this. But in further discussions with the current fire marshal, he was unaware of that change. And he doesn't even think that that change is valid, and he had questions about it himself. So that's why I say it's suspect. So it might sound like I'm second-guessing my former staff, but in a way I am. Because this project cannot truly be considered fire safe unless you're looking at the off-site fire risk. The defensible space, sure, it's by the letter of the law, it's approved and conforming for the lot, but in no way does it meet the intent of defensible space. 50 feet of clearance in the back lot, that doesn't meet the intent of defensible space in any way whatsoever for firefighters. Firefighters don't care about what the rules are. They care about having a safe place to operate. That's what they'll care about when they're parked there with their fire engine.
Thank you for that clarification. I think that, Mr. Martinez, please.
Yeah, well, Mr. Hazard, while you're up there, I'm hearing you say two different things right now. You're saying that the fire plans, the ones that are existing, are simply limited to the parcel, like the 20-foot driveway. And that, but then I also hear you saying that the off-site defensible spaces, which even, you can tell me if I'm wrong, the laws don't address that, and it's inadequate. It's kind of, I think, I used a word, but I'm not finding it now, where they're saying, okay, this is what you got to have 20 foot on your parcel, but we're not having even 20 feet wide streets surrounding your parcel, which would really be the answer to the question. That's what I'm hearing?
Yeah, so fire department review, when they review these types of projects,
Review the parcel.
are focused on the parcel.
And
They
it's-
stop at the parcel line.
And
They
so-
don't look at the adjoining county road.
Let me stop you right there.
accesses the property.
Okay. So when the fire department looked at this project, it appropriately looked only at the parcel as pursuant to existing law, correct?
Except for the distinction that the current fire code requires a fire protection plan, and I guess maybe there's a difference of opinion on what a fire protection plan is, but I write fire protection plans, and so I have not seen in the material that I was provided with an actual fire protection plan. So a landscape plan is not a fire protection plan. A defensible space plan is not a fire protection plan. And so that would be my one challenge to the local fire department would be, are you applying the requirement for a fire protection plan? And does it meet your satisfaction?
For defensible fire.
Defensible space,
Which
impact
is-
on responding agencies, impact on evacuation, have you done fire modeling? Are there community fuel treatments that would be recommended by this fire modeling? What additional mitigations can you come up with?
So is what you're proposing here then to go beyond existing state law and look at all the surrounding stuff that would be, what you're saying is off-site matters?
Okay, so a fire protection plan potentially would come up with problems. It is going to identify problems. That is a fact. Problems with access and egress, problems with defensible space, problems with potential conflagration. So that gives you an opportunity for planners and the project proponent to redesign the project in a way that might mitigate some of this just from tweaking the design of the structure.
Let me stop you
tweaking
right
the
there.
design of the
Let
parcel.
me stop right there then. 20-foot public roads. How would that even be addressed, in your opinion, today?
So you could do it incrementally. You could create turnouts.
But who?
The county.
The county. Yeah.
Yep.
So even the hazards that exist as a result of those roads not being 20-foot wide, this community is at risk with that danger, the fire danger, with these roads not being 20 feet as it exists right now.
And if the county has no plans to do this, and it's not going to ever come to fruition, then you look at alternative methods and materials. For example, you need to seriously consider shelter-in-place options for this upper community. So that means you need to identify temporary refuge areas. So that's how the system works. You identify what your risk level is, then you identify where you have mitigations that you need to implement, and then are those mitigations feasible? So do I think it's feasible for the county to redevelop the road to East Camino Cielo and have an actual escape route out of the community? I absolutely do. It's not that long of a stretch, and there's not any geographic constraint. It's not super steep. It's not mid-slope. It could be done. But is it going to be done? Most likely not. And so then you fall back to, well, what is an alternative method or material that we could use that would give us a similar effect, okay? Same practical effect. And in this case of Painted Cave, it clearly would be options like temporary refuge areas, better early warning systems for the residents. So you could go down the list, on and on.
And the temporary refuge centers, those would be through the community interaction or county again?
It would be a cooperative effort because it's private land, so you'd have to find a large enough area to do this. And by the way, it typically has been Laurel Springs Ranch. They had the only large area that could suffice. So you would have to come up with a system that would quantify it, that would enshrine it in some kind of memorandum of understanding so that it's maintained, that the fire department inspects it, it's signed and appropriately noticed to the community, like this is where you go if you cannot get out of Painted Cave.
So, okay. And so what I'm hearing is it would take the community and the county, so it's a we, not a you, but a we.
Everything is a we.
Okay.
Yeah.
Thank you.
Yeah. Because, but I might add, widening the road will cut into fences and, areas that residents might not be happy about. So yeah, it's always going to be a we.
You mean, don't take it from my land, take it from somebody else's, probably. Yeah,
I mean, it's a 40-foot easement that the county has, so they can do what they want, but yeah, people wouldn't be happy.
Thank you. Thank you.
You're welcome.
Thank you. Mr. Wilson?
Madam Chair and Commissioners, we appreciate the comments that have been provided today by Mr. Hazard. We do want to let the Commission know that Fire Captain Mr. Chris Olmsted is online via Zoom, and he represents the County Fire Department currently and was involved in reviewing this project. So if the Commission would like to speak to Mr. Olmsted via Zoom, then he's available to answer any questions regarding the review in this project.
Mr. Park, thank you.
Would you consider a break?
I am considering and calling a break.
Thank you.
But would you like to ask the question first as he is online?
No, that was my question.
Oh.
My
Mr.
other
Martin-
question was more urgent.
Oh, I'm sorry.
I understand about urgency. Mr. Martinez, oh, no, okay. Well, as it is 11 o'clock, I would like to call for a 10-minute break, so make sure that everyone is fresh, and we will continue with the applicant's presentation. Thank you. Welcome back. I call this meeting back to order, and we will continue with the applicant's presentation. I'd love for you to introduce yourselves and also tell us how much time you think you'll need.
15 would be adequate.
Thank you very much.
Good morning, Chair Ford and Commissioners. I'm Amy Steinfeld, the applicant land use attorney, and I'm here with my team, whom I'd like to introduce. I'm here with Josh Kaplan, who's the owner representative. We also have here Rob Mell, who is the architect, and Mark De La Garza, project biologist. They're here to answer any questions. For now, I'm going to turn it over to Josh to explain a little bit more about this project and the owner.
Good morning, Commissioners. My name is Josh Kaplan. I have been friends with and worked with the Zucker family for about the last 6 years and have been intimately involved in this project, in the planning of it, the details of it for this almost this entire time. And I'm also involved in the property next door, which is the Laurel Springs Retreat or Ranch, depending upon how long you've known about it. I think we've heard a lot of information about fire and other things, but from my humble perspective, I think we're really here today because the appellant does not want us to build 2 single-family homes next to her parcel. And previously, she had suggested turning one of the lots into a park and one into a very small home. That's not reasonable, and it's not required of us to do that. It's a classic NIMBY situation, and for me, it's frustrating. I've never done this before on behalf of anyone. I've never done this before on my own behalf. But working with people who, I think we have a problem in the state with people who are trying to build single-family homes and they're running into issues like this, and it causes frustration, it causes expense, and it's really, really difficult to understand sometimes from a layman's perspective. So I apologize if I'm crossing into a territory I shouldn't. We didn't rally support of our neighbors because we didn't want to pit them against each other, despite many of them working with us, including the leadership of the Painted Cave Water Company, really the part of the organizing body, if you will, of the neighborhood. They helped us get through this, get us where we are today by helping us get the water that we needed for these 2 properties, including establishing a new water main, a new water service to the 2 parcels. We also didn't want to pit neighbor against neighbor because we know that in Painted Cave in particular, when you're living in some place like that, the first responders are your neighbors. They're the first people who are going to come help you, whether it's an emergency or it's a broken toilet, whatever it is. We know that neighbors help neighbors in this community. Our adjacent property, which is the Laurel Springs Ranch, is an historic retreat and now is a family farm. It's a working farm. It provides fresh produce to the Santa Barbara Community College food pantry, and we've heard a lot about needing a place of refuge. Well, it's also served as a place of refuge in case there is a fire or other emergency for as long as anybody can remember. And if there is ever an emergency, the gates of the property are opened immediately. We've listened to concerns about the project and we have made changes. We've reduced the scale of the homes, removed the ADUs. We even considered the boulders that underlie this project, because we know that someday, in decades or 100 or 200 years from now, these homes may not be there, but those boulders, those beautiful rocks, that beautiful topography will still be there. We've really been considerate of all these issues. The homes are going to meet and will meet modern standards. We have real foundations, insulation, energy-efficient windows, internal and external fire sprinklers. It has solar, it has battery backups, and it even has a generator for emergency power. These homes are going to be safe and efficient, designed for today's family, and I would add, again, hearing what I've heard today, probably they're going to reduce the danger of fire in this neighborhood because they will remove a lot of the combustible material. We know that change is hard. These homes are thoughtfully designed by our local architect, Rob, who lives in the community. He's designed them to fit the topography and complement the neighborhood. They are not the largest homes, but they are more modern, larger homes. If these homes were being built today based upon the land use approval that we had a few years ago, One of the homes would be occupied by the Hosea family, who presently live on next door on Laurel Springs. It is 3 people, 2 adults and a daughter. There's no intention of ever stacking this with 30 or 40 people, whatever has been discussed. Sorry, I added some notes as I've gone through here. In response to the fire that Mr. Hazard mentioned, that was at Painted Cave Ranch years ago, we were responsive. We added a 6 or 8 inch hookup to a 28,000-gallon tank. So there's 28,000 gallons of water just for fire, pressurized next door. We watch fire trucks and large vehicles come up and down these roads all day. We saw a picture of Painted Cave Road access with the giant boulder. We also have East Camino Cielo, where we've seen trucks come up and down constantly. So we know that when vehicles need to get up and down these roads, they can. I guess I'm just going to close with, we can't project or predict the future, but we can say that the family that owns these properties wants to do good things for the neighborhood, wants to do good things for the environment, and has a track record of doing so. And if anybody is ever interested in seeing what the ranch does and how it supports the community and how the no-till garden that they run there has become a model to how we actually protect the soil, we're happy to share it anytime. So pardon me for going off on a tangent, but thank you very much.
Thank you, Josh. So I just want to point out that no one should be under the impression that this project did not go through extensive environmental review. You can see here the host of experts that we hired here. So we had our architects, arborists, archaeologists, biologist, engineer, geotechnical engineer, geologist, landscape architect, surveyor, and a structural engineer. So this project is not a fly-by-night project. These parcels were actually purchased in 2013. So for the past 12 years, the owners have thoughtfully considered these sites, studied these sites, and designed these homes accordingly. As a result, there was detailed documentation preparation of what you can see up here. Again, as we heard, the applicant has a long-standing commitment to thoughtful development. As you heard a little bit about the ranch, I just wanted to dispel some rumors about the ranch. After the sudden death of Mr. Zucker's wife, Alyssa Zucker, the family decided not to proceed forward with turning the ranch back into a retreat center. It is going to be used for private purposes as a family farm, as you heard. While these 2 homes before you are not part of the Laurel Springs Ranch, I wanted to make it clear what was going on next door because there's been a lot of questions. In addition, again, the ranch serves as an emergency gathering site for Painted Cave residents. It has for the past several decades and will continue to provide that service. We heard a lot about, the zoning and whether these homes were appropriate. So again, these homes, one thing I want to talk about is there's concern, again, about additional residents up in this area. The good news is that the Painted Cave EDRN is almost fully built out. There's only a handful of vacant lots that will ever be built in this region. The rest of the areas we'll see on some of the ensuing maps is very mountainous and will never be developed. So you can see here, there's a little carve out of the Painted Cave EDRN here. And the whole purpose of the EDRN is really to ensure that you don't have a lot of sprawl and that the homes are clustered together. So as we heard, Rob Mell, 40-year Painted Cave resident. The family really understood how sensitive the Painted Cave community was, so they identified a local legend, Rob Mell, to thoughtfully design these homes. Stone walls and entry gates are very common, and these homes really reflect the mountainous terrain and the natural stone in the region. So you saw these renderings, but they really are beautiful and are going to serve as the gateway to the community. With regards to access roads, these homes are actually at the entrance of East Camino Cielo, where it meets Painted Cave. So they will have the ability to utilize that road, which we heard is wider and more straight than the other Painted Cave exit. So the homes will fit thoughtfully together. You can see here what these 2 lots will look like. They are both set back from the road as well. And they both have a 16-foot gate, so there's sufficient entrance and egress and entrance on both sides. We also spent a lot of time driving around the community. Rob, again, lives in the community. And so you can see here the beautiful stone walls that are very consistent with the neighboring community. Again, these are some of the neighbors. So in summary, there's a lot to love about these homes. As you heard, we reduced them in size. We removed the ADUs, incorporated natural materials. One thing that is new, and this was a development standard that was adopted in 2024, is this concept of this zone 0. So there will be no vegetation whatsoever within 5 feet of the home. And in addition, the rest of the vegetation is completely fire resistant. We spent months working with the fire chief. He was not happy with the first iteration of the landscape plan, so we went back. We completely revised the plant palette to reflect natives that were truly identified as being fire resistant. So we're quite proud of where we landed. In addition, we worked very closely with the fire chief to ensure that all the shrubs were thoughtfully placed and spaced. And some of the new development standards in 2024 that we complied with required us to place each shrub 2.5 feet, times the height away from each other. And the purpose of that is to ensure that the fire can't jump from shrub to shrub. So here are the two homes together. You can see the large entrance gates and then the really big turnaround. We have a gravel driveway at the front of each of these gates. And then you can see here the zone 0, which is the area where there will be no vegetation whatsoever. And then the rest of the green hatching reflects the area that will be restored with low flammable native vegetation, again, that was signed off by the fire chief. And these are actually adopted from a plant palette that was developed by the Montecito Fire Department. They came up with their own plant palette reflecting native plants that were truly fire resistant. My favorite topic, CEQA review. We heard a lot about it today, and we just want to thank the county for the extremely detailed Section 15183 analysis. Again, since the time that we received the appeal, it's been over 2 years. So we worked closely with county staff, developing additional plans, refining the plans, and ensuring that every issue that was a policy that was applicable in the Eastern Goleta Valley Community Plan was complied with. There was a contention that new laws somehow would obviate the purpose of the streamlining, but there's clear case law that states that new laws do not constitute substantial new information. And again, here, the Eastern Goleta Valley Community Plan carefully evaluated wildfire hazards, including very high fire severity zones, emergency responses, access constraints for these mountainous communities, fire protection services, and cumulative fire risk. So here are some of the many standards that we complied with. And what I want to say here is that I think what everyone's forgetting is that the homes and their existing vacant state actually present a huge fire risk. For those of you that visited the property, you saw there was a lot of shrubby vegetation, a lot of very woody vegetation. And so the lots, as are today, are more unsafe than they will be with this new construction. One thing we didn't really focus on, but these homes really go above and beyond. The homes feature state-of-the-art resistant construction. I spent a lot of time learning about this, and I'm excited to go back to my own home and implement some of these materials. So the homes are going to be constructed with fireproof shingles and fencing, dual-pane glazed windows, stucco, completely metal roof, Trex, which is a non-wood material for the patio and gazebo, foam insulation, and then backup batteries for the sprinklers in the event of a fire. So we are very excited about the design of these, and also they each include a 5,000-gallon water tank for fire protection purposes. A little bit about the biological resources. Again, we worked very closely. Mark De La Garza, over a very lengthy period, did many reports, many surveys. He went out again to do another spring survey to make sure he hadn't missed any sensitive plants. And so what you can see here is, someone asked about this 3 honeysuckle. We would love to retain them, but again, they are pretty close to the home, so we're gonna look at options if we can, salvage them whatsoever and retain ones that are out of the zone 0. But I think the takeaway from this is that overall, the restoration area on both lots will exceed 5,000 square feet of total restoration across both parcels, which is 4 times the total square footage of ESH that presently exists on site. In addition, during this process, all non-native plant species will be removed along with flammable species, which will both increase the native habitat and also make it more resistant to fire. A little bit about the water supply. The project sites included, they actually have existing meters. They worked very closely, as you heard, with the Painted Cave Mutual Water Company, and they both have active water meters. They have also replaced a lot of the old infrastructure that was needed to supply these projects. And then we heard, too, a little bit about the drainage. There's a lot of interesting things that are happening here to ensure that all storm water is going to be retained on site. As far as the geological conditions, they did several studies to determine what building on this cold water bedrock would constitute, and the geologists found it was suitable for construction of the residences, low potential for liquefaction, and they also did a lot of work on the septic systems to make sure it wouldn't impact the slope stability. So here, I just want to close by saying that the homes meet all applicable standards and align with the county housing goals. I do want to very briefly address fire. So we heard today that there's a lot of concerns with fire in the community. The owner is very aware that this is a high fire risk area, for that reason that they incorporated all fire resistant materials. In addition, the owner is open to chatting with the community. A lot of the concerns that we heard today are really community-wide concerns and should not be foisted on these two specific projects. If, in fact, the county or state prohibited building in these zones, we would not have much new development in California, especially in Santa Barbara County. But to address these, the county fire department has recently implemented recent fire development standards, and these projects comply with all of them. So if you look closely through our plans, we spend a lot of time talking about different features of these homes. I also want to talk about the propane tanks. So most of the homes in the areas do have propane tanks, but they're all above ground. And so we worked with our architect to actually bury them. And the reason I learned a lot about this during research on the topic, many insurance companies now require you to bury your propane tank. The reason being is that the soil acts as a natural insulator, and if there is a fire, the propane tank is protected. So they've done a lot of things, and one thing that we're going to emphasize in our updated plans is to ensure that there's at least 10 feet clearance around both of the underground storage tanks. So with that, again, I just want to emphasize our client is very interested in learning from the community and hearing more about the fire concerns. And one thing they're currently doing next door on the ranch is implementing the goats to deal with a lot of the shrub brush and to clear out a lot of the dead brush. So again, we're open to a community-wide discussion, but we don't believe that these concerns about the road clearance, things like that, should be addressed today in this particular forum. Thank you.
Thank you very much. Now I'd like to move to my colleagues for any clarifying questions. Mr. Park.
First one's preliminary. Is Mr. Mel or Mark, what's your last name, Mark? Is Mr. De La Garza or Mr. Mel going to be testifying, or should I direct my questions?
No, no, but they are both available if you have a specific biological question or if Mr. Mel has a
I do.
Yeah.
One from Mr. De La Garza.
Please come to the podium.
Mr. De La Garza, I don't pick on projects with regard to my preference and the law's preference for avoidance as opposed to mitigation. I just bring it up every time to see if we've gone through it. Now, but you have experience with restoration using this plant, Santa Barbara honeysuckle, correct?
Yes, I've been doing habitat restoration work, preparing these kind of plants for the past 25 years. I have 3 or 4 projects in Santa Barbara County where we have planted this plant, this particular plant.
And what's your success like with planting this plant? I know it varies from plant to plant, but what's yours with this particular plant?
Well, Santa Barbara honeysuckle is a native perennial shrub, and on this particular site, it's growing out of pretty much bedrock, cracks in the bedrock. When I have planted it in my restoration sites, it's quickly grown. It can grow to be 3 to 5 feet tall, and it produces these yellow-red berries. Copious quantities of them. The berries fall on the ground and they germinate. So pretty much after a few years, you wind up with more honeysuckle than you actually planted by a lot. So it's very hardy. It can be mowed down to the ground. It will resprout. And it'll be persistent. I mean, we'll probably have to remove some of it from the site after we plant it after a few years, just so that it doesn't take over.
I texted my friend Lisa Stratton, who I'm sure you know, and she's the head of the Cheadle Center for Biological Diversity out at UCSB,
Yeah.
and asked if she had experience with this plant. She said they have tons of it, and it's easy to grow. Is there anything you disagree with about that?
No, most of my restoration projects, we provide the seeds to a local nursery that grows the plants from us, from the seed we provide, and they would do that for this project as well. 1 gallon sized container pots grown from locally obtained sources. Yeah.
Okay.
Yeah, it grows quite well, and it's easy to grow. Santa Barbara Natives is a nursery that I usually contract grow with for my restoration projects.
Thank you, Mr. De La Garza.
All righty.
I had questions of
Any other questions from?
oh, I'm sorry.
I have.
Let's continue with questions from Mr. De La Garza, please. Mr. Reed.
Yeah, I just had Ms. Seinfeld made a reference to the plants being installed and with a spacing of 2.5 times their height. Is that their height on installation or their anticipated height?
Yeah, that's a really
when they're
good
grown?
question. So one of the things that we worked very closely with the fire department was to make sure that the habitat restoration plan would meet the defensible space requirements, the spacing between the plants. So when we designed this project, we built basically a spreadsheet that assumes what the mature plant size will be after 5 years.
Okay.
Yeah.
Otherwise, I think we're going to wind up pruning them all the time, but no, thank you for
Yeah.
that answer.
Well, there will be some of that as well, because plants do spread and grow.
Okay, so this honeysuckle is pretty vigorous, right?
Yes, it can be quite vigorous, although up there at this elevation, it's probably going to grow a little bit slower than some of my other restoration projects down on the coast.
Oh, great, thank you.
Very helpful. Thank you, Mr. De La Garza. And your question next, Mr. Park.
Is that Mr. Mel? Do you mind coming to the podium? And can we go to the elevation slide? Who controls the? It was in Ms. Steinfeld's presentation. There was a slide with elevations. Bingo. There you go. That's perfect. Handsome design, Mr. Mel. I'm sure you've thought about the area for a long time.
We have, yes.
Yeah, okay. This shows eaves, and I'm surprised to see extensive eaves in a high fire area. Could you comment on this? Has this been reviewed and met fire department standards for those eaves?
Well, the roof is a metal roof, and it comes down to a metal eave, which runs back to the building itself. So that's all metal.
And has it been reviewed by county authorities?
The fire department hasn't gotten into that kind of detail yet, because we're still in this planning approval stage, not in the detailing stage.
So it'll be looked at in the future at some point?
Yes.
Okay. How big's your house?
1,600 square feet. We wish it was double that size.
I'll bet.
Small kitchen, small dining, small living room. We have 3 bedrooms, so 1,600.
Well, it's cozy.
Pardon?
It's cozy.
Yes.
There you go. Well, thank you, Mr. Mel.
Thank you.
And I do like your design.
Hold on just a second, please.
I have a couple of questions.
Mr. Reed has a couple questions for you.
Yeah, I would agree with Commissioner Park. I think the designs are beautiful, but what we deal with so often is issues of fit rather than a great-looking design. I do have a question, though. It appeared up on the second story. The exterior material, are those shingles?
Those are. They're a composite shingle with concrete and wood fiber. So it's fireproof.
That answered the other half of my question. All right, thank you very much. Yeah.
My pleasure.
Thank you. Any other clarifying questions of a general nature? I see none, so we should continue with public comment, please.
All right. We don't have any speakers online, so we'll just go with what we have in person. If you haven't submitted a speaker slip yet, please there in the back of the room and just bring that up. So our first speaker, and I apologize in advance for any mispronunciations here. First speaker will be Tal Avitzer, to be followed by Dr. Arthur Olgin, to be followed by Paulina Kahn.
Hello, my name's Tal. I moved here 42 years ago, and like most people, I came here for the beauty of Santa Barbara. And 30 years ago, I bought a house, a small house, at the base, near the base of the 154. And one of the nice things about the house is we had 8-acre field behind it that was undeveloped. And about a month into living there, I had a friend visit from LA. He's a lawyer and developer, and his gears were spinning. He said, "Oh, we could build big houses here." And the feeling I got was, wow. I mean, I'm not against building, but it wasn't in scale with the small houses in my neighborhood. And I think it's comparable to what's going on in Painted Cave. And during the Painted Cave fire back in '90, I wasn't living there, but I was living nearby. And I saw how in 2 hours that fire just came and jumped the 101. It was scary. It threatened our house there. So I think I agree. I think most people in Painted Cave aren't against the development. It's probably just not to scale to what they're used to in that neighborhood. And the fire, I had friends living up there. I visit often. One visit, I was coming down from Camino Cielo on Painted Cave Road, and there was a truck blocking the road, bringing horses in or something. I thought, what if that happened during a fire? And I spoke to a friend, and sure enough, I guess that did happen during one of the fires. So the fire concerns, I agree, there are concerns with the road. That's all. Thanks.
Thank you very much.
Good afternoon. I don't even know if it's morning or afternoon, so.
Still morning.
Still morning, okay. Honorable Chair Ford and members of the Santa Barbara Planning Commission, first of all, I just want to thank you for your public service, because I have seen some of the most prepared and excellent questions that you are asking of the participants here in today's meeting. And for me, that's a rarity to see. I would like to see more of that among public officers, and so I really do congratulate you for work well done. My name is Arthur Olgin. I'm a resident of Santa Barbara for 34 years, and I speak today in support of Ms. Peterson's appeal of the Laurel Springs Retreat projects. Clearly, considerable work has gone into the project and its review, but substantial and glaring problems exist that should halt this project unless and until the defective proposal is cured. I have limited time, but I am in large agreement with Mr. Catillo's December 1st summary to the Commission. The several documents and expert opinions really provides substantive justification, in my opinion, to accept Ms. Peterson's appeal. The CEQA exemption is not reasonable or lawful, because I do believe that there are considerable new information, new relevant and substantive information that's been collected in the past decade. And it's certainly, and in fact, I'm very surprised and rather appalled that the Eastern Goleta Valley Planning Report failed to include any kind of wildfire impacts or associated risks. It's just amazing to me that was absent. And so many people have talked about the very high wildfire hazard zone. So I won't speak about that, but it does concern me greatly. I have investment property in Ventura, and we were 2 blocks away from that fire a couple of years ago that started in Santa Paula and came through Ventura, 2 blocks away from my residence, my tenants, tenants with families, disabled family members. And so I have a very awareness and concern about the potential for fire. And that fire came through Ventura to Carpinteria to spread to Montecito, and it was really very concerning to me. Last of all, I will say that as a researcher and a professor of psychology, over the past years, I have encountered a number of, in fact, a succession of tragedies that have unfolded that have impacted community members and traumatized them from loss of fire, loss of family, friends, dwellings, their personal effects, and certainly their memories. And I think that these events result in lasting emotional scars that can affect their lives long after the ashes and debris are cleared. Victims of the LA fire just in January leave a very visible impact upon me. Again, my experience with my tenants a couple of blocks away from a large moving fire, it raises very great concerns. So I urge you to support Ms. Peterson's appeal. Thank you.
Thank you.
Paulina Khan will be our next speaker, to be followed by Rich Robar.
Good morning, Planning Commission. My name is Paulina Khan. I live in Mission Canyon, have lived there for 50 years. The Laurel Springs LLC project must be denied a land use permit. Please uphold the appeal. CEQA is needed. Decisions have been made that violate the Eastern Goleta Community Plan and the County Comprehensive Plan. The small lots, 10 at 8,712 square feet and lot 11 at 10,454 square feet, are environmentally sensitive habitat lots. That means all species, not just plants, that can only support a small 1,500 square foot home, including the garage, and still support the ecology, the total ecology of the rare and endangered species of the ESH. The planned homes with a total of 6 bedrooms, 2 studies, 8 toilets, can easily support 82 residents with 2 sets of bunk beds in each of the rooms. The 2-car garages on each lot and 1,480 square feet of parking lot can accommodate many vehicles. There seems to be no limit on the number of residents in any place, but the larger the house, the more residents there can be. The plans totally destroy the environmentally sensitive habitat, killing 11 of the 12 rare plants, and maybe that's changed since I read, because you're saying other things now, and covering nearly all the land with structures, tanks, hardscapes. The only soil left is a not ideal 6-foot wide setback along part of the solid 6-foot high fence and solid stone walls and a few square feet in the front setbacks. Please uphold the appeals. Thank you. I would like to know why lot 11 doesn't have a street number. Thank you. Thank you very much.
And our last speaker on this item is Mr. Robar, unless there are any additional slips. Okay.
Hi, my name is Rich Robar. I've lived in Santa Barbara for 45 years. Bought a house directly across the street from this proposed development. As someone, I've had my entire life turned around as a result of the soil samples that they took at this development. As soon as they did that, within a week, I started losing my voice. So you can tell it's very hoarse. I will probably lose my voice during this conversation, but I was diagnosed with aspergillus. Aspergillus is a fungus that comes out of the ground. It took over a year for that to finally kind of go away. I'm much better now, but suddenly now I've got penicillin, which is also a fungus, which is from the same spores as what came out of the ground. Now they're going to start building a house 100 feet away from me that is going to raise up more dust, more dirt. There are 2 other houses, my very next door neighbor, who unfortunately had to leave, and Michelle Peterson, who all have compromised lung issues. We're all elderly. We're all in our 60s and 70s. This is going to go on for a couple of years, and it's a well-known fact that construction dust and dirt and all the stuff that's involved with that causes lung issues with people that have compromised lung issues. And I'm one of those, and I'm wholly opposed to this development. And I would really like for you all to think very seriously about what these people are going to be doing to the elderly, which is most of the residents in the Painted Cave. I also would like for any one of you, in fact, all of you if possible, to just put yourself in our shoes and drive down Painted Cave Road. Try it 3 times and see if you don't run into somebody coming up Painted Cave Road, or vice versa, as you're going up Painted Cave Road, if you don't run into somebody going down. You have to stop, you have to back up, get off the road. Most of those places don't have enough room. On our way down here, we ran into a roofing truck that blocked our way down. We thought we weren't going to make it to get here in time for this hearing. So I challenge all of you to give that a shot. Go down that road or go up that road 2 or 3 times. And I guarantee you're going to run into people that are going to prevent you from easy ingress or egress. Imagine that during a fire when there's panic and people trying to get out of there. There are switchbacks on that road. Somebody's going to hit the tree. So there's a tree that's right there on the edge. Somebody's going to hit that tree, and it's going to stop everybody behind them from getting out, and there's nowhere to turn around. We're going to end up just like the people in Paradise. And I have that in my head. I know that's going to happen. So thank you for your time.
Thank you.
And Ms. Robar was our last speaker on this item.
Thank you very much. Now I'd just like to mention, as we continue to wrap up this item, that I'm going to give the appellant time for rebuttal, and then the applicant time for rebuttal, and finally the staff a time for closing comments. So let's begin with, would the applicant like to rebut?
How much time would you like to?
What do we usually give? 5 minutes or so?
That
Would
should do
be
it. Thank
enough?
you. I'll be as.
Thanks. Let's stick to
Thank you,
5
Madam
then.
Chair. Mark Shatillo on behalf of the appellants here. We heard the applicant try to assign motive to my client's intention and the concerns of the community without a basis, and that's not, there's not an objection to any development on this property. Let me just be clear for the record that development on this property is acceptable. It just needs to be the right development. It needs to fit with the neighborhood, and there needs to be a consideration of what those impacts are. We have offered to meet with Ms. Steinfeld for a rational, fact-based discussions about this project, and we've not had that invitation accepted. So we are trying. We recognize the rights of the owners with respect to the parcel that they own, and we're trying to articulate the interests and concerns that the community has with respect to this project. It is not no development, it's the right development. The project as proposed is not the right development. One of the pieces is the water company. We talked about that. The water company, there's no leadership here that's expressing support for the project. In fact, I think probably there's evidence to the contrary in public comment. But one of the major concerns is that the Painted Cave Water Company is not able to deliver modern water pressure or volumes. They have on their books a request for a major upgrade. I think it may be a $20 million upgrade is needed. They don't have the funds for that. The hydrant that's that's required to be in front of this project, this parcel, lot 11, won't be able to deliver anything close to water, and I think probably it'll remain hooded until there is the upgrade to the main to the fire company or to the water company's entire water system. It's a huge undertaking. The water supply is an issue that needs to be discussed and evaluated in the environmental document. The tank is going to only provide so much protection. And that leads to my second point, is that we're even now hearing that there are other pieces of the project that need to be disclosed. And again, this is why we do the environmental review process, so that we can see, kick the tires, what's the whole project? Ms. Steinfeld indicated that now there's going to be external fire sprinklers. Well, with external fire sprinklers, you have a drain on your water system right away, in addition to the internal ones that are required. They're not a bad thing, but they create a tension with the availability of water supply when your first responders get up there and they're counting on 2,500 gallons of water to be able to address a structural fire. If it's a wildfire, it's kind of all bets are off, as you heard from Mr. Hazard. We had raised the issue in the appeal about the stone walls, and it was that the foundation of the stone walls were going to further eclipse the roots of the oak trees in that area. That was the concern, not that stone walls were not appropriate. And then as we look further into the plan, we see that also there's no reflection of the water piping to connect to the water tank. In the drainage, the trenching. So you've got impacts to root systems throughout the project and the existing oak trees that just aren't disclosed yet. The project description is incomplete. The project called for rain barrels, but those are going to be in the 0 zone, and you generally can't put plastic rain barrels in that area. So how is that? There's a lot of incomplete pieces. And you've heard, obviously, and considered Mr. Hazard's testimony with respect to the wildfire risk and what really needs to be done here. By approving this project, you do need to consider offsite impacts. In fact, that is one of the critical pieces of the exemption. And that helps, the environmental review process helps give full disclosure so that you, decision makers, and we, the public, can recognize and understand and avoid and mitigate any potentially significant impacts. There has been a sea change in wildfire law and impact analysis and knowledge of evacuation that does bear on your consideration of this project. Ms. Steinfeld referred to a case without citation where the change in law wasn't considered to be a justification for exemption or exception from the exemption. There's only one case that I'm aware of, published decision, the Hilltop decision. It did not address that issue. And let me just read from that case. It stated that, in summary, kind of the holding of the case was the exemption permits streamlined review because the project's effects were already sufficiently taken into account and addressed in the programmatic EIR. And that's really the thrust of our argument, is that these impacts, these wildfire impacts, didn't exist by matter of law. Under CEQA, it's a new identified impact by our Attorney General's guidance that says you need to look at ignition impacts and evacuation impacts by state law that requires quantification of evacuation time. These are things that were not covered in the 2015 EIR, and they're the very core issues that we're concerned about, that the Painted Cave community is going to be an area where we're going to have a fast-moving wildfire under conditions where evacuation is going to be compromised, and there are going to be significant potential consequences. That's what we need your commission to recognize this project implicates.
Please wrap it up.
So thank you, Madam Chair. And in closing, we believe that there is a project for this site and the adjacent site, and that CEQA is the best path to ensure that we get one that's actually going to work for the needs of the applicant and for the community. Thank you, Madam Chair, members of the commission.
Thank you. Ms. Steinfeld, please.
Thank you for this opportunity. With regard to the case law I cited, it is included here. It is included in slide 16. This is Olin Properties Court v. City of Newport Beach. And that case was in the context of a prior EIR, which the lead agency had relied on to find that new information that changes in law, specifically changes in traffic impact analysis standards, did not constitute a new law creating new information under CEQA. And that was not in the context of a 15183, but it was a very similar analysis that was done under CEQA. In addition, the recent Hilltop case made it very clear that if a new project is consistent with a prior EIR, the county is required to rely on that prior EIR if none of the exemptions are met, which is the case here. It's not a categorical exemption. It is a statutory exemption. Statutory exemptions are absolute, and as you saw, require a very robust analysis, which is included in the staff materials. With regards to, I'm not sure where the confusion lies, but my client reached out to talk to Michelle on October 20th. I always believe it's best to get the lawyers out of the way and have neighbors talk directly to each other. She did not respond. I did talk to Mark Shatillo, and it didn't seem like he was interested in chatting about a reduction in project, but was more interested in seeing one of the lots not being developed. But again, I apologize that we didn't have a chance, and we did reach out to them. I also want to make it clear that the EIR, the Eastern Galita Valley Plan EIR, did evaluate wildland fire hazards, including very high fire severity zones. We knew in 2015 that this area and many other areas in the county were at fire risk. The EIR also addressed emergency response capacity, access restraints for mountainous communities, fire protection services, and cumulative wildfire risk. I actually have this chapter here, 4.9.2 of the prior EIR. Again, the project, though, it addresses and complies with all of these standards, also the more recent defensible space standards adopted in 2024 as a result of numerous consultations with the fire department. With regards, again, to these community fire concerns, all of these fire safety standards were addressed in the plans, and they were put together by a very diverse team of us. Again, the complaints that we're hearing today about the roads are community-wide concerns. And again, Laurel Springs, owner of both the large ranch and these two projects, are very interested in working with the community. And what we're hearing is we understand a lot of the existing homes in the area are not fire safe. We understand that. Our client understands the risk of building up here. But it's a silly argument to say that because the other homes were built before these more stringent fire requirements, somehow these new homes shouldn't be allowed to be constructed, even though they are properly zoned. And so I think instead of focusing on these two very modern homes, we would urge the community to focus on the community at wide. There's a whole host of fire measures that you can take that are very inexpensive that can be done for the entire community. So it seems to me that this should be a larger conversation with the community at large. With that, I want to thank the team and happy to answer any questions.
Mr. Park, please.
We don't always get the materials at the Planning Commission that maybe we need to rely on, and I'm not blaming staff because, it's like the Pacific Ocean, the number of documents that are out there that we could possibly rely on. And so I don't think we got the East Galita Valley Community Plan in our documents. Maybe I'm wrong, but I don't think so. It'd be like this high, right? And I do remember approving part of that plan that Julie Harris presented on wildlife things years ago, and I don't know whether that was the ultimate plan or an addendum to it or whatever. And I don't even remember being aware that it included the Painted Cave community. I'm wondering, in the chapter 4, is that what you were just holding up in your left hand?
Yeah, so chapter 4.9 includes public services and facilities, and it's 4.96 is where the chapter
Does
starts.
it specifically mention Painted Cave community?
It does, and I'm trying to find exactly what page that is. Law enforcement. I'm wondering if maybe Ms. Liu can do a control find, just if it references specifically the Painted Cave community in that particular chapter, the fire chapter, which is 4.9. Okay, yeah, if you give us all a minute, I'm just skimming. And most of these, I can read kind of the titles. I don't see a reference, but it's basically talking about the designation of the high fire severity zones and the mapping, what that establishes, and the corresponding regulatory framework, the different standards required for building code, requirements for fire hydrants, water storage tanks, fire sprinklers, defensible space, access, and then plan build out. So,
And that would all be logical because that's
Yeah.
describes so much of the East Coluta Valley area.
Yeah,
But
and-
Painted Cave is so unique in its access issues, in the size of the lots up there in the middle of nowhere.
They
and
do
and
reference the fact
buildings.
that the Painted Fire occurred in 1990 and what changes they made in conditions after that.
Yeah, but the paint fire, it went into Hope Ranch. It went all over the place. It didn't actually burn out Painted Cave. That's what was called the paint fire. But okay, well, somebody should show us that at some point. If there is something, I'd like to know.
Thank you, Mr. Park. And Mr. Reed, please.
Hi. I have a couple of questions. First, as to the occupancy of those homes, one of them is going to be by a family name of Hosea. Is that true?
So those are ranch. So the idea with providing homes for the ranch staff is that it would provide sort of a buffer where they didn't have to live the place where they resided. So there's no particular official designation, but the homes are going to continue to be owned by the same entity that owns the ranch, and they're either going to rent out to their own family members or to the ranch staff. So he was, I think, Josh was giving you an example of one of the ranch managers who has one daughter and a spouse.
Right.
So that would be 3.
Because I noted he said the Hoseas, which would be 3 people, would
Yes.
be in one of the homes.
Mm-hmm.
Okay. All right. The other will be for a family or?
For either, if any of their grown children are interested in moving to the area, they would offer it up to them, would be, the concept, or maybe even Josh himself.
So it's not intended to be used for short-term stays or anything of that nature?
No, not at all. And, there's no plan to turn this into a boarding house or a bunkhouse. We also don't think it's appropriate for students just due to the distance to UCSB and SBCC. So it's really just suited to a modern-day family. Again, the reason why these homes tend to be bigger is, especially in this area, a lot of folks work from home, so there could be space for an office. If I lived up there personally, I wouldn't want to be going down on a daily basis. I would want to be enjoying the natural beauty of the area, so.
Okay, and then I was a little disappointed. I always pay attention to letters and public speakers, and although a lot of the letters we got in opposition were to me a bit stale because they were from 4 to 6 years ago. We got a petition. I think it was stale because it addressed ADUs, so that didn't really influence me. But I think what does influence me are people that actually make the effort to appear either physically on the phone or online and express their opinion. We had 4 people here actually show up. We had, one who spoke in favor, who's a resident of the area, but of course, he's the architect, so I don't know if he counts. So, and I know Mr. Kaplan said that, that many community members were in support, but you didn't want to pit neighbor versus neighbor and have them appear or speak. But, we're hearing, we make our decisions based on representations we see and people who speak or show up, and unfortunately, I can't consider that.
And I appreciate you pointing that out. I believe we had at least 2 letters of support that were submitted into the record.
Well, one is from a Miss Hosea, who I would assume will be one of the residents in one of the homes, who said, well, the owner is very nice and considerate and helps them out a lot. But I would imagine that's what you'd expect someone to say. But in terms of just a letter of concern from someone in the immediate vicinity, I see none. And unfortunately, that does not help your position a whole lot.
I think part of that is that this is actually at the entrance. So the one neighbor is Laurel Springs, and then we have the appellant on the other side.
Right.
The areas across the street, that's also a continuation of the larger 160-acre ranch.
Okay.
So,
Well, all right, thank you.
yep.
And Mr. Park, please.
Just a quick question. This is, and I'm just going to ask you a question you already know.
Sure.
I think it's always interesting to hear about what people's intentions are, but I think we've learned that those always don't survive after a while if they're clearly stated. Ocean Meadows and Glida. You don't have deed restrictions that are going to implement these intentions about who lives at the house and how many people live there and whether they're related to the family or not, and that there will be no alienation, meaning sale of the houses by the ranch. These are what Mr. Zucker thinks now, but we don't have deed restrictions implementing that, right?
Correct. I'm not sure if those type of deed restrictions on number of occupants are legal under the fair housing laws.
I think
They're
there's
shaking their head.
there's a Supreme Court decision from the state of California that's based in Santa Barbara on occupancy that addresses that from many years ago, before you were born.
I think what I will say is that, the Zucker family has shown immense interest in the community. They've spent years, living at the ranch, doing a lot of no-till farming, a lot of really interesting programs, germinating oaks. There's a huge program. If anyone in the community is interested in an oak tree, please let Josh know. They have many. So I think what this shows is that, as you heard, and the fact that we've been in progress for at least 7 years just to get to this point in time for two single-family homes, this is not an easy place to develop. But the owners really love the area, right? They wouldn't put themselves out there if they didn't really plan to stay and plan to work with the community. And it just made natural sense that they would purchase the 2 vacant lots that were adjacent to the larger ranch for development to really ensure that they could have sufficient staff. The ranch itself is a very large property, 160 acres. It takes quite a big staff to run, even for just the personal use. So they see this as, again, being able to attract better ranch managers who would have a brand new home to reside, next door to the property.
Mr. Reed? No, Mr. Reed. That looks like those are the clarifying questions. Thank you, Ms. Steinfeld. At this time, I would move to have my colleagues and I deliberate on this issue, leading to... Oh, sorry. Staff wrap-up, please. Sorry.
Thank you.
5 minutes.
I think we're happy to answer any questions on there's been a lot of testimony, so if there's any additional questions with the staff report or any of our findings, we're happy to answer it. We do have Chris Olmsted, the fire captain, and I would like to ask him to speak because there has been a lot of discussion on fire requirements, and he actually reviewed the project, and I think it's fair to give him some staff time to speak to you guys about
That would be fine with me.
Okay.
That would be great, especially if he would address some of the issues that were
Correct, yeah.
specifically brought up by the appellant.
Correct, yeah. Chris, you on?
Yes, I'm on.
Welcome.
Hello there. Nice to see you guys. Do you want me to give any specific questions, or do you want me to just speak with my part of the review?
I think at this time I'd like to have you speak to some of the issues that have been raised.
Sounds good. So I was the fire captain that did the reviewing of the project. This has been a multi-year sort of review. It's been a couple different things, looking at both access, water, defensible space, with obvious good reason. This is a very high fire hazard area, and it does lend to more scrutiny over certain things. And so the fire code, although it gives us the ability to request a full-on fire protection plan, it is not the norm. It's more of like when we see it's suited for the type of project. And we typically sort of do that for more larger developments in regards to multi-units, track homes and those types of things. If we don't typically do it for like a single-family dwelling, although we ask for the components associated with that. So we looked at the water, we looked at the defensible space. We actually enhanced and had them provide landscape plans that would meet both their environmental concerns, because that's one of the things that's considered, but also to the fire-related concerns in regards to Zone 0, the building materials, and giving ourselves some space for vegetation management and the requirements of the fire-safe, fire-smart vegetation. Access is always an issue up there. One of the saving graces is there is 2 points of egress that some communities up in that area does not have. Both of them are not perfect, but however, it's access off of a public road. And so it limits the fire department's ability to put an onus on the development. And it's really the public agency or county roads for this responsibility on when they want to upgrade their roads or not. And looking at the addition of 2 single-family dwellings and the impact in regards to evacuation, it was determined that it would be a minimal impact in regards to just, again, 2 single-family dwellings. We looked at complying to the requirements set forth on the task-specific review. And we went back and forth on a couple different things, and in the end, they were able to at least come to the compliance that we have in regards to our requirements and review for that. One of the things too is also too, we've talked about the differences between the 1990 Painted Cave Fire and the 2019 Cave Fire, which burned a pretty similar envelope, not quite as further down, but there is quite a difference in regards to the building materials of the 1990s and then when the 19 Cave Fire happened, and we have no loss of structure. And so I think looking at, and the state requirements and local requirements do try to address in regards to Zone 0, defensible space, and building materials to help reduce and make the new structures safer. So like I said, we did look at, and the water system was insufficient for the public hydrant system, and so that was one of the requirements, is the water district had to say that they couldn't provide the system, and then they had to develop stored water is what they ended up using in hydrant for those 2 specific parcels. So again, I mean, it wasn't a mandatory for a fire protection plan that would involve fire modeling and staff. Now, it would be quite a bit different if we were talking about larger developments, and that was the standard that we took in this place. Coming from a county agency and the fire department, we don't want to be in a position where we're, say, by de facto taking people's properties. We want to work with them in the safest way possible to allow people to build, and that's the stance that County Fire has always taken. So,
Thanks. Please wrap up your comments.
yeah, I'm done if you have any questions.
Please, Mr. Cooney.
Thank you for taking the time to help us on this challenging project, and more specifically, challenging circumstances. Listening to your comments, it looks like they amount to the fact that the fire department, under your leadership, made some changes, made some requirements, tried to tailor the comments to the proposal, which is to develop 2 single-family residences. Am I misunderstanding what you say, or would you agree with me?
I mean, I think that's a fair aspect in some regards to, I think we always try to look at case-specific projects so that we take the codes that are out there and apply it to the application for that individual case. I think it's hard sometimes to just take a broad brush and not account for the specifics of the individual case.
One of the points that was made during our hearing was that we could move forward, but with respect to some of the improvements to the fire safety would require involvement of the public agencies where these homes are proposed to be built. And that puts you in an extraordinarily difficult position, does it not?
Definitely so. I mean, my understanding of some of the legal requirements of not putting of how we can put an onus from an individual property to build out, say, a county road in all aspects, and to have one parcel, say, make Painted Cave, which is almost impossible to make it 20 foot wide. There's a lot of constraints associated with that. So, yeah, it is a difficult situation sometimes.
And I appreciate that. Nobody is saying the county under your leadership did anything wrong, but it is important for us to understand that more could have been done under different circumstances if, in fact, the county was a participant in, for example, developing a better, safer exit strategy, and you didn't have the benefit of that, I believe.
Yes, it's hard for us to apply that aspect to a single family development. We have a lot more broader aspects when it's a broader based community where we're bringing in a whole housing development, but it is harder to look at that as a single parcel and where that lies.
Well, we could go on a long time. We've already spent a significant amount of time, but we're valued by your comments, and I'm sure we'll have more in the future. Thank you.
Thank you.
Madam Chair, leading
Yes.
up to deliberations, because there's been so much discussion on the CEQA exemption, and it is one of the less common ones that we see, I just wanted to bring up the framework on that once again, so it is
Please.
a little fresh for you. So Section 15183, it is a statutory exemption that mandates projects which are consistent with the established density per the zoning ordinance or general plan for which an EIR was certified. Shall not require additional environmental review, except as necessary to examine environmental effects which are peculiar to the project, new significant effects, which could potentially be offsite impacts or cumulative impacts not previously discussed, or significant effects that are greater than that that was found in the previously studied EIR. The exemption further goes on to specify that even if evidence in the record demonstrates the existence of a project-specific environmental effect, those effects shall not be considered peculiar to the project or the parcel if the uniformly applied development policies and standards that have come out of that adopted EIR would substantially mitigate the environmental effects of the project. And CEQA, it requires environmental review, but it does not require repetitive environmental review. So there are streamlining provisions and exemptions throughout CEQA, and that is what this exemption is. It's a streamlining provision.
Thanks very much. I appreciate that clarification. So with that in mind, I believe it is time for Oh, sorry, you're blending in with the Sprite can.
Okay.
Please, Mr.
I have a
Reed.
question for Mr. Olmsted. Is he still available?
Yes, I'm still available.
That, I'm looking at a letter you sent to Ms. King dated October 20th, where relative to this, it appears that letter is limited to your evaluation of the landscape plan. You say it's in the SRA very high fire hazard severity zone, and looked at the fact that you've reviewed the restoration plan and landscape plan. Is that the limit of your communication regarding your evaluation of this project, or is there something else I'm missing?
Well, sorry if I don't remember quite that communication, but it might have been something specific to answering a specific question of the landscape plan for that. I can't remember. It was not limited to solely to landscape plan. I mean, like I said, there was a bunch of precursors coming up to this in regards to water and access that were part of the review. And I might have not a comment on that specific letter because those were done prior to even the requirements for the landscape plan. It was really a start on, I mean, the first aspect was really, do you have the water system? So that was one of the early on discussions is you can't even build if you can't meet the water requirements in that regards. The county access roads was a little bit of, our fire engines would stay on the county roads. I knew that we were limited to what we could do with scope-wise in regards to access to county roads. But that letter was probably just specific to, hey, this was what was in response to a question. I wish I could provide more on the details of that letter, but no, there was more than just the landscape plan that we went over.
Okay, yeah, because during the hearing, we heard an assertion that, in fact, your evaluation should have been conducted with a greater degree of rigor than it may well have been. Do you have any comments around that?
Well, I mean, I guess we do these projects case by case. I did this exactly like I would do any other review in this aspect. I applied all the required standards and regulations that we have in the codes, and I would say no, I did a thorough job.
Okay.
Is there always little things you could, spend more detail on? Probably, but I don't think any of those little details missed the mark of what my review did do and my ability to safely put something out for this.
Okay, in the event this project, ultimately were approved and proceeded to completion, would it also be subject to further fire department review to assure it complies with all the relevant standards?
Yes, so we have two different review processes. Obviously, during the planning phase and the development request, we do an initial review on the land use and the planning and stuff, and really, is this a viable development? And then once all that stuff passes, we do, as a building permit review, we are part of the building permit process where it comes back into our section, and we do have the ability to put additional constraints. And that's when we do our more detailed view of the actual structure in the building itself in regards to what the features would be. So yes, to answer your question, there would be another review process if it was to pass, and as part of the building permit, we would have to do a review before the building permit would be issued.
All right, thank you.
With that, I believe we can move to deliberation. Who would like to speak? Mr. Cooney.
Thank you, Madam Chair. This is one of the most memorable hearings I think we've held in the time that I've been part of the commission, and I certainly would want to hear from everybody before suggesting the outcome. But I do want to make one comment clear. Nothing I said was intended to indicate that anything had been done incorrectly because of the relationship with the parties or the type of building was. I think our fire department, as I think as the proponent said, this is not anything that was done in a slack way. And there was a lot of attention, and there will be other steps if this project is approved that would involve the fire department. I think we should be proud of our fire department and all that has been done by firefighters throughout, and we've certainly had our share. Turning to this project, my inclination is not to approve it on the record we have before us. I think there are lots of attractive features in this project, and there's been engineering done to try and mitigate the fire danger. But honestly, I can't get by the point that if there was a fire up there, the next time there is a fire up there, did I do everything possible to call to everyone's attention, including the applicant and also the appellant, that there's a real problem here. And I don't think this record indicates that we've done enough. I would not be able to vote in favor if the project was continued. I would not oppose that.
Mr. Villalobos, could you put up the charge of this commission for the motion, the different aspects of it? Please. So to clarify, Mr. Cooney, you would not make a motion to deny the appeal? It's sort of.
I would vote not to approve the appeal, and I'm willing to make that motion. I wasn't shying away from that, but I just want to give proper weight to the decision to not approve this project.
Therefore, but the action is to deny the appeal.
The action is, as it's been my practice, I wanted to hear how my fellow commissioners felt about it before a motion was made.
Sure. Just trying to understand that you actually, based on what you've heard so far, are in favor of the appeal.
Correct.
Thanks. Mr. Park, please.
You know, Mr. Reed pressed his button first.
Please, Mr.
And
Reed,
he's so
then.
used to me talking so much, he'd like to go first once in a while.
You want to go first? I don't care. I'm sure you have something lawyerly to say. I'll go. I'm not a lawyer. I'm sure he has something much more intelligent to say about this.
Moving on.
But typically, well, how often do we hear we need housing? This area lot is great for a project, just not this project. We hear that consistently throughout the housing element every other time we have a hearing. Only this time I'm kind of moved to agree, perhaps. Normally I come to a hearing, have a pretty clear understanding and at least an inclination of which way I'm going to go on the issue. During this hearing, I've had the opportunity to ask every question I thought appropriate to help increase my understanding and create a basis for a vote on this. yet I find I am still a bit ambivalent on what's the best outcome. I think the one most concrete thing that surfaced during the hearing is Mr. Hazard's comments relative to the potential risks to life and limb of inhabitants of the area. That affords this greater gravity than many of the issues we're asked to make decisions on. I think with respect to that, therefore, since this lies in Commissioner Cooney's district, I find myself inclined to follow him in his action not to deny the appeal and to explore additional information with respect to safety and fire. So I guess the short answer is I'm with Commissioner Cooney on this.
Thank you. Now, Mr. Park.
I appreciate the comments of my fellow commissioners. Actually, what you're both proposing is about as clear as mud to me, but that's okay. We go through this process. I think, to be realistic, there's going to be houses built on those lots someday. I think, paradoxically, Ms. Peterson should count her blessings that these houses will be built by the Laurel Springs owners and that they've put so much attention to what's appropriate there. I don't imagine that anybody else who owned those lots would have done all that. I'm not surprised anymore on how long projects take, but the idea that this hearing took 2 years to occur after the actual appeal was kind of amazing. But there you go. But I think it's also unrealistic for the owners to think, and I know they don't think this because they've gone through all this process, but we can't just approve a project on the basis, well, we already got 20 plus homes up there, and they're all little houses, and a lot of them are wooden houses, and they're all crammed together. How Painted Cave came to exist and why it still exists after all these fires is sort of a miracle. But we have to do our best that we can under the current circumstances. And under the current circumstances, we have a lot of environmental laws. We have a lot of fire history here and throughout the state. I don't want to reiterate everything that Mr. Homestead said or the attorneys or Mr. Hazard. I think looking at section 15183, yes, it tells us to look at that prior environmental impact report, and it makes for a statutory exemption, but there are exceptions to that, and one is where there are peculiar circumstances, peculiar impacts that weren't discussed there, and I think we have that. And yes, as Mr. Holmes had pointed out, or somebody did, if those peculiar impacts are substantially mitigated by the applicable policies and development standards, then we don't even look at that as an exception. But I don't think that they are. I don't think I could find that. I have to look at this just personally on, would I be satisfied if 10 years from now we had a fire and it wiped out that community, and I was somehow responsible for making a vote that didn't, as exhaustively as possible, examine every detail that can mitigate fire problems there? I would feel remiss. I would feel horrible. So I'm prepared to vote with what I think Mr. Cooney is suggesting, and I wouldn't approve this project right now because if any project we would ever look at would cause us to exercise the discretion that Mr. Homestead referred to, that the fire department has, to say, yeah, maybe we're not required to have a wildfire protection plan, But this is one where we should. If it wasn't this case, where would you require it? And so I think it is required, that environmental review is required before this project can go forward, so that we have done the very best that we can. Thank you.
Thank you. And Mr. Martinez?
Thank you. This is a rarity situation, and of which I'm going to differ with my fellow commissioners on this instance, because the way I look at this is this. We have one project. It's on a parcel. That parcel is a single-family home. What you have up there is single-family homes. You don't have a boarding home. You don't have a restaurant. If you look at to the exceptions of the particular impacts, that particular impact has existed then and it exists now. That's why I asked Mr. Hazard, who can actually do the 20-foot roads you're looking for? The county. Nobody in this parcel is going to be able to fix this particular hazard. Okay? That's where I'm looking at and saying, well, when the comment was just made, well, we're not for no development, but not this development. I have a problem buying that, because when you look at the challenges of the appeals challenging the propane tank, well, they all have, the same appellant has a propane tank, okay? Then you look at the situations of that the argument was that the adjacent property that it was proposed lot was historically provided for recreational open space amenities. Well, that's stopping development, in my opinion, in regards to those things. So what did they do? They did the best they could within the parcel, which is what Mr. Hazard and I interpreted from him, was when you look at these plans, you're looking within the parcel. Yes, the wish is it goes beyond it. And what they did is the building materials within the structure, and they took special efforts to address these situations. This appeal kind of morphed. I thought this appeal was going to be about, oh, the water runoff is going to cause these damages and so forth. Like any good advocate, you hear what is catching the ear of the decision makers, and you bend with it. I'm in court all the time. That's what we do. I represent a lot of ranches and deal with a lot of issues, and I think a lot of these issues are actually being addressed through insurance companies. The most interesting photo that I found today was when the honeysuckle photo was brought up, and we were talking about the Santa Barbara honeysuckle, and we were talking at the same time, it just followed about looking beyond the parcel for a defensible fire. And what I saw in that photo was a bunch of trees surrounding the adjacent property house. So if we're talking about defensible fire situations, wouldn't they want those trees cut down? Because that's what we do. We know we have to cut trees all the way around at least 100 yards sometimes just to get insurance. Maybe the fire department, I know Mr. Hazard's shaking his head, but that's what somebody was talking about fire jumping to fire, to tree to tree to tree. And that's what I was actually looking at and saying, that sounds interesting to me. But so my situation is this, is that I believe the same particular hazard, the fire concern, is there for everybody right now. And these are actually people that are not buying into the community, that they actually have been part of this community. And they're simply asking for the same right to live in the community, if not build a single-family house there. And that's what I'm having troubles with in regards to what Mr. Olmsted said. There is a minimal impact, okay? And that's where I was listening hard to the issue of how many people can live here or and so forth. Well, I believe Commissioner Parker was completely right on in regards to there is that case which we always use, which say you really can't restrict how many people can go in, but there is a certain particular formula to it. But that formula would apply to this house as it would apply to any other existing house up there. Same standard. That's just my rationale, and I just wanted to explain it. Thank you.
Thank you. I would say I tend to agree mostly with Mr. Martinez. I believe that most of the concerns have been addressed. in humane and thoughtful ways. I am disappointed to hear that the applicant and the appellant have really not spoken much to each other. That would have been something positive for me. I do think so many of the concerns we have raised today are the community's concern. They're Santa Barbara, they're the state, and they're this area. May not actually apply to this one particular applicant. So for that, I tend to think that this could be legitimately denied. So with that, would anyone like to make a motion?
I don't want to make a motion. I just wanted to, because I wanted to leave that to Mr. Cooney, but I did want
Yes,
to
please.
just elaborate a little bit on your point that it's disappointing that this matter could not have been resolved by the parties. I join in that because with my crystal ball, which is of course cracked like I am, I would see that when you have houses that are the largest in the neighborhood and they are twice the size of the architect's house, and they're 4 times the size of Ms. Peterson's house, that there's some wiggle room. And the size of the houses will make a difference on how long they take to construct, meaning how long it will take to bring materials up and workers and so forth. And it'll make a difference on the amount of flammable material up there. It will make a difference on defensible space that's available. It'll make a difference on how many people occupy the place over time. And it would seem to be significant. And I think in some circumstances, the parties would have gotten together and worked out that issue, and that would have, obviated some of the concerns that come up when we want to see a wildfire protection plan. But that didn't occur. So here we are.
So you're agreeing with me about would have been nice for the people to talk?
I
And
do.
possibly could have come up with a solution.
Right, but I'm still my position that as this sits in front of us now, I think we need a wildfire protection plan more.
I understand.
review, and I would tend to agree with Mr. Cooney if I read what he said right.
Mr. Cooney, please.
Often our staff, excellent as they are, has the whole would-be motion laid out, and I see it isn't quite applicable here. What we're talking about is an appeal by neighbors of the developers. And so I'm just going to shorten it to say that we can't ignore, shouldn't ignore, the location of this project and the neighbors, some of whom live in the area, have turned to us to at the least, require every issue that they question in this very high fire, as was pointed out, area. So I will vote to deny the appeal, and I've got it backwards.
So Madam Chair and Commissioner Cooney,
Please.
before we do that, as Commissioner Cooney knows, currently today, and I think I'm looking down the road as far as what Commissioner Cooney is the motion is going to be. Right now, if the motion would be to uphold the appeal and deny the project, we don't have those findings in front of us. And so we would be looking for a motion to continue the item and direct staff to come back with findings for denial. And then we'd want specific instructions on what findings that the commission cannot make. And then we'd prepare those findings and bring them back. So as it stands right now, we're not able to have a motion to uphold the appeal and deny the project. So we'd have to continue it for that. The way it's set up right now is to deny the appeal and approve the project. So we would, if that's the motion, then we would look to staff on a date that we'd want to continue that to come back with findings for denial.
That's fine.
Yes, thank you, Mr. Wilson. I think if you are going to continue it to recommend upholding the appeal and denying the project, staff also needs direction on which findings you would like us to write about in terms of denial. You need to give us some substantial evidence based on today's hearing.
Well, I look to work with you on that, but I think you're well qualified to come up with the appropriate language by the date that we agree upon. We'll turn back to this. I could give you my ideas, but they all come down to fire safety and the difficulty of the area of the proposed project.
So, Madam Chair and Commissioners, if I could help Commissioner
Please
Cooney
help
frame that a little bit.
with the
I
wording,
think-
the framing.
I think you're looking, the direction is that the finding related to being consistent with the comprehensive plan, which is the Eastern Goliad Valley Community Plan, is that, what I'm hearing is that you're unable to make that finding that it's consistent with that comprehensive plan due to wildland fire safety issues. And that could help staff as far as looking into that. I'm seeing heads nod, so if that's the direction, I think staff has enough to be able to write. Still getting head nods. We're so hungry, we're not talking anymore. So, I think
We just want to be accurate.
so. The request would, the date I believe would be February,
Sure. Let me look.
and we need to make sure the appellant and the applicant are also available for that date. But I think a date that
He's not going to.
Is January 28th too quick?
Give us 1 second. Is January 20th? Okay, we can try it. Yeah. We'll try and make that work, yep. Yep.
So January 28th. May I add one more item to the mix, which is, would there then have to be a separate motion for continuance for the item number 2?
So, Madam Chair and Commissioners, that is correct, because we're not hearing item 2 at this point. We'd have to read it in the record and then have a motion to continue that. But as of right now, we haven't heard that project. I
That's right.
understand that it's similar in nature, but we would have to take that as a separate
Okay,
action.
we'll do it separately then.
Ready?
So we have, the dates would be January 28th, February 11th, and February 25th.
I'm sorry, say that again, Mr. Wilson.
So for the applicant and the appellants and staff, we're looking at January 28th, February 11th, and February 25th.
Mr. Chatilla?
Madam Chair, members of the commission, the 28th of January is acceptable. The 11th, I have a physician's appointment, and the 25th, I'm not available. So if we had to do it, I'd try and redo the 11th, but my preference would be January 28th. Cannot do the 25th.
And then, Madam Chair, if we could have the applicant representative speak to the dates.
Perfect.
All 3 dates work for us, but we would prefer the first available, which is January 28th. Wait, sorry. January 28th. 28th, yes.
I think we're ready.
I
Excuse
had a question about the findings. I think you've well described the concerns Mr. Cooney had and I expressed about fire protection plans and associated things. I also heard from staff that there's a compatibility standard that's been imported in through the general plan from the East Goliad Valley plan. And I would be interested in exploring a finding that refers to that, because I think that's an independent finding, and it deals with size and things like that. I think size, as I argued before, is subsumed in the as an issue in the fire plan thing, but it's also a separate item that deserves at least a chance for us to see a finding that refers to it.
Madam Chair and Commissioners, that we will add that to the findings as well.
Thank you. So I think at this time, I know that Mr. Cooney has an interest in making a motion.
That's true. My motion is to continue this matter to the 28th of January, 2026. And at that hearing, we would consider staff's recommendation with regard to the findings that we need to support whatever action is taken.
Is
Do
there
you
a
need
second?
more, Mr. Seward?
Chair and Commissioner Cooney, is your motion to direct staff to prepare findings for denial for your consideration?
Everything you want is
Thank you.
in the motion. Thank you.
I'll second that motion. Would you like to take a roll call vote, please, Mr. Villalobos?
Yes, thank you, Madam Chair. The
Continue.
vote is to continue the item and for staff to draft findings for denial. Commissioner Cooney.
I see mics are on. Is it just for the vote?
Yes.
Okay, great. No, fine.
Commissioner Cooney.
Aye.
Commissioner Park.
Yes.
Commissioner Reed.
Aye.
Commissioner Martinez.
Nay.
Chair Ford.
Aye.
Motion passes 4-1.
Okay, take a deep breath, and we're going to go on to number 2,
So Madam Chair and Commissioners, just managing time.
please.
It's almost 1 o'clock, and I think we do need to have a lunch break at some point.
We will.
Because there's a much awaited workshop that we're hoping to have today. So just looking at item 2, to continue, we do need to read it in the record.
Yes.
The framework on that, though, is if the commission desires to continue it, then we do need to have public comment on any motion to just continue it. If the commission wants to hear public input or public comment on the project itself, then we need to hear the project and have it presented. So that's the kind of framework as far as how we want to address item 2. I know those items the project issues are similar, but we need to be able to afford the parties the ability to present and articulate those issues.
So are you saying that we should formally ask each one of them, or just continue this till after lunch?
So, Madam Chair, we can take a break now and then bring item
Number 2 back.
2 back. And if you want to hear item 2 today, then we can hear item 2 and take appropriate actions. If the commission doesn't want to hear item 2 today, we can just continue it to the same hearing. But it would only be to continue it to the next hearing and just hear it for the first time.
If I could restate what I think you're saying, though, we could read it into the record and then ask for any interest in presentations and public comment before we would make a motion for continuance?
No, let me rephrase it. So
Please.
what I'm not saying is we can't make a motion to come back with findings for denial until we've actually heard the item. So I was skirting around that, so I'm just going to say it. So the options for the commission then is if the commission, for time management, wants to say, we're just going to continue that item, we're not going to hear it, then we can bring it, read in the record, indicate that we're not going to hear it, we're just going to do a continuance, we'll just take public comment on whether to continue it or not, and then close public comment. If the commission wants to evaluate the project, then we need to hear the project and then have a motion on the merits of the project, which may be similar to the motion we just had, but we need to go through the project in order to get to that motion. So that's the balance is, do you want to hear the project today and get to a motion and continue it to the same hearing and deal with them on the January 28th? Or do you just want to continue it, but which will create a staggered effect on the projects? If I was the applicant and appellant, I'd just want to hear it today and then know that I have to come back with those findings on both of those projects.
I agree. But in wanting to hear it, we don't necessarily have to have the full presentations. They can be denied that opportunity. They can say no.
So, Madam Chair and Commissioners, I think the appellant and the applicants can truncate their presentations.
Yes.
And staff as well. I think we've gone through enough this morning, but I'd leave that to them. And you may want to bring them up after we read the record and see how much time they need on those.
Okay.
Then we can take a break and come back after lunch and bring the project back up. So if you would like to, Chair, get an idea from the applicant and appellant how much time they would need, then let's read it in the record, and then let's talk to the appellants and applicants, and then go from
Sounds
there.
exactly like what I was hoping to do. Great. So with item number 2, Mr. Villalobos, could you read it into the record?
Yes, thank you, Madam Chair. The following is a hearing on the request of Michelle Peterson, appellant, to consider case number 23 APL 38, to consider the appeal of the director's approval of Laurel Springs Retreat LLC new single-family dwelling residence case, project number 21 LUP 209, and to determine that the project is exempt from CEQA pursuant to Section 15183 of the state guidelines for implementation of the California Environmental Quality Act.
Thank you very much. And now I would like to ask each of the presenters how much time they think they would need for this item, keeping in mind what we decided on item number 1. So staff, how much time would you need?
Less than 5 minutes, Chair.
Thank you. And Mr. Titello.
Just a couple of minutes.
Thank you. 5. That is a total of 12. Shall we continue or come back after lunch?
I'd do it now just because there's so much of the audience is here for this project. And it'll give us an ability to focus on what we do next.
We have agreement to do it now, so I'd like to ask staff. Please come forward for your presentation.
Ms. Chair and Commissioners, I will be presenting the Peterson appeal of the Laurel Springs Retreat LLC new single-family residence.
Thank you. Go for it.
The project site is shown in red. The parcel is located within Painted Cave and is directly adjacent to Lot 11. Michelle Peterson owns the property outlined in blue. Here is the proposed project. The site plan shows the houses in yellow and the garage is in orange. Purple shows the fence and wall, and the habitat restoration plan is in green again. Here are the elevations. The appellant claims the walls and fences were omitted from the plans. However, the plans clearly show the stone wall and fence, and the biological analysis evaluates them in full. The appellant argues the landscaping does not meet defensible space requirements and stormwater management is inadequate. However, County Fire has reviewed and approved the landscaping plan, and the project does include comprehensive drainage measures. The appellant asserts the project ignores its relationship to the Laurel Springs Ranch and that the parcel has served as community open space. However, staff confirmed the site is privately owned and contains no public access or open space rights. The appellant claims the applicant illegally graded the site and that baseline surveys were conducted after habitat disturbance. However, a county inspection in 2024 found no grading violation. Surveys were completed in 2022 before any soil testing and accurately represent existing conditions. The appellant argues propane use is unsafe and should be replaced with electrical alternatives. However, propane use is legal and common in rural areas, including by the appellant. The underground tank meets all county fire standards. Here, the appellant asserts the project may cause sediment runoff and requests upfront erosion control plans, as well as a Chumash monitor. However, the runoff claim is unsubstantiated. The project includes long-term stormwater controls and an erosion and sediment control plan. A Phase 1 archaeological report found no cultural resources, so no Native American monitoring is required. The appellant argues the project requires further CEQA review due to resource constraints. However, the project qualifies for CEQA Section 15183 and does not require additional CEQA review. All right, lastly, the appellant asserts the project is inconsistent with the general plan, but does not cite any specific inconsistency. As discussed in detail in the staff report, the project is consistent with all applicable policies. This is a single-family home on a parcel zoned for that use. The community plan and its EIR anticipated this exact type of development. Because the project is consistent with the plan's policies and density and presents no new or unusual impacts, it qualifies for CEQA Section 15183. Staff recommends their commission deny the appeal, make the required findings to approve the project, determine the project is exempt and no further environmental review is required pursuant to Section 15183, and grant de novo approval of the LUP. That concludes my presentation.
Thank you. Before we continue, I want to make sure I follow procedure and also ask for any ex parte reports on this particular project. And so I would ask my fellow colleagues to restate what they have done. Who have they met with, please? Mr. Reed.
I had a November 18th video conference with Ms. Seinfeld and Mr. Kaplan.
Thank you. And Mr. Park.
I had an on-site meeting last week with Mr. Kaplan and Ms. Steinfeld in a meeting with Mr. Chitillo last Monday.
Thanks. Mr. Martinez.
Thank you. I had a Zoom meeting with Amy Steinfeld and Mr. Kaplan last week, regarding this project.
Thank you. And Mr. Cooney?
I had a Zoom meeting with Ms. Steinfeld, and let's see, that was earlier this week. And then separate from that, I had a Zoom meeting with Mr. Chitillo.
Thank you. And I also met with Amy Steinfeld and Josh Kaplan, who represented the applicant last week, and they met me at the site, so I was able to tour the site. And I met on Zoom with Mr. Mark Chitillo, representing the appellant, who shared the perspective and concerns of the appellant. And all of those are stated in the documents which were provided to the commission. So if there are no questions for the staff's short presentation, thank you. Do you have one?
No.
Great. Then we will move on to the appellant.
Thank you, Madam Chair. I'm Mark Chitillo on behalf of the appellant, Michelle Peterson. In light of the previous commentary, obviously you have a full agenda, and so we want to move this forward quickly. Lot 10, the subject of this matter, is very similar to Lot 11, with one fundamental distinction is that the adjacent landowner is also the applicant. So that affects the defensible space calculations. We would prefer to simply incorporate all of our prior comments and testimony from Lot 11 into this item, Lot 10, with the chair's support and I think council confirming that that's acceptable. All the exhibits that have been submitted to each of the items, exhibits A through Q, and the testimony given here, particularly the testimony of Mr. Rob Hazard. With that will culminate my primary submittal. Our request to your commission today is that you uphold the appeal and deny the project and adopt the following findings. And direct staff to consider these particular findings. One, that the project is incompatible and inconsistent with the wildfire impact policies in both the Eastern Goleta Valley Community Plan and the general plan's safety element. And land use policy number 4. I think those are 3 separate findings that are appropriate to make here with respect to the wildfire issues. Secondly, that you adopt, you direct staff to consider adoption of findings to support the denial of the project based on inconsistency with the Eastern Toledo Valley Community Plan's biological policies. In particular, because of development standard number 6 of the County Fire Department development standards, which does allow and indeed require adjacent owners to participate in defensible space, given the fact for this project that the applicant owns both sides of that property line. The third and last finding that we would ask that you adopt would be under CEQA, to make a finding that the project is not subject to Section 15183's exemption because there are particular circumstances that reflect significant impacts, that the project entails issues and impacts that were not addressed in the Eastern Toledo Valley Community Plan EIR, which, by the way, the fire policies are included in our exhibits, Exhibit B. Thirdly, that the CEQA finding is that the project is likely to cause off-site and cumulative impacts. And lastly, that there's new information of significance that indicates that there will be significant impacts that were not considered in the EIR below. We think your prior discussion on the last item addressed the general plan conformity and consistency issues generally. I tried to give you a little bit more specificity on the categories and issues that I think would be appropriate to direct staff to address. In addition, the CEQA issue is critical because that is the path to developing the information. We all recognize these are lots that should be, that are appropriate for development at some point. Let's provide the tools for identifying and giving the applicant and the community an opportunity to refine exactly what are those appropriate developments. And the CEQA process is the way to do that. So we respectfully ask that you do include also the CEQA findings in your, in any findings that you might direct staff to adopt concerning upholding the appeal and denying the project. Thank you.
Thank you.
Any questions?
Mr. Cooney.
Mr. Chatillo, the comments that you just made are detailed, and I don't think we should proceed on the basis of our inability to get them down correctly. But if you want to take the next 15 minutes or so to get to staff what you just made, then we could consider that when we reconvene.
That'd be fine. So are we contemplating we'll take a break before? Okay.
Yes, I think.
Madam Chair and Commissioners, thank you, Commissioner Cooney, for time. This is recorded. Staff can go back and review everything you just said.
Okay.
So we don't need to prolong this anymore.
Okay, great.
Thank you.
But it would be helpful that you do direct staff in accordance with that so that they have that direction. Thank you very much.
Thank you. And now the applicant.
Thank you, Chair Ford and Commissioners. I'd just like to clarify one thing. Is there an ability to have a rebuttal for this?
Yes, there will.
Okay. Okay, so I would also like to incorporate my prior presentation into this particular Lot 10. And I'm going to focus on a few of my previous slides that I want to emphasize a few things. I'm going to go to slide 17. Here. So I just want to again go through the fire standards because I think it's very important to see, again, this project spent 2 years working with the fire department, working with various consultants to determine that we are in compliance with all of these. So first of all, again, the county fire department has reviewed the plans, issued a condition letter. So there was an earlier condition letter that was done back in, I believe it was 2021, and then we have a more recent condition letter in 2025. Secondly, the project biologist, we even hired a landscape architect. That took another several months, and the county fire department was very clear that they wanted to have sufficient spacing. We also worked, as you know, we did a ton of research with various biologists, landscape designers, and various fire departments throughout California to determine which plants, truly native plants, were truly low, considered to be not very flammable. So we incorporated those into the proposed landscaping plan. The project is conditioned on payment of fees to offset any costs associated with the fire department. Those will be paid as part of the project. You look at this development standard number 6, very extensive plans. We worked through this. This addresses all of the defensible space. Again, we are incorporating, and we've worked with staff to incorporate that we have a minimum clearance as set forth above around the buried propane gas tank. You know, we understand the neighbor has fire concerns like everyone in this community, but we're a little bit confused because if you look at her house, for example, there's a large oak tree over her entire home. So we would just hope that all the neighbors would be concerned and also want to create defensible spaces around their own structures. So we hope to see that in the future. I'm going to go on to see slide 18. Again, I think it's important that we walk through some of these factors. So again, coordination with county fire department, the planting pellet, the underground propane tank, the water tank. 2 5,000-gallon tanks will be installed, one on each of the properties. I also want to point out that Laurel Springs Ranch, you know, obviously we're very disappointed in today's proposed findings that will be before you for consideration in a few months. You know, they've owned these properties for 12 years just to get to this point. And, you know, I think for the owner, you'll hear from him, is that the neighboring ranch has a very large pond that has always been used for fire protection services. It also has 84,000 gallons of water storage. Again, has always been made available to the community. The neighboring ranch as well has always been open to all of these community members to gather for as long as anyone, including Rob, who has lived here for 40 years, can remember. So it's very disappointed that, you know, it feels like no good deed goes unpunished. We spent exhaustive time with a series of, I think there was upward of 10 consultants on this project to really ensure we presented you with the best project. Again, we looked at every single construction material. These materials are not even required at this stage, but we wanted to make sure you understood that the construction materials all would be fire resistant. These are very expensive materials, but again, we feel that it would be important. So I do want to point out one factor that was not applicable to Lot 11, and that is we understood there was a lot of concern from Mr. Chatello. The letter that we also received Monday afternoon was that there was concern that there was a gas fire pit and a spa proposed on Lot 10. So we are here today to voluntarily agree to remove both of those from the project plans. And let's see, I'm going to end with water. Oh, actually, sorry, I had one more slide, and this also just pertains to Lot 10. Mr. Chatello had raised concerns over whether removal of a 1930s structure, we believe it was used as a residence, it's located on Lot 10, would adversely impact any of the oaks. And so Mr. De La Garza has prepared a report to demonstrate that removal of the shed, this old structure, can easily be removed without disturbing the coastal live oak, and that tree protection fencing will be installed during the demo process and before the new residence is constructed. So again, I just wanted to make sure that it was clear that we would not be disturbing the root, critical root zone or the canopy of that particular protected tree. And then lastly, there's been a lot of claims, misinformation over water. So these two projects, so just first of all, the projects do not overlie an overdrafted groundwater basin. This particular area is not designated by the Department of Resources as being under threat by overpumping. As you know, this is a very sparsely populated area. And the Painted Cave Mutual Water Company has actually done an incredible job. It was established back in 1931, and since then it's been serving, you know, upwards of about 175 residents. I think that number is important for all of us to see because you can see that, you know, if there's roughly 70 homes, there's roughly 2.1 or so per home in this region. And the Mutual Water Company pumps clean water from the San Ynez Mountains. The only item or constituents that they have to treat for are naturally occurring iron and manganese. And my client has worked very closely over the past several years with the Mutual Water Company to ensure that both lots not only have active meters and that the Mutual Water Company has sufficient supply to serve both projects, they've also invested in the infrastructure to bring this clean water to these two projects. So as you can see, and this is in the record, the Mutual Water Company issued two can and will serve letters to both of these lots confirming sufficient domestic use. So with that, I want to turn it, well, I guess we'll just wait for a rebuttal at this point. I think we'll reserve 3 minutes.
Thank you. So do we have public comment?
We did receive, excuse me, at least one public speaker slip this morning for item number 2 from Mr. Robar. Did you wish to speak on this item?
I'm okay, I'll pass.
And we have if you're attending online and would like to speak on item number 2, go ahead and raise your virtual hand and I'll call on you. No hands raised.
Thank you very much, Mr. Chitillo.
We'll waive rebuttal. Thank you.
Thank you. Staff?
Madam Chair, we do have rebuttal for the applicant.
I know. Does the staff have an opportunity for?
They'll do
They
it after
come
rebuttal.
after the
Yeah.
applicant? Thank you. Applicant, please.
Commissioners, this is really difficult because we've gone through, like, frankly, we don't know what else to do. We've done every single thing, every request that's that's been asked of us from every department in this county, and by a lot of the neighbors. We've done it. We brought you a really beautiful project, and unfortunately, some of the information you've heard today is just inaccurate. And one of the things that you heard today was that we have not attempted to reach out to Michelle. I have a text that I sent to her that she read on October 20th that refutes that. And I'm happy to show this to any of you.
Thank you.
Madam Chair, with your permission, just a
Quickly?
Yes. Just on this issue of communication, I contacted Ms. Steinfeld. In fact, we talked before this thing started, and I asked that all the communications that were coming from the applicant to Ms. Peterson come through me and through my office. And I made that request a couple of times. And that's the way we would like and prefer to have this. And after the text, I contacted Amy, and we're open, but we just, we do
Okay, one
want-
last comment, please.
Yeah, I just want
This
to say
can't be back and
I
forth.
had a conversation with Mr. Sotillo. We asked to sit down, and he said, really, there's nothing to discuss. My client would not like to see development or would want to see a much, much smaller project. So he just expressed.
And that was not in October this year. That was 2 years ago.
Okay.
Madam Chair,
Thank
this
you.
is
That's
not
it.
fruitful discussion,
This
and
is-
and I
this
think
is
the
fine.
parties should have discussions in private with each other over the next month or two,
Which
and
is
that
what
would be
we
fruitful to
expressed.
hear about.
Thank you. And now, staff.
We have no comments.
Wait a minute.
None at all.
Thank you very much. Okay, I think we're at the point now where there can be a motion made if there's no further deliberation. Mr. Cooney.
Can I just say I approve of the continuance to the date we have selected, the 28th of January, right?
Yes, I'd recommend that the motion be just to continue this item to January 28th and direct staff to come back with findings for denial.
So moved.
I'll second again. Roll call, please.
Commissioner Cooney.
Aye.
Commissioner Park.
Aye.
Commissioner Reed.
Aye.
Commissioner Martinez.
Nay.
Chair Ford.
Aye.
Motion passes 4-1.
Thank you. It is now time for a lunch break.
Madam Chair, what time, just so the people who are coming back for items number 3 and 4 on the agenda so we can give them an idea of what to expect?
Sure, of course. What is generally what we take? An hour. So let's come back at 2:30.
Thank you.
Thank you. Good afternoon again. This is Kate Ford with the Planning Commission, and we are reconvening with item number 3. So let's begin. Please, Mr. Villalobos, could you please read it into the record?
Yes, thank you, Madam Chair. The following is a hearing on the request of the County of Santa Barbara Planning and Development Department for the County Planning Commission to consider adopting ordinance case numbers 25 ORD 9 and 25 ORD 10, and to determine the ordinances are exempt from the provisions of CEQA pursuant to sections 15061B3 and 15265 of the state guidelines for implementation of CEQA.
Thanks very much. We'll continue now with the staff presentation. Please introduce yourselves, and will 15 minutes be a long enough time for you?
Yes, thank you, Madam Chair. Good afternoon.
Please.
Alex Tuttle with Long Range Planning. I have with me Karina Martin, project planner, who will be walking through the presentation. We know you've had a pretty long morning and a big item coming up, so we'll try to get through this as quickly as possible.
Thank you, Alex. Good afternoon, Madam Chair and Commissioners. Again, for the record, my name is Karina Martin, and this afternoon I'll be presenting the 2025 General Ordinance Amendment Package for your Commission's review and consideration. So the purpose of today's hearing is to review and recommend approval of an ordinance amendment package before you. Thank you. That is intended to keep the zoning ordinances accurate and up to date by clarifying, correcting, and simplifying existing provisions within the LUDC and the coastal zoning ordinance. It is common practice within the department to bring forward a package of amendments to ensure regulations are up to date, to correct errors and omissions within the code, and to improve the overall function of the codes. So to summarize, the ordinance amendment package before you includes minor amendments to the Ag Enterprise Ordinance that the board adopted last year, proposes to add provisions to exempt art, garden, and architecture tours in the coastal zone, implement revisions to existing state density bonus law provisions to comply with state law, and finally, to initiate minor other amendments to correct, clarify existing regulations. So starting with the Ag Enterprise Ordinance, the LUDC amendments include minor clarifications that are found in attachment C1 that clarify ag enterprise use structures allowed with a zoning clearance or a land use permit do not count towards development plan thresholds. They also remove an inconsistent development standard regarding planted acreage for small processing facilities. And finally, some minor revisions to the tent, cabin, and yurt definitions. Now moving on to the art, garden, and architecture tours. Your commission may recall reviewing and recommending approval earlier this year for similar provisions in the LUDC that the board adopted in May. And these proposed provisions will facilitate temporary community events such as artists, garden, and architecture tours in the coastal zone by expanding the temporary use section to exempt art, garden, and architecture tours from a planning permit subject to specific standards, which includes limiting these events to 4 times a year, no longer than 3 days per event, opening these events to the general public with or without ticket sales, and up to 300 attendees per day, and that receptions or parties associated with these events be limited to non-residential zones. And then finally, a standard that is not currently included in the LUDC, but we're proposing to add, is to include a standard clarifying that an exemption does not apply, or the exemption does not apply to properties operating with a CUP unless expressly authorized or conducted in accordance with that CUP. And now with state density bonus law provisions, your commission may recall that this is a state mandate that does allow developers higher density and other incentives in exchange for building affordable housing. And on September 24th of last year, Assembly Bill 3116 was signed into law, and the bill added additional benefits for student housing development. It also provided a definition for student housing development, defining it as containing 2 or more bed spaces. It established parking ratios for student housing, which essentially is no required parking for a qualifying project. And then it also included incentives or concessions for projects with at least 23% low-income affordability. And again, we're just updating the existing provisions within the LUDC and the coastal zone to comply with this recent legislation. And now on to the other minor amendments, which can be found on page 4 of the staff report before you. Starting with the LUDC, these amendments include simplifying front yard setback requirements to end up with a single standard regardless of the lot being greater than or less than 100 feet in width, to correct a subsection error in the telecom ordinance, clarify the number and category of ADUs allowed on a lot, clarify the floor area calculations are in gross square feet and not net for consistency, and then to revise the lot interior definition to remove unnecessary language referring to subdivisions, as well as to correct a typo in the street primary definition to appropriately reference the circulation element, as well as to correct a subsection error in the road name section for procedure standards and signs, and finally to update the mobile home park conversion noticing requirements to reference the civil code section. There are similar amendments that are being proposed in the coastal zone. They're all listed on this slide, but I'm just going to go over the changes that are specific to the coastal zoning ordinance. And that includes incorporating initial application review procedures that are existing practices in the LUDC and MLUDC, so staff is proposing to carry those over, as well as to add a new definition for flood control that is consistent with the Gaviota Coast Plan overlay. And the amendments also revise the major public works project and major energy facility definition to comply with Coastal Commission regulations, clarify the total setback for plant protection structures on lots containing 5 or more acres is 60 feet or 80 feet respectively. And finally, to clarify for lots greater than 12,000 square feet, that up to 750 square feet of an attached 3-car garage is not included in the floor to area ratio calculation, which is also consistent with the Summerlin architectural guidelines, and that it would be specific to the Summerlin area. And then on November 19th last month, staff presented a similar package of amendments to the Montecito Planning Commission, where they voted 3-2 to recommend adoption of the MLUDC amendments, as well as an ordinance to repeal the Montecito Growth Management Ordinance, and then to recommend adoption of the Coastal Zoning Ordinance amendments with a minor staff edit to Section 35-68.7.4 for clarification to the total setback for plant protection structures. So the proposed ordinance amendments to the LUDC and CZO are recommended to be determined exempt from environmental review, as they would not result in any new significant impacts or increase the severity of previously considered impacts. So as a result, no new environmental document is required pursuant to CEQA guidelines 10561B3 and 15265. And finally, the recommendations for today's ordinance amendments can be found on page 1 through 2 of the staff report dated November 25th. And to summarize, they're to make the required findings for approval, including the CEQA findings that are found in attachment A, to determine that proposed LUDC and CZO ordinance amendments are exempt from the provisions of CEQA, and finally, to adopt a resolution and recommend approval of the LUDC and coastal zoning ordinance amendments found in attachments C and D. And this concludes staff's presentation, and staff are available for any questions your commission may have. Thank you.
Thank you very much. I'd now like to open this up for any clarifying questions from my colleagues. Mr. Cooney.
Sorry, I didn't get it off fast enough.
No problem. Mr. Reed, please.
All right, this is going to be easier than last time I said. I only have one question so far. This has to do with the revised definition of tent, cabin, and yurt. Okay. I note it says tent cabins may include a limited 12-volt power for lighting, mini refrigerator, then doesn't include things. So conversely, does that mean a yurt cannot have those things?
Commissioner Reed, through the chair, yurt and tent cabin are the same, so a yurt would be able to have those same amenities.
Okay, well, then why, I'd like that sentence better than if it said tent cabins and yurts instead of just a tent. I realize the only basic difference is a yurt is a cylinder and a tent cabin is cuboidal, but I mean, I can live with it. I see where it could create confusion.
Madam Chair, Commissioner Reed, understood. The way it kind of works is if you go to the definition for yurt, it says see tent cabin definition, so kind of brings you back
That'll take
to
care
it.
of it.
So they're treated the same in that regard.
Great, thank you.
Mr. Park, please.
Yeah, I'd like, on the same definition, I'd like to ask a little bit about the 12-volt power limitation. You can just explain what that's for.
Commissioner Park, through the chair, the intention there is to provide some limited basic electrical supply to support things like some lighting or like a little mini fridge, but not the level of electricity that would normally be found in a more significant permanent structure. So these are intended to be kind of low use, low intensity, with minimal amenities, which kind of differentiates them from something more substantial like a park mod trailer. This was the issue that we discussed heavily during the adoption of the AEO.
Because I'm thinking of some yurts that I've seen in recent months. We approved yurts in the El Capitan development that are to be newly installed, and at least the photographs of those show refrigerators and microwaves. And I'm just not familiar with a microwave can be operated with 12-volt DC. But those are under a CUP and not under the AEO. So I presume if somebody wants to do something different and they get a CUP, they can do that. And then and I've stayed in the yurts at the Kachuma. You know, they're operated by the county, and they have little heaters. I guess you call them a portable heater. And those operate off of 110 AC. So those have 110 AC. But again, those aren't yurts or cabins or tents or whatever you want to call it under the AEO. So I presume that doesn't really matter. Is that correct?
Commissioner Park, through the chair, so I can't speak to what's at the county facilities. As you know, has come up before the county park or a state park or a national park are not subject to our same regulations. But the intent here with this a little more precise of a definition for the tent cabins and yurts is to kind of strike the balance between providing a reasonable use of these structures for purposes of the temporary occupation while ensuring minimal conflict with building code requirements because of sort of the more temporary nature of these facilities.
And is our building department comfortable with inspecting these with the 12-volt DC?
Yes.
Okay, I think that's important because I've seen some, I don't know what I would call them. They're hybrid type structures. It kind of looks like a tent, but it's got walls and so forth inside. And they're prefab walls. They've got 110 AC, and I don't understand how anybody could inspect that unless they inspected it wherever it was built. And these are prefabbed in China and sent over here.
Yeah, and I think one important distinction to make, not to get too deep into the and relitigate all the AEO, but if you recall, with the Ag Enterprise Ordinance, you have a property owner has the opportunity to do camping type of use, or they can do a farm stay. With farm stay, you have a lot more flexibility in terms of the type of accommodations you can provide, and that's where you can have more permanent type of structures where you could have full electrical and wastewater hookups and things of that nature. So trying to kind of hold that sort of differentiation between what's really intended for that low level, more camping type use versus what's more appropriate to be treated and permitted as a farm stay.
Well, with the benefit of 2020 hindsight, I wish that we'd had this definition, when we did the AEO, but it fits what we all talked about and certainly what I intended. And so now we have it. So thank you.
I see no further requests for questions. So, Mr. Villalobos, are there any public comments?
Madam Chair, I believe all the speaker slips I've received are for item number 4, but just for those attending online, if you'd like to speak on this item, go ahead and raise your virtual hand and I'll call on you. No requests.
Thank you very much. Then, if there are no further questions, we can move to deliberation on this item by the commission. So, colleagues, any thoughts that you would like to share? Or a motion? Mr. Reed, please.
Well, in the absence of any comments or objections, I'll stick my neck out and make a motion that we make the required findings for approval. Determine that the case numbers 25 ORD 009 and 10 are exempt from CEQA and adopt a resolution recommending their approval. Attachments C and D to the staff report dated November 25th, 2025.
Thank you. Do we have a second?
I'll second.
Thank you very much. I'd like to call for the roll call, please. Roll call vote.
Commissioner Cooney?
Aye.
Commissioner Park?
Aye.
Commissioner Reed?
Aye.
Commissioner Martinez?
Aye.
And Chair Ford.
Aye.
Motion passes 5-0.
Thank you very much. Mr. Wilson,
Madam Chair and Commissioners, can we take 3 minutes to set up for the next item?
please. We'll go on to the workshop, item number 4.
That was short.
Item number 4, this is a workshop on the recreational master plan countywide and comprehensive plan amendments related to it. Mr. Villalobos, could you please read the hearing item into the record?
And thank you, Madam Chair. The County Planning Department and County Parks Division will conduct a workshop with the County Planning Commission regarding the upcoming comprehensive plan and ordinance amendments related to the Recreation Master Plan.
Thanks. Let's continue with the staff presentation from a combination of the Community Services and Planning Departments. I know I have a lot to share with us in this workshop, so please feel free to stop at intervals as you'd like to request questions or feedback from the Commission.
Good afternoon, Madam Chair and Commissioners. Thank you for bearing with us. I know it's been a long day. This project before you has taken several years to get to the point where we are now for an update to the Commission, get some direction as we move forward to the next phases. With me today is Tina Mitchell, Senior Planner with the Development Review Division with the Planning Department, and then Jeff Lindgren, the Assistant Director of the Parks Division of the Community Services Department. And I'm the Assistant Director of the Planning Department, and I'll be wearing 2 hats. I moved just to shake things up a little bit. Commissioner Cooney's already off center because he doesn't know where I'm at. But, so I'll be sitting over here helping out with the presentation, and then my colleagues will be presenting as well. So with that, we were here in August and September of 2023 with the workshop as we began to move forward with drafting amendments to the comprehensive plan, specifically the recreation section of the land use element, and then we also moved forward with doing amendments to the land use development code. We anticipate the amendments that we will be sharing today, the draft amendments, will be able to be incorporated into the Montecito Land Use Development Code as well as the Coastal Zoning Ordinance. But as far as the purposes of today, we'll be just focused on the Land Use and Development Code as far as the ordinance amendments that we'll be sharing and talking about today. So with that, I'll turn it over to Jeff Lindgren, and he'll move us through the presentation. Next phase.
Oh, good afternoon. Hope you all had a good Thanksgiving holiday. Hopefully there's no tryptophan left in your systems because we're going to be talking throughout this afternoon quite a bit, and hopefully it'll be a little more interactive in a workshop format that you normally may have. I'd first like to acknowledge some of our team, our consultants. Taylor Lane with WSP is helping us with our EIR, and Erica Leachman with Bornstadt Consulting, who is helping us with completion of the Recreation Master Plan itself. And then, of course, my colleagues here who have put in endless hours helping write amendments to help implement the Recreation Master Plan. The slide before you shows a little bit about what we expect to do today. I'm going to brief you on the second revision to the draft of the Recreation Master Plan, and I will move through that pretty quickly. All of the information that I share today is available in the Recreation Master Plan, as are all the backup documents that were used for research and development of that plan. They're all available online for your use and the public's use as we go on. And then I will talk a little bit later about an interactive map that we've created that I think will be useful for the public and yourselves. And then we'll move on to what's an important part of this, which is an effort to create some amendments to the comp plan and to the zoning ordinance that will help implement the recommendations out of the Recreation Master Plan. So that's where we're headed, and I'll get started.
Please.
Next slide, please. You got it, thanks. As I said, we'll launch into the Recreation Master Plan. Next slide. Just quickly here, some of the goals for the Rec Master Plan are listed here. Essentially, we created this plan to assess and guide development of parks, recreation, and trails across the county. The plan provides vision, direction, and recommendations to improve recreation across the county, and really is foundationally based in working with the cities in the county and state parks and a little bit with the feds in advancing recreation across the county. Next slide, please. As we began development of the Recreation Master Plan, we identified the 5 recreation planning areas that you see on your map. We have the Cuyama Valley, the Santa Maria Valley, the San Ynez Valley, the Lompoc Valley, and the South Coast region. The large blank white areas on your map are Vandenberg Air Force Base along the coast and Los Padres National Forest on the eastern side of the county. Those areas kind of set the foundation for how we would analyze recreation needs across our county. Next slide, please. Here's the steps we took in creating the Recreation Master Plan. It started out as a very kind of conventional planning study where we did an inventory of existing facilities, we did some demographic analysis, we created a needs assessment looking at what was missing from the inventory of existing recreational facilities and trails across the county. We did a pretty extensive outreach program and then drafted the Recreation Master Plan to kind of summarize all of that information and present that to you. And today we're transitioning from that purple stack to that orange stack where we are beginning kind of our adoption phase, where we will be, working with you today to gather some feedback and from yourselves and from the public who's here today. We will be going out into the community following this meeting and then returning back in 2026 to your commission for consideration of the amendments and recommendation to the Board of Supervisors. Next slide, please. This is very exciting. Long time coming. A lot of people have tried and failed to create a map of all of the trails in our county. It's just a lot of energy and work that goes into this. But with the help of Mark Wilkinson and the Santa Barbara County Trails Council and the Conservation Blueprint folks, we were able to assemble this GIS map. This map will be available online and is interactive and allows you to zoom in and zoom out and click on different features and see what either those parks are, the polygons are parks, and then the dotted lines are the trails, and you can see who owns them, how big they are. You can get information about the facilities and the features that are in each of those parks. Will really be a nice tool that we can keep updated and help track our progress with the recreation plan in the future. Again, all this information is available on our website, sbcrecplan.com, and you'll see that come up throughout this presentation. And next slide, please. Just start to summarize a little bit of what we learned during the recreation planning process. Here's a quick summary of the amount of parkland that's available in our county. This does not account for open space, which is mostly natural lands that do not always have a recreation function. Where we do have open space with a trail on it, we account for that in our trail inventory. So it is counted, but this just shows you our parks across our county. We have a couple beach parks. We have a majority of our parks in what are smaller, more community-based parks and neighborhood parks, which generally don't have parking or restroom facilities and that sort of thing. Next slide, please. Again, this is a summary of our trails. Recreational trails are your natural surface dirt trails that people use for riding and hiking. And then the community/MPT trails, that's a multi-purpose trail. That's more of what you would see as a paved trail someone might ride a bike on for commuting purposes as well as exercise and recreation. So you'll see certain trails like that throughout our county. And then, of course, the Los Padres has an extensive network of trail system, and the state also does too. So overall, 1,100 miles of trails. Next slide, please. This slide indicates our effort to quantify what we learned about recreation in our county. We developed a series of indicators to determine levels of service. That's what the LOS means on their screen. The traditional one is the first one, Parkland LOS. That's the number of acres per 1,000 residents. And the county has an established policy from 1980 that we still use, and that tells us how many acres per 1,000 people that we need. In general, with all these indicators, we are pretty much on target. I'll walk you through these real quick, but you can read in detail all of these in the Rec Master Plan itself. Park count is just another very simple, how many parks per 1,000 residents. Key facilities gets a little bit into some more detail where you start to look at, do we have baseball fields and soccer fields and skate parks that accommodate what we need in the county? So we counted all of those as well, and this information is all in the plan. Trails, what are the miles of trails per recreation planning area? Neighborhood access, we're starting to look at some equity issues here, like how close are parks to where people live? Can people easily get to parks? And then active transportation is another indicator that we looked at. It was important to look at our recreation system from a lot of different perspectives instead of just using the traditional one of just acres per number of residents. So we've done that here, and you can see the results of all this in the plan. Next slide, please. This was a tremendous effort. Our community outreach component, we received over 8,000 responses to our survey. We had, I think, 86 different public outreach events. And we're able to gather input and feedback from a variety of sources. About halfway through this effort, we recognized that we weren't getting feedback from certain communities in the county, and we decided to contract with some not-for-profits in order to help us gather more input from communities which are typically more difficult to reach. So they already have built-in constituencies with these nonprofits, so they could go to the folks they work with on a daily basis, and they could query them on recreational needs within those communities. But we got a lot of positive feedback about our rec system, and I'll share with you that now. Next slide, please. What we heard was the community would like new and improved recreational facilities. In particular, and this won't be surprising to anyone, but it's active sports complexes, swimming pools, skate parks, soccer fields, basketball courts, all the things that you wouldn't be surprised to hear from the public. Next slide, please. Luckily, this really synced up with what we had analyzed in our levels of service analysis, and then we broke all of this information down by our 5 planning areas, and you can see what the priorities were for each of the different recreational planning areas. They're quite similar. We see trails, we see active rec, and we see swimming pools in almost every category. Lompoc has a very nice swim complex run by the city of Lompoc, so they don't have that same need identified in the Lompoc Valley, and Cuyama Valley has a swimming pool run by the county. So they don't have that need either, but very consistent across most of the areas here. Next slide, please. We learned a few other things about our park system while we were out there. People want to see lighting for extended hours and security. They'd like more community events in their parks. They'd like to see additional park rangers to enforce rules, things like that. So all of this is summarized in the plan. Next slide, please. And then as a result of all this analysis, we have designed a set of projects that are intended to respond to the needs that were found in the plan. And those projects
are outlined in the plan. There's about, I think there's 27 of them. Those are all projects that are on county lands and that the county can actually bring forward over time. Then there's another set of plans that were suggested by the community, or we know that there are other folks in the community who are interested in pursuing these. We don't have control over them, but we wanted to acknowledge them in the plan and give them the benefit of some of the environmental review that we'll be performing. Next slide, please. Here's a couple of the projects, just spotlighting them for various areas. One that's active right now is in the Lompoc Valley, Vandenberg Village Park, and that's an exciting project that's finally getting off the ground after years of community efforts to get that park built. We also are working on some trails in the Solomon Hills outside of the Orchid area, and then right now exploring an opportunity for a sports park in the Goleta area. Next slide. So, of course, the plan has to address funding. All these new parks and trails will generate a need for financial support. So the plan outlines various funding sources that could be available to help support these types of activities. Grant programs are traditionally a strong point for us. Grants have become more competitive and scarcer for communities like ours. A lot of the funding that comes out of the state is targeted towards larger metropolitan areas, so it's more difficult for communities like Santa Barbara County to be successful in those grant programs. But most importantly for the rest of today's discussion is the implementation programs. So the traditional set of tools for building parks in our county has been conditioning projects to add recreational features to their project. A lot of our ability to do that has been diminished with changes to state law that doesn't allow us to condition those types of projects any longer. I mentioned the difficulty in acquiring grants. So all of these things combined mean that we need some new tools for creating additional recreation across our county. And that's the main point of the rest of today's presentation, is to look at how these amendments to the land use element and these amendments to the local or to the zoning ordinance that will help implement these projects. Next slide. So as we move forward here, I want to acknowledge that one of the things that we're working on today is completing the rec plan as a vision document, but also initiating these implementation elements of the zoning ordinance and the comp plan changes. But also recognize that you'll probably hear some comments today about the agricultural enterprise ordinance. This is not the agricultural enterprise ordinance, and it's easy to see why people get confused about it, but this is a plan that is intended to support recreation in the county and is not tied to the agricultural enterprise ordinance. And with that, I think we move on to comp plan.
To follow up on what Mr. Lindgren just mentioned, that's why we're here today with the Planning Commission. This is partnering the Planning Department efforts with Community Services Department in really implementing the vision of the Recreation Master Plan. So in order to do that, we identified that the comprehensive plan, specifically the recreation section, needed to be updated. It needed to be in alignment with the goals and objectives of the Recreation Master Plan. And then the next step then is to align the ordinances to implement the changes in the comprehensive plan and also support the Recreation Master Plan. So in true recreation style, Jeff Lindgren is going to lead us in calisthenic exercises to wake everyone up.
Excellent.
Okay. Just wanted to, it's been a rough day, so we wanted to bring it back. So the rest of today is going to be talking about the amendments to the comprehensive plan and the proposed ordinance amendments. And again, the focus is how can we support the Parks Division efforts in creating this recreation master plan? How can we support that? And one thing that Jeff alluded to earlier was what tools, what opportunities can we do to create public-private partnerships to get resources to the Parks Division that we might not otherwise be able to do. So we're going to get into that a little bit later. So we'll move into the comprehensive plan amendments. So over the last several years now, we've been working on drafting policies and goals. The first was updating the recreation section of the land use element. The last time it was updated was like 1980. So we wanted to freshen it up, bring it up to current timing, make it up to date, make it relevant to the goals and objectives of the Recreation Master Plan, focus on community needs, focus on how to create opportunities for more park facilities, focus on the health attributes of it, on communities being part of it, really encouraging recreation and also encouraging like a fresh look at recreation and how that can improve our quality of life. So that's really the intent behind the updating the recreation section of the land use element. We're not going to do a deep dive in that. I'll let you read that for bedtime stories tonight. But we do want to highlight the policies and goals that we have provided in the packet. There's a lot of effort and attention that went into drafting goals that would match the intent of the recreation section as well as the intent of the recreation master plan. We have 4 overarching goals to implement this vision, and with it, not to any surprise to anybody, we did come up with 32 policies. I think before there might have been like 4 or 5 policies, but in true planner style, we have 32. So we're staying strong to our values of a lot of words. So the next few slides, we're gonna walk the commission and members of the public through the goals, and we're gonna highlight some of the policies. We're not gonna walk through 32 policies. I know you may be wanting to do that, but we're not gonna do that today. We're gonna highlight some on the screen, and then we'll take a break and get any feedback from the commission as far as any of the policies or the goals or directions, and then we'll move into the ordinance amendments. So we'll move over to highlighting some of the goals and the policies. And Ms. Mitchell will walk us through the first 2 goals.
All right. Thanks, Mr. Wilson. So as he said, on the next few slides, we'll walk through some of the main themes of the 4 new parks and recreation goals that will be part of the land use element amendments. And then we'll also look at a few example policies for each goal. So starting with goal 1, this goal emphasizes the need for public recreation and to ensure that facilities are welcoming and convenient to all people in all types of communities. Here are a few examples of draft policies that fall under goal 1. These policies require that new recreational facilities incorporate inclusive design and variety in the types of recreation offered. There's also a policy that mentions the Recreation Benefit Program, which we will be discussing in detail later on in this presentation. But this policy states that projects under the Rec Benefit Program must meet a recreational need identified in the Recreation Master Plan or other adopted county plan. Goal 2 focuses on the desire for creating networks of trails in the county that connect urban, rural, and beautiful natural areas. And again, this is just a small sample of the policies for Goal 2, and the full text is included with the summary document for today's workshop. But in general, the policies under Goal 2 will focus on good trail design, locations, and connectivity. And then I'm going to go back to Mr. Wilson.
So Ms. Mitchell indicated earlier about this public-private partnerships and the Recreation Master Plan. I think that's what most everybody's here today to hear about, and it's like the last thing we're going to talk about. So stay tuned, that's spoiler alert. Goal 3 is really the glue that's going to put a lot of this together when we're talking about not only public-private partnerships, but also interagency cooperation. And with the goal of supporting recreation, supporting different ways to create recreation, park facilities, and trails throughout the county of Santa Barbara. And when we look at the policies, under Goal 3, just to highlight a few of them, again, it talks about this cooperation between cities, counties, state, local, to identify opportunities for public parks, recreation facilities. On the screen, the last one talks about, that's the one that we're focused on, of trying to think outside the box. And that's the one that the county shall facilitate and promote this public-private partnership. And that's that recreation benefit program, which allows for members of the public to come in with a substantial in-kind contribution that will then provide some incentives to their projects, and that will be able to create greater opportunities for recreation facilities that may not otherwise be able to be funded or obtained through normal means. So that's one of the key policies that we're focused on, and we wanted to have ordinances that supported that and implemented that policy. And then we'll move to Goal 4. So Goal 4 is talking about the quality of life, and that goal is supporting creating these visually attractive, sustainable parks that are integrated with communities, that help support not only the visual aspect of it, the quality of life, and that it's really part of the community. And then the policies associated with that have to do with creating these high-quality parks, recreation facilities, and trails that are designed to be interconnected, integrated with the community. And then the last one is, paying attention to, as we're integrating our recreation facilities to the community, to the natural area, that they become part of it, and we're minimizing impacts to the recreational aspect of it. So that wraps up the 4 goals and a quick highlight of the policies with them. It's hard to show our passion and excitement of it in this setting, but this is exciting trend that we're trying to go through, is promoting recreation and really touching the lives of others through recreational goals and aspects. So moving on to the next slide. So we're going to transition. Well, we'll take a quick break. Any thoughts, reactions, Tara, on the policies and goals that we've shared briefly with you today?
Mr. Reed.
I noticed, you had a pretty comprehensive survey of trail types in the county and things like that. I was wondering, is there any sort of inventory on ADA compliant trails or recreation, for people in chairs, things like that? I noticed in one of the objectives, there's a reference made to, in Goal 2, unique users. Is that referring to ADA individuals? Because I'm certain that there's a need, and they do need to be incorporated into this.
Yeah, Chair Ford, Commissioner Reed, yes. So ADA law requires that many facilities incorporate accessibility. So we will continue to acknowledge that as projects move forward. But we'd like to go a step beyond that, and that reference does try and expand, kind of the typical understanding of wheelchair and walker accessibility, so that we're looking at things that can be more sensory oriented in certain circumstances, playgrounds that have multiple features to them that children with a variety of disabilities, say hearing disabilities or some other disabilities, could also enjoy those facilities. So yes, we are trying to incorporate all of those things into the plan.
One more question. I know the county is moving toward adopting an environmental justice plan, and for those communities, some of the goals are more facilities and things for physical recreation. Are these two going to be coordinated?
Chair Ford, Commissioner Reed, yes, we've been directly involved in helping to develop the environmental justice element, and there are several actions in that element that relate to, Parks Division and how we can help implement that plan.
I have a couple questions for you. Well, you used the term that you were going to develop a rec print. Is that what we see on slide number 7, or is a rec print something else?
Thank you, Chair Ford. That's we're taking the concept of a recreation plan and a blueprint
Yes.
set our direction, and we kind of playfully came up with the term rec print as a way to kind of market that, I guess, or model that in some way. But the rec print would ultimately be kind of a living, dynamic document that's available online. So it would be this map that would allow people to interact with, the rec facilities across the county.
Okay, thanks. And forgive my naivete, but what's a pocket park?
Oh, Pocket Park is often just a very small little park within a community. You'll often see them in a developed community that has an HOA, for example. That's just a small park for children in the community to go and use. Not always are they public.
Right, okay. And then also, I saw that you surveyed 875 kids. Do you have an idea of the age range, and how did you survey kids?
Oh, we created a unique survey that was targeted towards kids, so it was shorter, had a little more accessible language in it. A paper survey that,
Okay.
Or online, and that allowed them to kind of share their thoughts. And the age ranges I can't recall. I'd have to find that information for you.
Okay, thank you. I think we can move on.
Thank you, Madam Chair and Commissioners. As I mentioned earlier, the goal is to replicate these ordinance amendments for the Land Use Development Code into the Coastal Zoning Ordinance, as well as the Montecito Land Use and Development Code. Mr. Lindgren talked earlier about what this is and what it isn't. I'm going to just highlight that again. The efforts that we're doing with these ordinance amendments is to support the Recreation Master Plan. There is some similarities as far as the uses that may occur in like rural areas or agricultural areas. In the Ag Enterprise Ordinance, those uses were tied or to support the agricultural enterprise. Is this to make sure that the use on site stayed agriculture, that there's a primary use that maintained agriculture. Our effort that we're doing is to support the recreation and support that. So as Mr. Lindgren talked about, this is not tied to the Ag Enterprise Ordinance. It's not the AEO 2.0. This is the Recreation Master Plan efforts to find opportunities and ways to get recreation facilities throughout the county, throughout the communities. So you may see some uses that are allowed in the Ag Enterprise Ordinance, but we're going to talk about how we took that baseline of uses that we talked about in the Ag Enterprise Ordinance that also existed in the rural recreation section of the ordinance as far as campgrounds, and there's a variety of other uses that you could do in the agricultural areas, but it requires a conditional use permit. So we're just capitalizing and building on that foundation that was created with the Ag Enterprise Ordinance and the rural recreation section. And we're going to create an incentive program that Ms. Mitchell is going to talk about in the Recreation Master Plan. The spoiler alert is in the Recreation Master Plan and the Recreation Benefit Project Program, it's designed for a private partner relationship to be able to get recreation facilities. It's not designed that it's just going to be a blanket approach and all these uses are going to just be allowed everywhere. We'll talk a little bit about that later, but we just want to set the expectations that we're focused on encouraging and developing recreational facilities. So moving into the ordinance amendments, the approach that we took it's twofold. The first approach is that we found, looking at all of the zoning districts in the Land Use and Development Code, that there was an opportunity to increase the number of uses that are recreation centered. And so throughout the ordinance, we've identified additional recreational uses and have made those as allowed uses in those zoning districts. And so Ms. Mitchell is going to talk about a number of those recreational opportunities that we've identified. So that approach applies to the entirety of the zoning districts. Then we made specific ordinance amendments, and that's going to be creating a new chapter that's focused on implementing the policies that we talked about earlier in creating this public-private partnership, which is a recreation benefit project program. So that's not part of those general amendments. That's going to be a specific new chapter with guidelines and criteria to participate in that program. So we just want to make it clear that there is two approaches to these ordinance amendments. Overall, allowed recreational uses in multiple zones, and then this new chapter. So moving to the next slide, then Ms. Mitchell is going to walk the commission and the attendees today through that first phase of allowing additional uses, recreational uses throughout the zoning districts.
All right, thank you. So here we have Table 1, which was also in the summary document for today's workshop. This table shows new recreational uses that would be allowed in the zones listed in the left-hand column. Some of these uses are already established in the land use code, but currently aren't allowed in these zones. And other uses, like mountain bike course, for example, are currently not described anywhere in the land use code, but there is a desire for these types of uses. The ordinance amendments will include development standards for low-impact uses like trails, parks, and playgrounds, which will help facilitate streamlined permitting of those uses. And for the more high-impact uses, highlighted here in blue, staff would recommend a discretionary permit type like a minor CUP or CUP. As previously mentioned, we've drafted some development standards for trails as well as trailhead parking, and we'll walk through those on the next few slides. Development standards for parks and playgrounds are still being drafted, but we do welcome any comments regarding potential development standards for those. And just a quick note that any permitting requirements and development standards that we go over would only apply to privately developed trails and parks and not to trails and parks developed by the county on public easements or county-owned land. And Mr. Wilson will walk us through the standards.
To add a little bit more context and background of why we're identifying trails specifically as an allowed use in the zoning districts. Early on, there's a lot of interest and questions that we received from members of the public of, if I want to build a private trail but open to the public, how would I do that? The ordinance wasn't very clear on that in certain zoning districts. A lot of times it fell into the rural recreation section that then triggered a conditional use permit. So to address that, public comments and address that thing, we said, let's create a permitting path or an allowed use for trails. To clarify it throughout all the zoning districts, specifically like in the agricultural zones, there's some desire to have trails and what it would take to build a trail or have a trail. As Ms. Mitchell indicated, what we're walking through is really aimed at private recreational facilities or private facilities that want to build trails and have them open to the public. It doesn't apply to projects, development projects that are required to build trails, or if Mr. Lindgren and his team are building a county trail, these don't apply to that. So these really apply to those instances where there's a private entity that wants to build a trail, but it's open to the public. So on the screen, for ease of the ability to walk the Planning Commission through the permitting path, we came up with 3 categories. These aren't reclassifying trail types. These are not related to what Mr. Lindgren would classify trails. This is really only for permitting purposes, so we could walk the Planning Commission through different types of trail scenarios. So the first one is what we're calling a low-impact trail, and we're using the term low impact as in the development of that trail will have minimal or no impact to the environment. And that would be that the slopes of the trail are less than 10%. And if it's on an area that is generally flat, minimal to actually no impact to environmental, then that would be like a zoning clearance. Not like a zoning clearance. We're recommending that be a zoning clearance. Sometimes I talk like my teenager, so I got to check myself in public settings. Collateral damage of having teenage kids. But that's why we're focused on recreation today. So the other aspect of these low-impact trails has to do with a land use permit. And that would be if the slope of the trail is between 10 to 20%, minimal grading, and it's sited outside of environmental sensitive habitat and any buffers, and there's no trail support facilities on any of these low-impact trails. So when we talk about a trail support facility, we're talking about trailhead parking, signage, and lighting. These are really low impact. It's the zoning clearance, it's like grading, not grading, is it clearing the ground. A land use permit would be minimal grading. So that would be the low impact trail. And then if we look at the high-impact trail, both the low-impact and high-impact trail is really geared at developing trails in the rural setting or agricultural setting. The trail, a high-impact trail would have trail support facilities, and that could be restrooms, that could be parking, signage, lighting of the trailhead parking. We're recommending prohibit lighting on any of these trails, actually. It'd be inappropriate and impactful to have lighting in the rural areas. But for high-impact trails, if you wanted to have minimal lighting in the parking, it'd be okay for that. We're saying because of the nature of a high-impact trail, we're recommending that to be a minor conditional use permit. And the reason being is that the trails maybe have a trail slope greater than 20%. They may be in or adjacent to environmental sensitive habitat and require substantial erosion control measures. And it may be unimproved trails or improved surfaces. And it could be viewed from public viewpoints. So these are more of a potential environmental impact. And we're saying with these type of trails, it would be a minor conditional use permit. And then we get down to the multi-purpose trails, and the multi-purpose trails category is designed really for that urban setting where you would have a paved or a crushed aggregate path that would be in an urban setting or adjacent to a road right-of-way where it'd be appropriate for a multi-purpose trail. And that's what we're talking about when we're saying a multi-purpose trail, would be that type of setting. So I want to take a pause real quick with the commission and see if there's any questions or any clarification on the trails, any of the standards that we have.
Mr. Reed?
Just a simple question on what's your methodology to actually determine the slope of a trail, since most trails are undulating, have up slopes, down slopes. Do you do it on an average, or how do you calculate that? Because other than on the top of the levee, I haven't seen a trail that's absolutely flat or absolutely at a 20-degree. So what's your method?
Mr. Reed, thank you, or Commissioner Reed, thank you for that question. I'm going to defer that to our expert, Mr. Lindgren, to respond.
We have a room full of experts on this topic, but I will try and answer. The county requires that trail building use trail construction standards that are established by the Forest Service. And within that documentation, they have standards for slope, rise over run, and that it can, trails to be built sustainably should meet certain qualifications for how steep they are within a certain distance. I can't describe that to you directly right now, but that's essentially the formula that is generally used. Now, there are sections where it can be steeper, but we want to try and avoid those under modern day trail construction standards because those tend to create more erosion.
So it's basically a rise over run calculation.
Yes.
Doesn't really get messed up if you have a little steep incline or decline. Okay.
It can, but I don't think that that would undermine a project like this for a section where there's a big boulder that you have to go over or something along those lines.
Mr. Wilson, I appreciate your efforts to move quickly through these, but maybe I didn't hear it, but could you again state what trail support facilities are?
Madam Chair, thank you. I'll slow down.
No, you don't have to.
All right, I can speed
I'll
up.
just ask for clarification.
Whatever you want. When we're talking about trail support facilities, it's focusing on the trailhead. So a trail support facility would include like trailhead parking,
Yes,
restrooms,
okay.
lighting,
Just at the head.
signage. That would be at the head. It was when we're talking about the trail support facilities.
And do you make a distinction somewhere for who these trails are for? Or are they all for people, bikes, and dogs?
Yes, they would all be what we call multi-use. So again, I'm throwing another term out there. But multi-use trails we're a public access agency, and we seek to make sure that as many trails as we can are open to as many users as possible.
Okay.
So there would be equestrians, bikers, hikers, trail runners, anyone who is
Oh, yes, a
interested in
question.
using those trails, yes.
Thank you. Moving on. Oh, sorry. Oh,
That's all right,
great.
I'm slow. So that all sounds inclusive, but I've run into situations where horses are using trails and then bikes come along, e-bikes, and or walking and running, those kinds of things that are just simple in concept. But is there planning for those? Are there going to be separate trails for different users?
Yeah, Chair Ford, Commissioner Cooney, that's a good question. There are, typically when the county receives a trail easement, it's 10, maybe 15 feet wide. And that trail can really only accommodate multi-use. There's not enough room there for us to create separate trails for different users. There are other situations where there are trails in county-owned open spaces or other areas where we do have an opportunity to create a separate trail system for different user groups. And within the plan that we're discussing right now, there are projects that kind of bring this out and bring this to the forefront so that we can explore doing more of that type of trail building and trail planning.
Madam Chair and Commissioners, in context of the amendments that we're sharing with you right now, this creates a vehicle that a private entity could create a trail and open it to the public. They could govern the users of that trail.
That's why I was
And so that we wouldn't per se restrict the users of it. That would be under the project description of whoever that trail builder was. And what Mr. Lindgren is talking about as far as public trails go is to be more inclusive and create a multi-use environment, which would be under the Recreation Master Plan and not so much of what we're doing today with the ordinance amendment package.
for private.
Yes, and so a spoiler alert, and my colleagues will give me a raised eyebrow, when we start talking about creating a public-private partnership where a private entity may want to build the trail ahead of time and then dedicate it to the parks as part of a substantial in-kind contribution, the caveat to that is that they would be working closely with the Parks Division and building that trail to the park standard. So that way, when and if that trail is ever dedicated to the county, then it meets our standards and intent and purposes.
Thank you.
I have a question.
Oh, please, Mr. Park.
I've gotten a little bit confused here on these definition of trails. It looked like we were talking about what's the permitting for trails on private lands, mostly private lands. And then it morphed into a discussion of public trails, which confused me because some trails that are built are not intended as public trails. They're for, they may be under the recreation benefit program, they may want to donate it, or they may not. They might want to keep it as a facility for their private recreation purposes or for other purposes. But you're on general ordinance amendments now, right? We're not talking about the recreation benefit program. And so this is a broader set of standards and ordinances regarding trails on everywhere, whether they're public trails or private trails. And when you answer that question, I think it bears stating the current law in the county on private trails is essentially private trails construction requires a conditional use permit, which is surprising to many of us and overwhelming. But it's worth noting when you define what this is.
Chair Ford and Commissioner Park. So to answer your question, what I was presenting is related to what Commissioner Park is talking about is private trails. A private entity building private trails on private property, and they keep and maintain those trails themselves. the conversation did morph into a side path on public trails, but this slide is focused on a private entity building trails on private property that they may open up to the public. We're not proposing, if a landowner wants to build a trail for their own personal use, to require a permit for that. That's not what this is. We're not interested in regulating private owners building trails on their property for their own use. This is really focused on a private entity, private property owner creating a trail system that's open to the public. That's what this is about. Commissioner Park, does that help answer your question?
No. So if I go to a large ranch and design a trail system that I can use for events that I put on, and it's not open to the public except by entry into the event, are those trails, which might be extensive, you know, I mean, I'll use 150 miles of trail on a 3-day weekend. I can have those built as I wish, but because they aren't used by the public, I don't have to have any permitting. That's not my current understanding of the law, but.
That would be feedback that the commission would like to give to us. What we're presenting is that scenario where an individual wants to build a trail system. Let's say they have, use a scenario. Let's say they have a campground and they want to provide a trail system to their guests of that campground. This would apply to that trail system. I'm not quite clear on the scenario that Commissioner Park is talking about. So if you have a private property and you're building trail system, but it's not open to the public, then we're not talking about regulating that scenario.
Well,
unless the commission wants to provide that
private ranches
feedback.
allow people to put on events all the time, and that's one thing we've attempted to do in the AEO is expand that and make it more consistently regulated. And it's envisioned in some of this because some people will have a public trail easement, but they'll have a private, say, a mountain bike park that's adjacent to it, and they'll charge people for using that. And, you know, some of these, right now, I do believe that private trail installation requires a CUP, and that's why when people are designing trails, we look for cow trails and we look for ag service roads and things that aren't necessarily the construction of a new trail. And there's been a cry among trail groups for allowing the construction of these trails without CUPs. And it comes up with nonprofits. The White Buffalo Land Trust has trails it uses for reaching places on their ranch, and they have people that they're shown that, and there's things like that. So I can tell you, I don't want to spend the rest of the afternoon going through all the circumstances in which there might be private trails that aren't open up to the public that might have a commercial use, or they might not. But I'm just wondering whether these requirements and standards apply to those or not. And maybe the answer isn't clear right now, so that's okay too.
Yeah, so Commissioner Park and through the chair, that may be some feedback that we get from the commission, especially if the commission would say, hey, there's a scenario, let's say, for example, agricultural roads, there's an exemption for permitting on certain aspects for the grading ordinance. We could create exemptions for trails if it's like in scenarios where there's a rancher and he wants to build trails for his own purposes for his agricultural operation or whatever. And we could create an exemption for that. This is really, the focus here, Commissioner Park and Chair Ford, is focused on that scenario that I talked about, is somebody wants to build a recreational facility that's open to the public, whether it's for fee or not for fee, or charged or not charged. That's what these would come in. The most recent example that actually we got it resolved differently was in the Lompoc Trail Council. They wanted to build a trail outside of Lompoc. A private entity, current regulations, as Commissioner Park adequately indicated, building trails in the agricultural zone falls under rural recreation. That then triggers a conditional use permit. We're trying to create a framework that doesn't trigger a conditional use permit for building trails for if a private entity wants to build a trail. We did create that high impact trail We are recommending a minor CUP because we're saying those high-impact trails could be in environmental sensitive habitat. They could be crossing waterways. There could be some issues that need to be analyzed under a minor CUP. But a minor CUP goes to the zoning administrator for review and approval. It doesn't go to the planning commission. So that's what we're recommending. We're open to feedback, any direction from the commission in regards to this.
I think this bears further discussion, but I think we should move on.
Is that it from you then? Great, let's move on.
Okay, we put slides in, so we're talking about these standards. So to help get into a streamlined permitting process is creating standards so that if a applicant builds or develops a trail to these standards, it supports a streamlined permitting path. And so in your packet, we've gone into more detail about standards related to these different categories. Next slide. We're also creating, for the commission's review, public's review and consideration, standards related to trailhead parking requirements. In the document, we talk about making this a zoning clearance. However, if you're building a trail that triggers a land use permit or minor CUP and you're doing trailhead parking, then we recommend that trailhead parking just gets wrapped up into whatever that permit is. But if you have an existing trail and you're adding trailhead parking to it, and you can meet these standards, then we're saying have that permitted as a zoning clearance. And then the next few slides are just highlighting what those standards could be. We won't go into detail on those, but we came up with proposed standards for unimproved and improved parking that addresses a number of different standard types and development standards regarding the development of that parking area. But that's super exciting, but we don't need to get into that now because we really want to get into the recreation benefit project program. So that's where we had questions, but we'll talk about trails later. Any other questions before we move into the highlight of the workshop?
Just a little one. We've been down this trail before. I think you'd like that. But I sense we're going to definitely be revisiting the agricultural setback one.
Great. 2.3.4. The new chapter.
Commissioners, this is really the kind of the nexus of a lot of the tension thoughts that we put into it is creating this recreation benefit project program that's linked to the policies that we talked about earlier, creating an incentive program to really boost opportunities for Mr. Lindgren and his team to obtain recreational facilities or create additional recreation facilities throughout the county. So Tina's going to walk us through that, and then we'll take a break and get some questions, answers from the commission, and then we'll move on. So over to Ms. Mitchell.
All right, thank you. So the Recreation Benefit Program will be all captured in a new chapter of the zoning code. The broad objectives of the program and this new chapter will be to establish criteria for determining eligibility for the program, clearly lay out the specific incentives that will be available for eligible projects, provide development standards for recreation benefit projects, and ensure that there's permanent public access and ongoing maintenance of the public recreation component of each recreation benefit project. I'll go into more details on eligibility in the next few slides, but we just want to emphasize again on a big picture level that to be processed as a rec benefit project, the project will need to include a public recreation component and a private development component. The public recreation component is a substantial in-kind contribution to public recreation, so things like a public park, public sports fields or courts, or a trail segment dedication are a few examples. And the private development component could be something like a campground, a guest ranch, event facility, or a housing project. There's lots of options. So this table, which is Table 4 from the workshop summary document, lists the zones that the Recreation Benefit Program will be available to. So we have the 2 agricultural zones, mountainous zones, several commercial and mixed-use zones, the recreation zone, and some residential zones. And these were all selected based on their potential to accommodate future substantial recreation projects. All right, so this flow chart walks through the Recreation Benefit Program eligibility review and application submittal process. Step 1 is the eligibility review. And to initiate this step, the applicant will need to submit a joint recreation benefit project application to County Parks and Planning and Development. At this stage, the main project components only need to be identified on a conceptual level, but at a minimum, we would need to know the public recreation component, the private development component, and the requested incentives. Those will all need to be identified. Step 2 is consultation. County Parks and Planning and Development will conduct a joint review of the application. County Parks will be responsible for determining the adequacy of the public recreation project component, and Planning and Development will be responsible for reviewing the private development component and the requested incentives to ensure that they're consistent with what the Rec Benefit Program chapter allows. The applicant will be invited to participate in the consultation sessions as needed for clarification or project refinement. During Step 3, County Parks and Planning and Development will prepare a joint letter that informs the applicant whether their project is eligible as a rec benefit project or not. Eligible projects can move on to Step 4, which is submitting a formal application for permitting, and ineligible projects can resubmit a revised application or appeal the determination. This list describes the criteria that County Parks would be looking for in the public recreation project component when considering if a project is eligible for the program. We've highlighted the key points of each criteria here in green, but just to walk through these, the public recreation project component must be a substantial in-kind contribution to public recreation, and I've listed those examples again there. The public recreation component must be identified or meet a need identified in the Rec Master Plan or another adopted county plan. The project must include a plan for ongoing maintenance and permanent public access. And lastly, the project must be located either on the same site as the private project component or within the same rec planning area as the private component. Yeah.
Before we move on, I just really want to emphasize this criteria. You are likely to hear concerns about the rec benefit projects popping up on every parcel all across the county. And while it's true, application may be submitted for that, those projects will need to meet this criteria that, number one, they need to be willing to provide a public recreation benefit project to the county, open to the public permanently, and then meet this other criteria as well. And then what we're not listing here is that there's actually, market forces at play as well. Not everyone is going to be able to build a campground. Not everyone is going to be able to build a country inn. The developers will need to be very strategic. They have to meet this criteria and then understand, the marketplace they're working in to see if their project will actually be feasible. So I just want to reemphasize that these criteria apply. So not every Ag 2 parcel or not every commercial parcel is necessarily eligible.
Could I just ask one clarifying part of that? So they have to meet all 4 of these?
Yes.
And do you have a definition of substantial?
Not yet.
Okay.
But the in-kind is probably the bigger piece to this.
Yes.
There has been some discussion about proportionality, and it's a very difficult thing to try and quantify and say this is substantial or this is
okay.
Or this is not, because an 800-foot section of trail could be far more valuable to the community if it connects a community to the Los Padres Forest, for example. than a mile and a half of trail in another area that doesn't particularly go to any destination. So we've talked about this at length, but it's very difficult to really nail down any sort of numeric or very, clear definition of it. So there is going to be some magic in the process.
Okay.
All right, so now we're going to get into the details on the incentives that will be available to eligible rec benefit projects. This table gives a broad overview of the 3 different categories of incentives, and I'll go over each on a high level here first, and then we'll go into a little more detail for each category. So starting on the left in blue is simplified permitting requirements. This incentives allows the recreation benefit project to be processed as a whole with one land use permit. It will also waive the requirement for a development plan. This is a significant incentive because it provides certainty to the applicant on what the permitting process will entail. Additionally, the findings for land use permits are limited in terms of the level of discretion that is provided to the decision maker for approval or denial. Land use permits are noticed to the public and provide the opportunity for public engagement in the process. In the green center column is additional allowable uses. This incentive gives eligible rec benefit projects access to additional uses that would not normally be allowed in the zone. Again, I'll go into more detail on the additional uses in the next slides, but in general, these additional allowed uses are intended to supplement and support the public recreation on site. And last, in the red column on the right, is modification of development standards. This incentive would allow applicants to modify certain development standards like height or setbacks, with limitations, of course, but this is beneficial because projects would gain some flexibility and potentially more room on the site to accommodate recreational uses. So going back to that first incentive category, simplified permitting requirements, this incentive allows rec benefit projects to be processed with one land use permit. This means that if the use for the private project component typically requires a CUP or a minor CUP or multiple permits, the applicant would be getting a downshifted single permit type with a land use permit. In terms of development plan requirements, with this incentive, the gross floor area associated with the recreation benefit project would not count towards the applicable development plan threshold. This simplified permitting incentive will be subject to some exceptions and limitations that will be clearly identified in the ordinance. We would recommend that certain land uses be excluded from using this incentive that are typically controversial, and that the director of P&D holds some discretion at the eligibility review stage to determine if the simplified permitting incentive is not appropriate due to an unprecedented project scale or potential compatibility issues. Moving along to the second incentive category, we have a list in this table of additional allowable uses that will only be available to rec benefit projects in the zones listed there. These are uses that are otherwise not allowed in the zone and would support the recreational use on site while providing some convenience or additional income to the property owner. Draft development standards have been prepared for the 3 uses highlighted here in green, so we'll go into those on the next few slides, but we would be looking at making development standards for all of the uses listed here. So this slide explains what a country inn is and some of the development standards that have been drafted for this use. It's a form of overnight lodging, which can be in a single building or separate buildings, up to 15 rooms with a land use permit, or you would be able to go beyond 15 rooms up to 48 rooms with a conditional use permit. This incentive would be available to rec benefit projects in the ag zones to support guests and visitors of recreational uses, and in the DR zone to support guests and visitors of DR zoned housing developments. Following that same format, this slide explains what a trailside cafe is, which zones it would be allowed in, and the draft development standards that we're recommending. Trailside cafes would be small dining locations that can be walk-up counter service style or table service. They can include indoor or outdoor dining areas, and they can be supported by a semi-mobile food vendor or a standard commercial kitchen. Trailside cafes would need to be located within 1,000 feet of a public trail and provide a direct connection to that trail. Oops. Okay, and lastly, for the additional allowable uses, we have non-ag employee dwellings. Agricultural employee dwellings are already an allowed use in the ag zones and a few other zones, but this incentive would allow for employee housing for any type of employee that works on the premises. This incentive use would be available to rec benefit projects in the ag zones and in the DR zone, and we're still looking into additional development standards like a minimum parcel size and maximum floor area for this type of dwelling. Then I'm going to pass it back to Mr. Wilson.
In this incentive, we're looking for any feedback, direction from the commissioners or members of the public in regards to setting either minimum, maximum variances on or modifications on any of these potential incentives. Like increasing height of structures, if it's typically allowed to go 2 stories, allow for it to go up to 3 stories, reduce setbacks. That could be a reduced setback from potential like environmental sensitive buffer areas or property line setbacks. Reduced parking requirements could be another incentive. The other area that we have on here that we're looking for feedback or direction on is the intensity of use and coming up with some quantifiable numbers. That could be number of campsites. We know that the Ag Enterprise Ordinance set a limit on campgrounds or campsites, and so with the Rec Master Plan as an incentive, if somebody is doing a recreation benefit project, then we're looking for, what would the commission potentially look at as like, what would be the max number of campsites on any one property? Maybe number of farm stays as far as a quantifiable number of maximum farm stays and or employee dwelling units. Those are examples. So when we're looking at incentives, we're being creative and saying, okay, what could be an intensity of use? And what would the commission direction be as far as if we were to create either a percentage increase or a maximum number? Or if the members of the public have some insight or comments on that, that would be welcomed as well. So that's what this slide is talking about, is providing some incentives on development standards in these categories. And then I'm going to turn it over to Mr. Lindgren as talking about this incentive that has to do with development impact fees.
Thank you. Maybe our final incentive here is a fee against development impact, or a credit against development impact fees. So currently, we offer private development that provides public recreation. We offer them a credit for the value of the facility that they're providing. So the land cost plus the construction cost can become the value of the fee credit applied against their development impact fees. As an incentives, we are exploring how we might change that ratio so that there is a credit that is slightly higher than the value of the land or construction value to incentivize the faster and private delivery of a recreation project. We still have some vetting of this concept to do, but we think this is a potentially good incentive.
Okay, so this slide goes over a few requirements that we would recommend for all recreation benefit projects. First, the projects under the program would need to comply with all existing standards for specific land uses in the land use code. There may be some exceptions to this. This is something that we're still researching, and it will be more detailed in the draft ordinance. In terms of project phasing, if we're dealing with a phased project, we would want to ensure that the public recreation project component is timed to be completed during the first phase of development. And then lastly, there's going to be some minimum setback requirements from things like sensitive habitat, agricultural, row crops, cultural resources, and other sensitive resources. All right, so now I'm going to go over a few example recreation benefit projects, and this will include the zone, the public component, the private component, and some example incentives to help explain how this information all fits together. So this first example is located in the Ag 2 zone. The private recreation component is a public trail segment dedicated to the county. The private component is a private campground and RV park. The incentives for this example are: one, simplified permitting, because the applicant would get everything here with a land use permit and no requirement for a development plan. And then let's say the applicant wants to have a trailside cafe for both the trail users and the campground visitors. That's something they could request as an incentive. And three, they're able to get permits for a campground and RV park via a different permitting pathway than the current pathways that we have, which would be rural recreation or the Ag Enterprise Ordinance. Okay. This next example is in the design residential zone. The public recreation component is a public park dedicated to the county. The private component is a housing project. And then possible incentives for this example could include additional rec benefit uses like a country inn to serve visitors of the residents of the neighborhood, or a non-ag employee dwelling. Since this is a housing project, they could also request the park's development impact mitigation fee credit as another incentive. And example number 3, this one is in the general commercial zone. The public recreation component is public sports fields. The private component is a commercial indoor aquatic facility. And the incentives would be: 1, simplified permitting with the land use permit and no development plan. And then they would be able to develop an indoor aquatic facility, which is otherwise not an allowed use in this zone. Okay, and last example that we'll go through here is an Ag 2 zone property with an existing Tier 3 winery. They propose to dedicate a public trail segment to the county, and in return, they could request a country inn to provide lodging for their visitors and an employee dwelling for their tasting room manager. So to summarize this section on the rec benefit program, we went over the eligibility criteria and the eligibility review process. We went over the different types of incentives that will be available to rec benefit projects, and we went through some examples. And at this point, we would want to open it up to questions from the commission.
Thank you very much. This is a lot to digest, but very exciting. I will start with Mr. Reed.
I think you said this, but I want to clarify it. Both the Trailside Cafe and the Country Inn, are they going to be allowed to have commercial kitchens?
Commissioner Reed through the chair, yes, that would be
Okay,
for both
good,
of those,
good.
yes.
I keep revisiting the tasting room, all we went through there, so thank you. And now I notice both the commercial and the recreation component, they're going to be able to be combined on one land use permit?
That's correct, yes.
They're not going to get immunity from appeals, are they? Are they still subject to appeal?
Commissioner Reed through the chair, yes, they would still
Okay.
be subject to appeal.
Thank you.
Thank you. Mr. Park, please.
I'd like you to go to the incentives. First, Go to slide 53, if you don't mind. I'm just going to share some things for the benefit of the public that might illuminate some of this stuff. And I think that might avoid the need for some public comment. That's why I'm trying to do this. I personally interviewed every developer for the big mega projects in Goleta, 4 of them, maybe there's more, at the time of the housing element, in an effort to get more parks. We coordinated, did we not, Mr. Lindgren? And this was a very important incentive, this fee reduction. You know, we're going to be discussing park fees per unit later in the year, I'm sure, or maybe this commission won't, but you will be. And right now, they're about 7,000 per unit. I think they are. And there's
Commissioner Park, it depends on the part of the county in which you are seeking the permit.
Okay, but that's in the ballpark. And there's discussion that it might need to go up to past 10,000 per unit. So you can imagine with a 1,000 unit housing element project, they're looking at $10 million in park fees. So this is very important. And the reason I interviewed these people, because I wanted to know what incentives were appealing to them and which were not, so that we could design that in the program. Now, if you could go to slide 52. There's 4 of those things on the development standards, and I think the bottom 3 are ones that should survive, and they don't raise the level of controversy. I'd say the increase in allowed height of structures, it has a giant red bullseye painted on it. And it's, I'm actually surprised to see that it survived. We raised that in the, at the workshop we had in August of 2023. And for members of the audience, you can look that up. I think it was August 23rd, 2023. And there was a actually larger PowerPoint presentation, and it covered much of the same material, and it raised this issue. It turned out to be very unpopular with the elected officials, unpopular with the public, and it was unpopular with the developers. And the reason why is that under SB 35, SB 330, builder's remedy, the state density bonus law on projects, especially those with affordable housing, they can request concessions and waivers on height anyway. And none of the developers felt we needed this. You know, when it says increase in allowed height of structures, I don't think you, at least at the time in 2023, we didn't mean that to mean just structures that were built like country inns or trailside cafes, but as part of the actual development, including housing projects. So I would submit that we don't need this, and a lot of people just don't want it, and we're better off right now, and that's why I'm speaking right now, putting it aside.
Chair Ford and Commissioner Park, I remember those conversations, and one of the items that we'd have the commission think about is we concur about not having this apply to housing projects. Yeah. They get a lot of concessions with the state laws and density bonus things, but we would want the commission to potentially consider other zoning districts that this could apply if there's height limit restrictions in either commercial or potentially agricultural zones to allow some flexibility in those zones. So we could create a carve out and say this doesn't apply to housing projects, they get concessions anywhere else, but in a commercial or agricultural setting, there may be some options to create an incentive for increased height. Just something to consider, but we concur with Commissioner Park that this doesn't apply to housing projects.
Anything else, Mr. Park? I just have one question. I see that the minimum room size is 350. Does that include, in a country inn, does that include the bathroom? Otherwise, that seems pretty big. None of us are in 350 square foot bedrooms.
So Chair Ford and Commissioners, that would be inclusive of the bathroom area.
Okay.
Unless you want to have a bigger one, you want to have suites. I mean, that's the
I see
feedback.
I see what you're saying.
So this is just really to provide an opportunity for the commission and public to weigh in.
Sure.
These are just draft. So that
Got it. But also, I see that the maximum square footage is TBD, and I think that's going to be an important one to figure out.
So Madam Chair and Commissioners, that's correct. When you do the math of 350 square foot rooms times 15 rooms or 48, that could equal the square footage allowance. So we wanted to start somewhere, so this is the starting point.
It's in the document. No. Do you want to look at this, John? Do you want to look at it? No? No? Oh, okay. I don't see any other speaker requests from the commission, so we can now move on to public comment, please.
Madam Chair, we have just a couple additional slides to wrap
Oh,
things up.
sorry, I thought we
Yeah,
were at the end.
But almost there. Thank you.
I'm not trying to be rude.
I just want to summarize where we are in the environmental documentation, the CEQA analysis
Sure, right here.
for this process. Oh, yeah. Back in January of this year, we released the notice of preparation. We had a comment period. We received something like 280 public comments on the NOP. That led us to revising the rec plan and revising some of the elements of the programs that you've seen today. We are also continuing to look for feedback as we move forward. Our next steps will be to hopefully release the public draft of the EIR in 2026, at which point, we'll have a good understanding of the impacts for the programs that we're proposing, and we'll be back to your commission for your deliberation and consideration in 26. And next slide. And then this is just for everyone. This is where you can find information about the Recreation Master Plan and these programs, website, email address to sign up for our mailing list. Have a pretty extensive mailing list going so far. And then we'll see some of you at some public meetings we'll be holding with the County Park Commission and with CRATAC, the County Riding and Hiking Trail Advisory Committee. We love our acronyms. And with that, I think we are done with the presentation.
To clarify with your request for an interest in feedback, I'm assuming that you would continue to take, doesn't have to be, today is not one and done, and so people could continue to send emails to the commission and get them forwarded to you.
That's correct. When we release the public draft of the EIR, that has a statutory public comment period. But beyond that, we'll be taking, comment throughout, sooner is better.
Sure.
So that we can edit and revise and update as we get too close to our project description for the EIR, finalizing that and getting the EIR out to the public. But yes, we will be taking comment for some time.
Excellent. Thank you very much. And now, on to public comment. Could I address something first? Sure.
There's an issue here that we'll have to address at some point in time today. And that is, when does public comment end? And how late will we go? And I think it's important to discuss that now so that people here can pipe up so that we meet their expectations and can weigh in on it. I look out there and I recognize nearly every single person. And I can say whether they liked it or not, I've spent hours with each one of them. They've got a lot to say, meaningful things to say. I personally have encouraged them to come to this and discuss with Mr. Lindgren and Mr. Wilson the advisability of having a workshop and created some excitement for it because it was asked for people. And we've been discussing it since, I think, last June. And I hate the idea that here we are close to 4:30 and people might feel rushed to get in a minute or two of comment instead of the 10 to 15 minutes that I know some of them have. And so whether the other commissioners like it or not, I'm going to move at some point as we get into the evening to continue this so that public comment can continue and people can make their full public comment. And also, I think we would need to do that because we've asked some questions now at these breaks, but the commission hasn't really deliberated in any fashion. And I can't conceive of how we could get all the public comment and the deliberations in before the time in which people will want to end today. So that's
we're
fair
going
warning.
to work on it, and we'll continue. I appreciate
Madam Chair, I just wanted
perspective.
to indicate right now, if
Please,
I could.
Mr. Martins.
Sorry for the interruption, but I have to leave at 4:30 for a telephone conference. I didn't anticipate the beginning morning going as far as it did, but I am the leader of that telephone conference. I'll quietly
for letting
excuse
me know.
myself. Yeah.
Let's continue.
All right, I have 8 speaker slips, and then I have 2 speakers online. Do you have a preference of which we start with?
Let's go in person, and just a reminder that the time limit is 3 minutes.
All right, our first speaker will be Suzanne Duca, to be followed by Dan Giroff, and then Kevin Snow.
Thank you for hearing me. I think I'm going to just address the, the pink elephant in the living room, which is the assumption in the Rec Master Plan that we have multi-use trails that include both equestrians and horses, equestrians, pedestrians, and bicycles, all on the same trails. For instance, on the North Shore project that they're working on, it assumes bicycles up there. There are no bicycles up there now. And I think we have to have a fairness doctrine that I think you all use when you're making these plans. There's a certain fairness that we all have to live with. We start as children at our feet of our parents, learning how to be fair with one another. The equestrians have been basically eliminated from all the front county trails because it's not safe for us to share those trails with bicycles. We're going to get hurt. Our horses are going to be scared off the trails. We're going to get thrown. Same with off-leash dogs. So there's very little unitary trails for equestrians in this county. And the one that one of the few that we have that's so beautiful and lovely is the one at Live Oaks. But the Rec Master Plan already assumes bicycles over there. I don't get it. How is that fair? You know what we have across the street from Lake Cachuma? We have let's call it the Trek Foundation, donated $175,000 to extend the mountain bike trail at the Boy Scout camp from 3.5 miles to 10. That's one way in, 10 miles. So that's 20 miles for the mountain bikers right there in the same area as Lake Cachuma. The trail that we have at Lake Cachuma for equestrians now is 15-mile loop. So we already have fewer miles than the bicycles in the same area. And yet you want to add bicycles to the north side of Lake Chuma, and they already have the front country trails in the first district. How many horses did any of us who hike all the time see? How many horses do you see on those trails in the front country trails anymore? You never see them because it's not safe. So I'm going to leave it at that. I hope that you will think about fairness. What's fair? Thank you.
Thank you.
Madam Chair, members of the Commission, Dan Draw, 2nd District CRATAC representative. Just want to say that for better or for worse, I'm the author of substantial portions of your comprehensive plan and zoning ordinances in my former life as a county planner. I was also the Recreation Master Plan Program Manager for the first 3 years of the project, where John Park and I worked together to cook up the Recreation Benefit Program. So it's our creation and staff's taken it and run with it. Good to see that we're at this stage now, finally. A couple of comments. I know Mr. Califf, the chair of CRATAC, is going to have some specific recommendations for you. I think that the land use element policies, as you have you're in receipt of our letter from CRATAC, both the land use element policies, the development standards, and the trail permitting sections should all be considered a good start. They need work, a lot of work. But I think it's a good start. I'm glad to see we're at this point. We hope to work cooperatively with the Planning and Development Department to refine those. You have a lot of expertise on CRATAC, my trail planning experience, trail construction experience, trail management experience, and recreational experience in general. So I would hope that the Planning Department would take advantage of CRATAC and our expertise as you refine these. It's a lot for you to refine and not necessarily directly in your wheelhouse with this recreation stuff. It is ordinances which are in your wheelhouse. So I think working together, we can come up with some improvements on those. I would say on the Recreation Benefit Program, I know the people in the room, and with Commissioner Park, I was the original outreach to many of the recreational benefit people. They're scared to death of the county's permit process. And I think there's not yet necessarily a sense of trust that the Recreational Benefit Program will be what it's cooked up to be. So I think something like, as we mentioned in our letter, the creation of a recreational ombudsman position that has some power, maybe it lives in the CEO's office, can work between two departments, because right now I think there is a sense that without some active, strong management, the program will not deliver the benefits that it is purported. And there's many, many examples we don't need to go into that people are concerned about. So, and I think it's a crucial program. The reason we came up with it is because of the things alluded to by Mr. Lindgren. The county's lost some of its ability to exact, particularly trails, from private property. So during development process. So I think the recreational benefit program is crucial, and a stronger policy framework is absolutely crucial. And so we provided comments to you, and we hope to work with P&D and Parks to refine those. Thank you.
Thank you.
I have a question for this speaker.
Okay.
If I may. And I don't know if this is going to be covered in Mr. Califf's points or not, but since I don't know, I want to ask you, for the benefit of all the planning commissioners, could you tell us what CRATAC means and what relationship it has to Santa Barbara County?
The County Riding Hiking Trail Advisory Committee was created about 40 years ago by the Board of Supervisors, and CRATAC has 3 to 4 members from each district. Right now we have representatives from all the districts. Representatives live in every part of the county. Santa Maria Valley, Lompoc, they live in San Ynez Valley on the south coast. So we have a good feel for the community. We're pretty well connected. Many of us are members of the Trails community. For example, I'm vice president of the Trails Council and have prepared numerous environmental documents on trails for the county. So I'm familiar with trail construction and impacts, high impact, low impact, and all that. So CRATAC advises, is directed by the board to advise Planning and Development Department and the Parks Department on trail matters, and including impacts, mitigations, et cetera, projects that affect our trail system. That's the board mandate from the adopted resolution from the 1980s, I think, when the board created CRATAC.
You saw on the slides that one of the key kinds of public benefit projects, recreation projects that would be here, would be trails. I mean, I know there were others, ball fields, but trails is a very large component. And you also saw a nice flow chart on how the process would work, starting with submission to parks and then a consultation between parks and planning and development and so forth. You remember this?
I did see that, and just to emphasize, our team turned in a complete draft of policies and zoning ordinance amendments 3 years ago. And P&D has taken that and run with it and developed it, and that's good to see. We have specific comments in the CRATAC letter on who should be determining recreational benefits. Because of the rush, I think it happens all the time. There's inconsistencies within the documents between policies and within the ordinance, and that happens especially when you're trying to get things out the door. So that's why I think that working together with CRATAC, we can help refine these things and the steps in the process. For example, should it just be parks that determines it's a qualifying recreational benefit program? The policies seem to say that. The ordinance says that it's parks and P&D kind of working in tandem. Whether that's good or bad, that's up to you. That's your judgment. But I think that we need to clarify and refine and sit down in a working manner, because there's a lot of expertise CRATAC can bring to the table to work with parks and P&D on this. And Jeff and I have worked together for years. I think I gave him his first job a long time ago.
Do the CRATAC members see a role for CRATAC in that consultation process about something like a trail as a
I think
recreation
for major
project?
trails, there's a question. We want it to be streamlined. We don't want things where it's, it's a big deal for people to get into the program. We want it to be easy. That was the idea originally when John and I worked on this. So I think for major recreational trails, and again, is it what's substantial, what's major, I don't know. I think there could be a role for CRATAC. Similarly, there could be a role for the Parks Commission on a big park. I mean, that should be early consultation, because that's how you have an effect early in the process. So CRATAC is certainly prepared to do that, and we can act pretty quickly, but I don't want to have CRATAC be seen as a barrier to recreational benefit projects. So I think that's something to sit down with P&D staff and parks and work on together.
Excellent, thank you.
Okay, thank you so much for your time.
And after Mr. Snow will be Gary Meyer and then Claire Weinman.
Good afternoon, everyone. My name is Kevin Snow, and I think I'm hearing that challenge between implementation and policy is a problem that I've been dealing with as president over 3 different times of Montecito Trails Foundation during 40 years, also a member of CRATAC for almost that long, since CRATAC was first established, and that is that the difficulties of what happens on the trails, who's using the trails, who's building the trails, who's raising the money to get the trails built and maintained, comes down to the nonprofit foundations like MTF, Trails Council, and the public, and the issues regarding horses, regarding bicycles. Those kinds of things were meant to come up at CRATAC, where we can discuss and argue and come to a consensus about a policy that we can all live with. The challenge that I find is that we do that, and then policy comes out of P&D that doesn't seem to connect with our experience, with what we know and we have been dealing with for year after year after year. You've seen us come to these various commissions. We would like to participate in the process, but we need to feel a sense of respect that our experience, that what we are telling you is actually the truth and not something that we've just made up. And sometimes policy has a way of making things seem like it's doable, like it's wonderful, but in practice it just isn't. So I hope that as we go forward, that the process of developing this recreational master plan will include steep conversation with Trails Council, MTF, CRATAC, and trail users, including the equestrians. Thank you very much.
Thank you.
Next speaker is Gary Meyer, to be followed by Claire Weinman.
Good afternoon, Madam Chair and Commissioners. I may have come the wrong day, but I'm here. I'm here to voice my strong opposition to the proposed trail from the Barone Ranch through my property at the beach. My name's Gary Meyer, and I own both sides of the creek all the way to the ocean, and then to my neighbor's property, the Casey's, on the other side. The trail would pass 100 feet in front of my front door. The house was once the home to my great uncle and aunt. Pierre and Marie Barone, and it's been in our family for 150 years. Now my daughter's family and 2 granddaughters live there, and we see plenty of strangers walking up from the beach already and down from the dirt road. No trespassing signs, Civil Code 1008. And we don't want to see a trail because people don't stay on the trails anyway. They'll be walking into our yard and sitting at our picnic tables. So I'm not a willing participant. There's plenty of parking and access to the beach to the east of me, right along the freeway. Another thing, law enforcement is very slow to respond out there, and you never know who's going to walk up. And the other thing is sometimes we have weddings and party venues out there, and I can't have a trail going through a wedding venue. It just can't happen. Questions?
No, thank you.
Just, would you say again where, the location you're describing?
I'm just south of the Barone Ranch.
Okay.
Under that very narrow bridge that says no passing.
Yeah.
My
okay.
house is right under that.
Okay, thanks.
Thank you.
Next speaker will be Claire Weinman, to be followed by Otis Califf, and then Gellere Macon.
Hi, good afternoon. I'm Claire Weinman. I'm the president of the Grower Shipper Association of Santa Barbara and San Luis Obispo counties. We appreciate the great work that's been done and the opportunity to engage in this process over the past few years. There's a lot of great content in the plan and also some real potential issues that would, for conflicts and even life safety. We're still reviewing the documents, but would like to call attention to some of these crucial issues that we haven't seen addressed in the updated draft, and these are detailed in our letter from March 11th. Foundationally, there's really 3 separate pieces, 3 separate documents. You've got the Recreation Master Plan, the LUDC amendments, which I think it'd be super helpful to have that on the project homepage because the only place I could find it was in the box for the Planning Commission meeting, and then also the rec benefits. So I'm going to try to go fast and cover the high level for each of those. Also just wanted to speak briefly on a main foundational issue, which is the level of service. And this being a goal of 10.8 for acres per 1,000 people. That's a national average, but if we look to the Pacific Southwest region, those median values are 3.5 acres per 1,000 residents. And in all counts, Santa Barbara County is well ahead of the regional medians, calling into question some of the fundamental premises of the draft and how the county can best support future recreation needs. In terms of some of the specifics of the rec master plan, again, there's a lot of really great stuff in there. We're just drawing attention to the remaining concerns. We are concerned about the Guadalupe campground and the inclusion of the sports fields. It looks like there's a new Lompoc sports complex, so we'll continue discussions with our stakeholders on that and the potential conflicts that they can create with surrounding agricultural operations. We also articulated concerns with the Guadalupe to the Dunes Trail and specifically the River Trail alignment and made a distinction with that particular alignment along the river and the disruptions that would have for ag operations compared to potentially widening Main Street and having that as an alternative route. In terms of the Foxen Canyon and Los Alamos trails, we have heard concerns from our members about potential disruptions to agricultural operations in those areas, and have a few others that we mentioned in our letter as well. Briefly on the ordinance amendments, we do have some concerns about the trails and especially parks and playgrounds and some of the Table 5 amendments. These are all new allowed uses in ag zones. Would like to look more carefully at those permit types and fencing requirements and setbacks so that you're not inducing these sensitive uses into industrial places of work. Again, there's locations where that's great and fabulous. Sorry, I get confused by that counter. And then just real quick, high level on the rec benefits program. We do have some concerns about it fundamentally undermining or having the potential, again, great potential, but concerns about undermining orderly land use planning and zoning, resulting in significant conflicts with ag operations, potential for unequal protections, and then creating county parks in a quasi-judicial role in addition to the Planning Commission.
again, don't want those concerns to hinder the forward progress of these other pieces, and so see value to it being considered separately. So thank you again for your consideration, and would love to see more response to our detailed written comments in the draft as it moves forward.
Question. I'm going to ask this question without replaying the whole process of the AEO and how we got to the overlays that we have for the protection of agriculture. But we have them for AEO purposes. It basically excludes AEO type uses from those overlays. Has your organization been able to reach a conclusion as to whether you want a similar overlay for Rec Master Plan things or not? I think I'm hearing not, but I'd like you to address that.
Yeah, thank you. So in our involvement with the Ag Enterprise Ordinance, we did seek input on the concept of overlays, and our board provided direction that they supported a limited permissive overlay. We had concerns about lack of equal protections for members who farm both within and without or outside of the overlays. And the other concern that we heard was, let me find the right word. What's the PC word? How these overlays, if adopted under the Ag Enterprise Ordinance, how they could be applied for other purposes in the future and the unforeseen applications of that. And in our mind, this would be an additional application of that overlay, one of many in the future. And for that reason, we would not support applying that overlay for an additional purpose. We see that as an additional application of that, and we really felt that should be, had concerns about the introduction of that line once it's on the map and what that could mean. And so our association would not be supportive of overlays for the Recreation Master Plan.
Okay, thanks.
Or, sorry, I should say limited. We are in favor of permissive overlays. We are have concerns about exclusive, prohibitive overlays.
Whatever label we put on that overlay, you don't want to expand its use to the Rec Master Plan.
Correct, yes.
And I appreciate hearing from grower shippers because we were very concerned about that.
Thank you.
Thanks.
Very good, thank you.
Good afternoon, Chair and Board. My name is Otis Califf. I'm Chair of CRATAC. I'm also happen to be President of the Santa Barbara County Trails Council. Been active in trail issues for many, many years. And we're really happy to see that the Rec Master Plan is finally out. We see this as potentially an unusual opportunity. We're disappointed that the public workshop and review process seems to be rushed. CRATAC were given 2.5 days over the weekend preceding Thanksgiving holiday to review a substantial volume of complex material. It appears that the Parks Commission was not even consulted. Our 9-page letter of December 1st this year provides relatively detailed recommended changes focused on the land use element and policies, as we simply were given insufficient time to delve into the complex ordinance materials, particularly of the Recreational Benefits Program. We've tried to very carefully lay out the sort of language that would make a much better, stronger document. Given that the Commission has unfortunately limited time to review and comment on this extensive and complex material, we respectfully request that the Commission direct P&D and Parks to take the following general actions. 1, conduct workshops on this material as CRATAC and the Parks Commission with CRATAC and the Parks Commission, including a presentation by P&D, Park staff, and open discussions with these advisory bodies. And work with these bodies, and work with these board-appointed recreational advisory bodies to address recommended changes, including those raised in CRATAC's letter of December 1st. And then there's a previous letter from March 11th, too, with the goal of reaching consensus on as many issues as possible to ensure that advice from these advisory bodies is incorporated into future drafts and to ease future commission and board review. 3, send the project forward into environmental review to keep this effort going while continuing to refine this preliminary draft. We citizen planners, and I consider you citizen planners with us on our committees and boards, we can make something good and very useful out of this plan if we put in a serious effort. If not, it will just evaporate and blow away. Having wasted our time, $1 million was spent with the consulting contractor. And what in my lifetime, this is a totally unique opportunity. So I'm looking forward that we'll be working together on this to make a fine document for our future recreation. Thank you.
Thank you.
And following Ms. Macon will be Tom Parker, and then we'll move on to our online speakers.
Madam Chair, members of the commission, long day. I've been watching it too, but thank you for having us. I was hoping for more time. I've been involved for about 5 years with this program. It's really exciting. I really love it, and I'm, if you don't know me, I'm a land use planner working with several landowners throughout the county, and with a lot of interest in this program, specifically the rec benefit program. You do have your best and brightest working on this, and I am so glad Jeff and Tina, of course, are working on it. So I'm going to be as brief as I can. I did have a 13-point letter, which I'm not going to be able to get to. So I will try to summarize. I think that the high-impact trails should just be an LUP, not an MCUP. I'm a little confused on how that works when a lot of these rec benefit projects are going to include some level of trails, and if that's an LUP, it should all be an LUP. I want to clarify that the 200-foot setback from ag doesn't include your own ag on your own property, that it would be adjacent neighboring ag. Right now, it's not clarified. I think the appeal process for the eligibility should go to the Planning Commission, not the board. I think you guys have, we'll do a deeper dive, and I just think it would be more appropriate to go to your body. I'm very supportive of the rec benefit projects requiring land use permits. What a wonderful, I just want to support that. I think for the country inn, for larger parcels, I think the upper limit should be 60 or 75. At least that should be studied in the programmatic EIR. For the campgrounds, there's no number identified. I think there should be a number associated with a land use permit, a number associated with a CUP. I'm going to throw out 100 or 200 just to consider. I think the Trailside Cafe should be larger than the 1,200 square feet, more like 2,500 square feet. Okay, so my two big kind of questions. The eligibility letter. It states that it's non-binding. I'm a little confused as to what this letter really means and gets you. So you get your letter, and then you get to use the new planning uses, but does it get you more than that? If you have a larger project that requires a CUP, does your letter get you out of any of the findings for a CUP? Do you still need the compatibility findings? Do you still need, like, is it more than just you qualify and that's it? Or is it that you're a special project? Like, you should get special provisions, special privileges, even if it's a CUP that you kind of, because for the virtue of, the virtue of this program is that you're getting additional allowed uses that otherwise aren't available. So that compatibility component is going to be tough because there's not going to be your neighbor that's doing that same thing. It's not even allowed on that property.
Can you finish, please?
Yeah, sorry. And then the Williamson Act and the uniform rules, we got to address that somehow. I didn't see it in any of the materials, but none of this would qualify under the Williamson Act and contracted lands. Thank you.
Thank you very much.
Our next speaker will be Tom Parker, to be followed by Kathy Rosenthal, and then finally Nancy Emerson.
Thank you, Commissioners. For those of you that don't know me, I'm Tom Parker. I'm the District 2 representative to the Parks Commission. I'm just finishing my first year there, and boy, has it been an education. By way of background, I'm a former National Park Service employee, park ranger in one of the big national parks. I was a county park ranger prior to that, and I've had a lot of exposure to parks and park environments. I've also, I'm coming up on, 20 years now here in Santa Barbara County. So I've had the opportunity to learn a lot about the county, and I'm very, very happy with having been given the opportunity to move here 20 years ago. What I really want to do, and I'm going to try and keep this very, very short, I'd like to submit what I was going to say, thinking that I might have had more time in a letter form to the commission rather than tie up the time today. But what I wanted to say, and I want to echo somewhat what Mr. Califf and Mr. Guerra had to say on the Park Commission, and let me emphasize, I'm speaking as an individual commissioner, not as part of the, or not as on behalf of the Parks Commission itself. My concern has been, and I'll back up a little bit, in a major federal agency, I was the chief of strategic planning and resource management for a number of years, so I do understand the planning process. What bothers me, what I've seen so far in this master plan, and this is what we've received on the commission, and when I got that and started to look at it, I felt like a fire hose had been unleashed on me with the just all of the pressure that I felt really in trying to understand this plan and what it meant and where it was going. The first thing that hit me, and I brought this up in the commission meetings, is in my experience with planning, there's a whole formula, there's a process you go through, figure out where you're at, where you want to go, how you're going to get there, how you know when you have arrived, but most importantly, what's the cost of that? And I've asked several questions about where this is cost-wise, even on just an estimated basis. And as best I can tell, there is none. I don't know how anybody that is in a decision-making authority can really give serious consideration to the components of this plan without knowing what it's going to cost the county or whoever the plan is being created for. Like I said, it was like getting hit with a fire hose. There's a lot of very, very good material in there, some very good ideas, but my first impression, finally having gotten through it over several months, is it's a gigantic wish list. And wish lists are great, but they're not plans. And we need to have a plan if it's going to address as many topics, as many parks, as many recreational areas that we have here in the county. I'm in total alignment personally with CRATAC, with what they're trying to do with the trails. I've spent 45 years in Boy Scouts and have hiked hundreds, if not over 1,000 miles of trails all around the country. And you can see the differences between the ones that are planned, the ones that are cared for, the ones that are used. And I really admire what Craytech is doing, and personally am lining up with where they're coming from on this, and share the concerns that they have. But there's a lot of work that needs to be done. I personally think it was premature to have this today because there's still so many loose ends in this thing, and there's so much to understand. So I would encourage you, as you move forward with your deliberations, look at the details. There's an old saying, the devil's in the details, and by golly, it sure is in just about any plan of this type. And I've been encouraging in our commission that we've had virtually no public input other than from Craytech, and it's been serious input. But I think there's a lot more of it out there in the community, and I'm one that strongly believes that the people that we serve, the people in the communities, the people that this plan is going to affect are the most important ones that we can listen to. So with that, thank you for just a moment here, and I would like to submit some extended remarks in the form of a letter or whatever the appropriate mechanism is.
I hope you will. Thank you.
Thank you.
Our next speaker will be Kathy Rosenthal, to be followed by Nancy Emerson.
Good afternoon. Can you hear me? Can you hear me?
Yes.
Go ahead.
Okay. I wanted to explain, I am representing two organizations and two letters in my comments this afternoon, so I'm going to ask for 6 minutes if I can, please.
I'm sorry, we're going to keep you at 3.
All right, then. I represent We Watch. I'm the vice president on the board, and we are aware P&D staff have not had time to fully develop the standards for the RMP, including the recreation benefit project, so some of our thoughts are tentative, and we would appreciate follow-up commenting. The RBP does not recognize the agricultural enterprise ordinance, and people have been asking all day why that is important. When the agricultural enterprise ordinance, the housing element, and the recreation master plan were going through review, we were told those would all be coordinated. And there are good parts of the AEO that need to be considered in this recreation master plan. For example, the sweeping uses on Ag 1 and 2 lands may be inappropriate. Some of the Ag lands are only 5 to 20 acres in size, and therefore things like a country inn or these larger incentives that are proposed for the RBP may not be appropriate. We ask that you look at those and maybe look at the AEO for guidance so that we can determine what is proper on those smaller ag parcels while still protecting agriculture. We suggest that the larger items not be allowed on parcels any smaller than 40 acres. And we've also had input from smaller farmers that are on Ag 5 parcels that maybe agricultural incentives should include things like farm to table dinners, that kind of thing, that are also considered can be considered a recreational activity. Also, negative neighborhood compatibility was not discussed in the materials, and that was extensively talked about in the AEO. And we hope that you'll review that and take a cue from them, and the requirements for setbacks and other mitigating items for light, noise, and traffic. We wanted to make the point that it appears the Rec Master Plan is playing to tourism more than the community needs. We had a lot of input to the Rec Master Plan, and we want to make sure that our community is going to be allowed to use their resources in a way that benefits the community rather than the tourists that come and visit us. Secondly, I am the president of the Santa Ynez Valley Riders. We submitted a letter to you. Again, I want to echo Susan Duca's and Mr. Snow's comments. We need to ensure that there are equestrian trails in this plan. We've been working with Jeff and the Craytech organization for over 5 years now and it really appears like none of our comments were incorporated into this plan. We were told that there is not, and there never has been, a policy for multi-use trails, and you heard today that there is discrepancy even in staff's interpretation of that. We do need specific trails for specific users. I'm also questioning how the Trek Foundation track that was developed on the opposite side of Lake Kachuma off of 154, how that was even built if we cannot build trails on virtually any parcels in the county right now. I did not see any notice for the trails being built or any CEQA review, anything like that. Not that it's not needed, don't get me wrong. That's a perfect spot for it, but I'm just questioning how we're going to be consistent moving forward in our application of all these niceties that we would like to see. So thank you very much for the extra time. I appreciate it. And thank you, staff and commissioners, for all the work that you do on this.
You're welcome. Thank you.
And our last speaker will be Nancy Emerson.
Nancy Emerson, representing WeWatch. It's a land use organization, and recreation is part of land use, and we need to remember that. We began work on agricultural tourism issues in 2019-20 with well-attended stakeholder discussion meetings. Our work continued with an early public meeting on the RMP and includes support for expansion of and connectors within our Valley Trail System. I'm concentrating here on the RBP today. 1, we support work to develop a definition for substantial that will enable application reviewers to evaluate projects fairly. The term is used in evaluation with at least 3 different tasks: in-kind RBP, contributions, reasons for not granting eligibility, and modification of approved plans. 2, we recommend that the appeals process start with the Planning Commission, which focuses on land use issues, which we think will be the reason for most appeals. Then, if an appeal reaches the supervisors, they have detailed reasoning from the commission. 3, we question whether an applicant should be able to substitute an off-site location for the public recreation facility. It seems to us it could be a loophole for obtaining a use otherwise not available to that person. 4, required application notices for LUPs are a help to the public if one sees them. The P&D running list of proposed cannabis projects was an example of a tool much more helpful to both staff and the public once the public knew it was available. We recommend such a tool for the RMP. 5, regarding allowed uses, if allowing expensive country inns, we need to offer affordable hostels too. The following uses are not recreational or recreation tourist serving, and we recommend removing them. Neighborhood serving commercial uses, neighborhood serving professional administrative office, education, or research facility. Number 6, please develop a full list of reasons for not granting eligibility on page 16, paragraph 4. The ETC left us dangling. Thank you very much, and we will continue to work with you on this important work with recreation. Thank you.
Thank you.
And Ms. Emerson was our last speaker.
Thanks very much. Now I'd like to ask my colleagues if they have questions or feedback for staff today. Mr. Park, please.
Well, I have an enormous amount of feedback, and I've been involved in a continuous process with the three people at that table for years, actually, having those conversations. But I think it's important that we have those conversations publicly, in less time than we've had privately, and that we have them with these folks in attendance, and we resolve some of their suggestions, that we go through and say, let's focus on this suggestion, let's work it up. Let's work up, for example, a glossary that deals with substantial in-kind contribution. There's a lot to do. We thought this workshop would be very important, and I relate it back to the AEO where we had 8 hearings that if one even dreams about them, it's almost insufferable, the idea that we would go through that many hearings with this. And we can't do that with the Rec Master Plan. We just can't do it. We need to deliver something to the board and get it done. The idea behind a workshop was it's kind of like sucking the venom out of the wound, that we would hear from everybody what their concerns were, we would address them, and so that then we would go into the drafting stage with a sort of a community consensus about what we were doing. And I'm going to repeat the concern I expressed an hour ago, that just given the necessary constraints of today, where we took so long on our first matter, that we've had less than an hour allocated for public comment, when I think folks thought we were going to have all day with give and take. And we gave them just 3 minutes, as we would of any development project. And this is for people from sister agencies like CRATAC and AAC that have importance and are created by county ordinance, just like the Planning Commission is. So, and frankly, I'm just too tired to give the kind of deliberations in the comment that I think are going to help you out and shorten this process, and to do it right now. So I do believe we should have a short continuance of this so that people in the public can make further comment, and so that we can organize our points we want to address in deliberations so that we'll shorten the overall process. That's where I stand.
Thank you. Mr. Reed, do you have any comments or questions?
Yeah, I would also support some sort of a workshop that's more collaborative, particularly with people from CRATAC and the Trails Council, et cetera, because it seems like a great deal of this is concentrated in, of the concerns we've seen are concentrated in the Santa Barbara portion of the county, the Front Ranges, Santa Ynez Valley. So I would, support a robust program of incorporating advice from all contingents, you might say. I did not appreciate the lecture we got in the letter from Ms. Rohrer about the value of ag, particularly since I have the district with this greatest amount of ag in the county, have ag holdings. We appreciate that. And the same time, I will agree with her that we need to protect the integrity of ag in this county, and to ensure with her and with Clara Weinman that whatever we ultimately wind up with accommodates both the recreational need, but preserves the integrity of agriculture in the county. I think we have the prospect of coming up with a fantastic product, and should make certain we collaborate with all affected parties who want to participate in the process to come up with the best product we can. And 1980 was a long time ago, and this certainly warrants as good a product as we can possibly produce.
Thank you. Mr. Cooney, please.
This is just a personal observation at the end of a long day. I do want to indicate that all of the topics we discussed from 9 o'clock this morning to now have a rightful place with our commission, and there was nothing that I think indicated a lack of interest or a lack of willingness to continue our role as we go forward. It would be great if we didn't have as much work because it's all been done, but it appears that there is a lot of work, and we're looking to our leaders, both the Park Commission and the Planning Commission. So it's hard to do this, hard for staff, hard for commissioners, and hard for the public, but the only way we're going to get better at it is to bite our tongues and go ahead.
Thank you. I would just echo in some ways the comments of my colleagues. I think that the presentation is great and it's going to be a wonderful plan, but we heard many interesting comments, suggestions, red flags, and I hope that we can be thinking creatively about a way to continue the conversation, especially because we have heard multiple times that people feel they were not heard. And maybe it's only because I'm new to the commission that I want to make sure that people above all feel that they've been heard and that their comments and their thoughts have taken a place in this document. So maybe it's a town hall, maybe it's a continuance. I would just say that I would like us to continue to talk with many of the key people who spoke here today. They will only make our work better. And Mr. Park?
Well, I have to say it. You may be new to the commission, but you have great instincts.
Why, thank you.
I would like to make a motion to continue this. I know that Mr. Lindgren's under great pressure from his supervisors to get this done, and they're under pressure from the county executive to get it done. But I sincerely believe that with a continuance, so we can go through the best suggestions that we see, comment on it, comment on what we've seen so far, give you feedbacks, and go forward, will shorten the overall process and make all of these folks feel that they've truly been listened to. So I would like to make a motion to continue it to the next available date, and I hope that Mr. Wilson will tell me what that date is.
So, Madam Chair and Commissioner Park, I just wanted to start by, I had a hard stop at midnight, so just kidding. Just wanted to see if Commissioner Cooney's paying attention.
Yeah, right.
So, part of that date that Commissioner Park is asking for is managing expectations of the commission as far as what you would like to see occur at the continuance. Looking at, I think the rest of this year has complications in order to continue it for any hearing this year. We canceled December 10th. I think that might be relatively quick to come back. So we're really realistically looking at next year.
Yeah.
The first available hearing is January 14th. That may be ideal because there's no other items on that day, and we could just reserve that day for a more of a robust workshop, give members of the public time to, that gives a month and a half to look at the documents, come back with some more comments or suggestions if they would like. I'd almost think that we want to reverse the hearing. We talked a lot today, but we didn't hear from the public a lot, so it might be good to have a lot more time for the public to provide some input and then have the commission react or provide guidance based on that public comment. We heard a lot of great things, but it was a light touch from the public, so I think I'd like to hear more from the public as far as those things. So I would say January 14th. If the commission's expecting staff to come back with additional information, then that may be too soon just because of our deadlines for docketing and getting material out for the commission. The next date after that is January 28th. I would strongly oppose that date because that would be a repeat of today, and no one wants to do that. So January 14th, and then after that is February 4th, but I think Commissioner Reed is not available that date. So January 14th may be a good date for a touch point and to get more public comment. And it gives the commission time to review the material in more detail and come back. I'm talking way too much, but we would like for the commission and the public to come back with, I think as Ms. Macon had indicated, some parameters. I think even Ms. Emerson had talked about it, other public speakers, as far as like country inns and what parcel size would be appropriate or not appropriate. So those are some of those specific details that we're looking for on a workshop to be able to come back with. So to answer Commissioner Park, we're looking at January 14th as long as it's a light touch as far as staff goes is what your expectations are.
Well, so I would like to include January 14th in my motion, and I don't really think staff should do much of anything in between now and then.
Other than listen.
Yeah, listen and continue to collate those comments from the public, however they come in. Make sure we get them and look through them and kind of pick through, okay, what's a major point, what's a detail we don't need to deal with, so that we can focus down on the 14th. Okay, here's 5 things, here's 10 things we need to work up, and also I think that will give people like AAC, CRATAC, Parks Commission, whoever, time to have meetings and deal with this some more if they feel they need it. Because I want to be able to say to them, you've had the opportunity to be heard, so let's move on. Right now, I'm not there.
So we have a motion. Do we have a second?
Yes, I'd second it. I think the 14th would be a great day, and having it dedicated to this single topic would be an excellent opportunity for people to really feel heard.
I appreciate your openness to continuing this so that we're as knowledgeable as possible, especially with the experts on many different fronts. So I'll call for a roll call vote, please.
Commissioner Cooney.
Aye.
Commissioner Park.
Aye.
Commissioner Reed.
Aye.
Chair Ford.
Aye.
Motion passes 4-0.
Thank you very much. I would just say that now there are no further items on today's agenda, and thank you so much to the staff, the community, and to the commissioners for hanging in all day. Our next meeting now will be January 14th, 2026. I wish you Happy New Year and happy holidays.
I just want to speak up. I think this is the last meeting you will chair.
It is my last meeting as chair.
You know, I think you've done a great job as chair.
Thank you, John.
I think you've done as good a job as chair as anybody I've seen in this. And
Why, thank
just
you.
walk in and do it. It's
Thank you.
it's great, and I really appreciate it. And I think you had to use all your skills today to just get us through the day. So thank you very much.
Thank you.
That's right. We get the ogre, right?
Now go home.
Yeah. All right. We look forward to having Mr. Reed.
This meeting is concluded.
Bye-bye.